麦克风测试，麦克风测试，一二三，一二三。
两公约第3次国家报告。
This is the second cluster of the International Review for ICCPR reports. The meeting will start in 2 minutes. Please turn your cell phone on vibration or silence.
各位贵宾早安。两公约第3。
Ladies and gentlemen, good morning. This is the second cluster review of the ICCPR reports. The review scope is Article 1 to 5, 26, and 27 of ICCPR. Please keep a proper pace for interpretation when you speak. Thank you very much. Chair, you have the floor.
Thank you. Thank you very much. Good morning to everybody. I'm very happy that we have time now together with the government first and afterwards with NGOs to go in a very detailed discussion on a few articles. And we would like to also keep it very targeted. So we will ask one question and then immediately request you to provide an answer. And then we might ask additional questions so that there are issues where we are not yet totally clear or where there's contradicting information that we understand better what your government has done in order to implement these obligations under the Covenant on Civil and Political Rights. So the first cluster deals with Articles 1 to 5, 26 and 27. We have put that together because 1 and 27 are closely related, in particular in relation to indigenous peoples that are recognized as peoples in accordance with Article 1, but at the same time they are also seen as minorities as protected under Article 27. Similarly, Articles 2, 3, and 26 all deal with the right to equality, equality before the law, equal protection of the law, but also non-discrimination on all various grounds. So that's the second bigger kind of topic that we will discuss this morning in this a little bit less than 3 hours that we have. And then there are a few other articles like 4 and 5 where we might also put some questions. So without further ado, I would like to pass the floor to ROC, who is herself coming from an indigenous community in Indonesia and is our expert on indigenous peoples, so that we have a first cluster on indigenous issues that do play an important role in your country. ROC, you have the floor.
Thank you very much. Selamat pagi, good morning. I'm sorry, I don't know how do I say good morning in language of this country, yeah, but I'll just say good morning. And we start with the smile, beautiful day, and I hope that brings the spirit of optimism, yeah, that we are trying really how to advance the situations of all peoples of this country. So with regards to indigenous peoples' issues, rights to self-determinations, collective rights, and in the practical level, on the implementation level, it has a lot to do, so much to do with the free, prior, informed consent, with regards to any development projects within indigenous territory or might impact indigenous peoples. I have some follow-up questions. We already have, and I would like to congratulate because we already have comments and response from the government written on this paper here. And also we have conducted interview and consultations with civil society, including indigenous peoples organizations. In the last 2 days, they were here also in the room, and they have raised some concerns regarding the need to improve the way the government of Taiwan protecting and fulfill the rights as indigenous peoples, especially when it comes to free, prior, informed consent. My question is, in obtaining free, prior, informed consent, to what pace is free, prior, informed consent start? Is it from the beginning, or is it when we already have the permit to the companies, or to what stage? And how is the implementation in case you obtain FPIC from indigenous peoples? What are the next step? Is there any, what normally we say within the FPIC, there is indigenous people's plan. So what will happen when they say yes to any project? So that's, I think, that's my first question, Chairman. And let's start to discuss. I will ask more if needed later. So I think I want to pin down on this process because this has been one of the issues that is coming back again and again, especially from indigenous people. They kind of like, it's always just big things missing. That's what the aspirations of indigenous people. So I think we need to discuss on this. Thank you.
Thank you very much. The floor is to you. please.
好的，那是不是请那个原住民委员？
Okay, maybe we have our representative from CIP. Yes, this is CIP. What's your title? What's your scope of responsibility?
会。
I'm from CIP. I am a specialist. I am Zhen Xingzhong from CIP. My work involves consultation process and the recognition of indigenous identity and status. On the consultation process, well, the time of the beginning of this process, well, in the Indigenous Basic Act, for any government agency or for any private sector entity, when they have any development, well, in fact, before the development project, they have to engage in consultation with the indigenous people and obtain consent. According to the Indigenous Fundamental Act, the consultation is applied to various forms of development of land, use of resources, ecological protection, academic research, and if the government want to use any means to limit the use of the land by the indigenous people, falls under the scope of getting consultation first. Since there are many forms that can apply the consultation, generally speaking, before these actions are taken substantively, consultation have to start, meaning that when these actions impact the rights of the indigenous people or may infringe upon the rights of the indigenous people, consultation must be initiated. And this process now is recognized by judicial and administrative agencies. If government agency or private company want to use indigenous land without obtaining indigenous consent, then in the follow-up stages, all the administrative decisions made by the government will be treated as illegal treatment by the government. For example, without the consent, the mining rights was given to certain company, and the court decided that the decision made by the government agency to go ahead with the mining project is illegal. Second, once the indigenous people give their consent, then in the consultation process, the indigenous people, along with the government or the company, may start to discuss how to conduct the development and how indigenous people can engage in the development. In the current regulation, it states that the administrative agencies can use this kind of consent as the additional clause in the development project. For example, if the company promised to give certain compensation to the indigenous community, then the government agency which regulates this project must ask the company to fulfill its promise to give the compensation to the indigenous people. If this promise is not fulfilled, and all the agreement and all the permits may be revoked. Then currently we encourage government at local level or at any levels or the township offices that after indigenous people give their consent, they are encouraged to sign a contract or an administrative agreement with the company so that the company will fulfill their obligations. These are my responses to your questions. Thank you very much.
I was asking earlier, is this the planning or development? Because, especially in indigenous world, development sometimes means constructions. So, it's not the planning phase. I think that needs to be clarified. And also, what is the gap do you feel or do you think might still open within the existing regulations relevant to implementation on FPIC that probably needs to be improved? Because, as evolving, as development of the policies going on, there's always a window of opportunity to improve any laws and regulations. And I think we also want to. I also want to hear from the government side, because this is also one of the critical points that is always brought by indigenous peoples, that there is a lack of the respect, for example, decision-making process of indigenous peoples. So I wanted to know what is the plan, what is the agenda of the government when you implement FPIC to really respect and use the decision-making mechanisms within the indigenous community, and not just like, our modern way is doing voting and all this kind of stuff. So I think that's the follow-up question from me, Chairman. Thank you very much.
Thank you, please.
So I again speak on behalf of the Council of Indigenous People. In response to your question, we have seen that when we perform the FPIC process, there are many cases. In most cases, we have been able to complete the consultation, whether the indigenous people agreed or disagreed with the proposal. And of course, there are many NGOs who pay close attention to specific cases. So many of these cases are under scrutiny, but even though the process has gone very smoothly, but there's still room for improvement. For example, under our existing law concerning the consultation process, basically, there's only one provision under the basic law for the indigenous people that is about consultation. And that provision actually delegates the executive branch to plan the consultation process. So the provision itself is very prescriptive. Therefore, the executive branch is given a limited scope of power. If we can revise the consultation process provision, for example, we can escalate or upgrade it to a special act. Through a special regulation, we will be able to provide more detailed restrictions or procedural requirements in the consultation. In that case, the indigenous people will not be misinformed or suppressed, pressured into giving consent. In that case, the free and prior informed consent will be more adequately realized. So we are trying to formulate a special act to formalize the consultation process. And actually, some members of the council have made proposals. They are right now under readings by the parliament. Secondly, as an executive agency, we hope that the indigenous township offices can play a more important role, because in the consultation process, local government should be there to provide assistance to the indigenous people. For example, the indigenous the indigenous township office should identify a place where meetings, consultation can take place. Information should also be made available to the indigenous people. If necessary, the township office also needs to source scholars to help explain the relevant information to the indigenous peoples. Therefore, the Council right now is working closely with these township offices so that staff at the township offices know better how the FPIC process should proceed, so as to enable the indigenous people to know better the pros and cons of different development projects. That concludes my response. Thank you.
I think I asked earlier, what is the indigenous do you have within the project development in case they give FPIC, because FPIC doesn't mean you give up your land, you give up your right, or you allow everyone to evict you from that land, that you will completely be out of that, you can be part of the development. So I wanted to know if there is any lessons learned or cases where there is really involvement of indigenous peoples, or what we call indigenous peoples plan, remain part of this development, or they can choose to leave, or they can choose to back, or if it's there, because in many cases that is part of the FPIC itself, indigenous peoples plan. Thank you.
Please.
Again, I speak on behalf of the CIP. Among the cases we have handled, based on our regulatory consultation process, only the public land will be applicable. In other words, such public land is recognized as part of the indigenous land. But in regulatory terms, such land is public land. So for private enterprises, they only gain access to use the land temporarily. It doesn't mean the private enterprise does have ownership of the land. The land still belongs to the indigenous people. And through the FPIC process, the indigenous people and local people have a better understanding how land can be properly developed. So we are also looking into a Homeland Development Act, so that the indigenous people can know what rights they have in developing the land that is public land. So the indigenous people know what they can do on the land that is theirs, but it's also, legally speaking, public land. So the indigenous people are not passive, waiting for their land to be planned and developed by other people. The indigenous people will have a better idea to know how their land can be developed.
Just also add to the question. We are always speaking, I think, about development projects by the government and consent by indigenous peoples. are there also projects that originate from the indigenous peoples? Or is the initiative always coming from the government? Because, I mean, one of the main criticisms that we heard from indigenous peoples' organization is there's ongoing land grabbing. So there is more and more land, in fact, taken away because of industrial, mining, whatever type of development projects. How would you respond to this question?
Again, I'll ask our colleague to reply. I speak on behalf of the Council of Indigenous People. The indigenous people's land mostly belongs to the public or the government, the nation. And of course, there's also land that solely belongs to the indigenous people. How does the state gain access or ownership of indigenous people's land? Well, during the Japanese colonial period, many of indigenous people's land have been grabbed by the ruler then. So now we hope that the indigenous people's land can be returned to the indigenous people if they had been grabbed by the state. Therefore, we actually have streamlined and simplified the process by which the indigenous people can claim their land back. Now, as long as the indigenous people can prove that they inherited the land from their ancestors, the government will, as soon as possible, reallocate the land to the indigenous people. So this is an area we have been working. This is in response to the land grabbing by the state, and we are trying to return the land to the indigenous people as soon as possible. As for the scope of the consultation process, it includes government's project, development project. It also applies to private developers' project. I know people pay a lot of attention to the mining usage, but in addition to the Asian cement company's case, there are many other developers that try to proceed with development projects in indigenous people's land, and they have gone through the FPIC process smoothly. There's also a contribution giving back to the local community, creating job opportunities, and there's also transparency in information sharing so that the indigenous people can take part in this mining development project. A few days ago in Pingdong, in Taiwan people's land, there is a lot that has been used by the Ministry of Science and Technology to launch rockets. The indigenous people has agreed to permit such a usage of their land. But a few days ago, the Ministry of National Defense also asked to use the land, but the use is not in line with the prior agreement between the indigenous people and the Ministry of Science and Technology. Therefore, the Ministry of National Defense apologized later after they realized that they have made a mistake by making such a request. Therefore, once the consultation process is completed, if we, the government, have made any promises to the indigenous people, we will honor them for sure.
Thank you. Okay.
Okay, I feel like we need to have more discussions on this because I think there are, from what I observe from the discussions with the indigenous peoples, the NGOs, and the government, I think there is still gap of perceptions, understanding of what is really FPIC means, self-determinations means, the role of indigenous peoples means, and I want to go back to my first questions about the Pingpu. Yeah, how is the situations of the Pingpu now? Because I've still observed over the years, there's still problem about the recognitions of the Pingpu. Also the criticisms, the other day we heard that the ongoing process of drafting the Pingpu recognitions today is actually being opposed by the Pingpu themselves, and it's not moving forward. Oh shoot! It's not moving forward with the process at the national level in terms of the legislation. So, what is the status of the legislations now? Thank you.
Again, CIP, would you respond to the progress of legislation?
原民会代表做发言啊。
Yes, this is CIP. I am Zhen Xingzhong, specialist at its CIP, and this is my first time comment on the issue of Pingpu. The current administration is the first administration that recognizes the issue revolving the status of the Pingpu peoples and propose a draft to recognize Pingpu people. We ask the Legislative Yuan to let Pingpu people to be recognized as Pingpu. And this legislation process has been delayed in the Legislative Yuan because in the Legislative Yuan, they still need to achieve a consensus, which has been challenging. One of the reasons is that the population of Pingpu people, based on our current stats, is 981,000. And the indigenous people overall account for 570,000. So there's a big difference. So many indigenous people and non-indigenous people are concerned. If all the Pingpu people are recognized as Pingpu people, how would the government ensure the rights for the Pingpu people? So at the beginning, we thought about this. We wanted to focus on the needs of the Pingpu people and to create a mechanism that can bring benefit to the Pingpu. So in the draft amendment to the Status Act for Indigenous Peoples, we hope the Legislative Yuan can agree to have another dedicated piece of legislation to recognize the rights of the Pingpu people. This is the supplementary measure we propose, but the ruling party and the opposition party have not yet reached agreement. So we're still in the process of trying to persuading all the stakeholders to find a way to recognize the status of the Pingpu people. The second reason why this legislation has not been advanced as much is because at the Judicial Yuan, the Grand Justice, as of now, are discussing and reviewing how Pingpu people can obtain their status. That is to say, the current legislation regarding Pingpu people may become a constitutional case and on a constitutional review to see whether the current situation is unconstitutional. So the Grand Justice may make a deciding judgment on this matter, and that's why we hold the legislation process and see what the decision will be made by the Grand Justice in the Judicial Yuan. And based on that decision, we will continue with our legislative efforts. And the Judicial Yuan in this June started oral arguments on this matter. According to the 3 months after the oral argument, a decision has to be made by the Grand Justice. So by the end of this year, we will see the results as to how our Constitution recognizes the status of the Pingpu. We will be able to see such a decision by the Judicial Yuan by the end of this year. And based on that decision, we will propose the legislation progress. And anything that the Judicial Yuan would like to add to this explanation? Okay, Constitutional Court. On this matter, well, as said earlier, Constitutional Courts will have their oral arguments as scheduled. And according to the Constitutional Proceedings Act, yes, 3 months after the argument, a decision has to be made, or if more time is needed, then 2 extra months will be taken. But all in all, by the end of this year, the Constitutional Court will make the decision, and they will find whether or not the current situation is unconstitutional. And the executive branch then will, based on that decision, to make follow-up actions.
Will they be recognized as indigenous peoples or any other category aside of indigenous peoples and other Taiwanese? The recognitions of the Pingpu as indigenous peoples, or as what? As minority, or as tribes, or? How? Thank you.
Point 29 of our recommendations in 2017 clearly said that the current classification of indigenous peoples into 3 categories of mountain peoples, plain peoples, and Pingpu peoples is partly a legacy of the Japanese colonial period and does not correspond with the present situation of the 16 recognized indigenous peoples. And that's why we recommended that the government of Taiwan apply the classification of indigenous peoples as identified by themselves and guarantee them full and equal participation and representation. Is that the process that is ongoing? That you have gone away from this kind of 3 types into the self-identification process, including the Pingpu peoples?
I
think this is an ongoing case. Well, maybe CIP, can you talk about the purpose of this case at the Judicial Yuan, at the Constitutional Courts? Is it to recognize Pingpu people, or is it to include Pingpu into the current different indigenous classification system? Well, this is CIP. In the current legal system, indigenous peoples are put into 2 categories: mountain peoples and plain peoples. These categories were made because of elections. Because mountain peoples can have 3 legislators, and plain people also have 3 guaranteed seats in the parliament, and among all the local council members or representatives, still there are these 2 categories for the purpose of election, but indigenous people can register themselves as either mountain people or plain people as they wish. In this current system, some Pingpu people want to be recognized as plain peoples so that they can enjoy the benefits given to plain peoples. So they seek remedies in the court. And that's why this is a court case. So the purpose of this case now is on the Status Act for Indigenous Peoples. So the purpose is to distinguish whether the Indigenous Peoples Act on the rights of the Pingpu people is unconstitutional. Because the current issue is that some Pingpu people want to be registered as plain peoples. I think back in 1950s, if some indigenous people didn't register themselves as plain peoples, then the current law cannot recognize these people as indigenous people. And whether or not this practice is unconstitutional will be decided by the Constitutional Court. So if the Constitutional Court finds that these elements is unconstitutional, and as long as people have Austronesian linkage, and if they want to be registered as plain peoples, they should be so. If that's the decision made by the Constitutional Court, then the Pingpu people will be categorized as plain peoples, and Pingpu people will be able to enjoy all the election rights as plain peoples. But for all the other rights, mountain peoples and plain peoples have the equal footing. So we also consider the Canadian system. Many different indigenous peoples are categorized as Métis and Inuits and Indian. So there are 3 categories. And among the 16 peoples in Taiwan, they are categorized as mountain peoples or plain peoples. And of course, the Pingpu people, which could be a 3rd category, that had a very different historical background, but we want them to enjoy the same benefits. There is still necessary to distinguish them from mountain peoples and plain peoples, given the legacy system, but we try to create national policies or mechanisms that still meet the needs of the Pingpu people. I think that was the spirit of the draft amendment to the Status Act for indigenous peoples.
Very much. Are there any further questions on indigenous peoples by Ruka or anybody else? Yeah. Then I have still one question in relation to Article 1. There is this amendment to the Referendum Act, and in the report of the National Human Rights Commission, there are certain concerns expressed about the rampant spread of disinformation, which is detrimental to the positive development of the referendum process, conflicting referenda, etc. So could I have a short explanation? As far as I know, everybody can start an initiative for a referendum. And if you receive a certain number of votes, then the referendum must be held. But what is it that the government can do in order to ensure that the referendum, also the result, does not conflict with human rights obligations? please.
好的，公投法应该是
Yeah, on referendum act, I think this question goes to MOI or Central Election Committee. Hi, I'm the Director of Election Regulations at Central Election Committee. You ask about referendum act. A referendum act gives the people the direct right to exercise their power, and it's different from representative politics. So without direct exercise of people's power, it is possible that at the end of the election, people are not happy about the results and therefore started their protest. However, if we rely only on direct exercise, then the representative system may collapse because people may go ahead and ask for whatever they want. So it is very important to strike a balance. Back in 2018 and 19, we had a large amendment to a big amendment to Referendum Act. The threshold for approving the referendum has been lifted. Referendum is about the exercise of public goods or benefits, so it's different from election. It has a low level of regulation. It's not as regulatory. So many regulations are not as strict as the regulations in the Election Act. As for reviewing the initiative, if one wants to deny an initiative, if this is an initiative that is related to human rights, then it may be denied. And this denial has to go through a hearing process first. Scholars and experts provide their opinions and insights so that the initiative may be revised or be rectified afterward. That is to say, the review of the initiative right now has very low-level intervention. Relevant agencies and scholars and experts have the responsibility to propose their ideas to decide whether or not this initiative should go ahead.
那当然现在
Of course, right now, according to the Referendum Act, anyone aged over 18 is able to make a referendum proposal. Thank you.
But could you be very precise? How many votes do you need so that an initiative that everyone can make needs to be put to a public vote, to a referendum?
In the initial stage, if you want to make a referendum proposal, 1 of 10,000 of the eligible voters, then you can make a proposal. But for a referendum to take place, you need to have 1.5 of 1,000th. And for a referendum to be passed, 1/4 of those who vote must agree or approve.
So if somebody proposes, I say something now, that a certain religion should be absolutely prohibited. So if you get this certain percentage of the voters who support this referendum, then it must be put to support this initiative, then it must be put to a referendum. And if the majority, or at least 25% of the voters approve, then this is a law that is binding on the government. So do you have any kind of safeguards so that these kind of clearly unconstitutional, human rights violating initiatives cannot be put to a referendum? Because otherwise you have popular lawmaking. And in times of populism, I think this, we know that from many countries in the world, it might be very dangerous to a representative democracy. So I'm a little bit concerned, and I think the National Human Rights Commission is also concerned about that might be misused.
是麻烦中选会的。
是
In our country, it's kind of complicated when it comes to the types of referenda. There can be people-initiated referenda, there can be government-initiated referenda, or the president can initiate defensive type of referenda, and the parliament can also initiate referenda on major policies. For people-initiated referenda, if they involve major lawmaking or policy making, there are two types. Basically, we do not expect people to make a specific or propose a specific regulation. Rather, the people-initiated referenda will be about a rough description about a law or regulation they would like to see formulated by the government. If the referendum is passed, then the executive branch will provide a draft based on the result of the referenda, and then within 3 months after the referenda, and then the parliament will review the draft. So it does not mean that once passed by the referenda, that proposal will become law. It's different. And for the parliament-initiated referenda, once the referenda are approved in the voting, the Constitutional Court also has to review and pass it, make it into part of our law. So we don't expect to see hasty lawmaking because of a referenda result.
So I take it that the decision on the referendum is not a decision on a draft law already. It's only on a general issue, and that then needs to be formulated in the law with all the. So finally, it has to be adopted by the legislative yuan. That correct? All right. Thank you very much. Anything else on Article 1? Then I would like to come to the second big cluster, and that is the right to equality and non-discrimination. And since Shanti Dairiam has been long-term serving in the Committee on the Elimination of Discrimination Against Women, and is an expert on anti-discrimination and equality questions. So I ask you to raise your questions, please.
Thank you, Chair. And good morning, everybody. I'm very pleased to be here with you, and I'm pleased to see so many of you here from government before us as well. Thank you for your presence. I'm going to pick up the issue of anti-discrimination law and gender equality law. Right at the start in 2013, when this committee first came for these reviews, we recommended that there should be a gender equality law legislation that will mandate gender mainstreaming and budgeting and ensuring de facto and de jure equality, as well as a time frame for the adoption of this equality legislation. We also recommended a comprehensive anti-discrimination law covering all prohibited grounds of discrimination. Now, the report and responses to the 2017 concluding observations, when we came in 2017, this equality legislation had not yet been adopted. But in the 2017 responses, it was indicated that the Judicial Yuan had drafted an equality legislation with a definition of direct and indirect discrimination with certain procedural aspects of the law for ensuring access to justice. But still, no law has been adopted. There was a draft. We were told there is a draft. Now, this is 2017, and we've been talking about equality legislation since 2013. But now, in the latest list of responses, there seems to be a change in the procedures. What we read is that the need for this equality legislation will be included in the Human Rights Action Plan. This is what I read, yeah? And I read further, which is a bit of concern, that first of all, you have to have a human rights plan that is approved. And the Executive Yuan has to approve the human rights plan, in which will be integrated equality legislation also. This, then once the human rights action, this is my understanding, correct me if I'm wrong, once the human rights action plan is approved, then the Legislative Yuan will draft the equality legislation for review between 2020 to 2024. It will go into that frame of time. So from 2013, what I read is there is no, the equality legislation has not been adopted, whether it's gender equality or an anti-discrimination law has not been. Earlier, there was a draft, we were told. So now, we also, my question to you then is twofold, two related questions. One, is there a draft for this equality legislation, anti-discrimination law, or gender equality law? Do you have a draft or not? Because it's confusing. From your responses, for me, it's confusing. Is there a draft, number one? Number two, is it going to go through this long drawn-out process of it going into the Human Rights Action Plan, and then only there will be a draft, and then it will have to be approved. Is there any possibility of speeding up this process and bringing the equality legislation into the legislature? And can you indicate a time frame in whatever process you're going to take when such equality legislation will be adopted? So if you can answer those two questions first, then I will take up further questions.
好，谢谢就。
Thank you for the question. I am Huang Yuyuan from the Department of Legal System of the MOJ. On equality, in fact, we have relevant laws and regulations under the purview of different agencies. For example, children, women, people with disabilities, migrant workers, refugees, even inmates or former inmates, all fall under the protection of such laws. When I attended the first international review meeting, we look forward to consolidate and compile this different regulations into one. And we wanted to speed up the passage of such a law. But the different ministries seem to have different ideas, concerns, priorities about such a comprehensive equality law. And now we have the National Human Rights Action Plan. 64 UN member states have formulated such an action plan. Last week, the Executive Yuan has passed the National Human Rights Action Plan. So the data you have in hand may be out of date. But last week, Premier Su already approved the National Human Rights Action Plan. The action plan covers 8 issues, emphasizing the human rights protection mechanisms, non-discrimination, equality principles. In this regard, we are looking into the draft equality law. The Executive Yuan is going to set up a Human Rights Promotion Office, which will be tasked to promote the implementation of all human rights conventions. Therefore, we hope by 2024, we will be able to adopt the comprehensive equality law.
运作，那
And we will continue to work on that. Thank you very much.
Okay. Would you agree that this process is very long drawn out? We've been talking about it since 2013. And you have even then told us that various ministries have their own regulations for equality. And we pointed out that there has to be one overarching comprehensive legislation. Otherwise, there could be inconsistencies. Different ministries may develop standards and indicators of achievement which are not consistent throughout the country. And that is not a good way to go. Therefore, from 2013, we have been proposing this. Now, to my question of a time frame, do I hear you right when you say that by 2024, you will have the equality legislation, which is really quite 10, 11 years of work before it's coming to fruition, yeah? And then just a follow-up question on that. Who's being consulted in the contents of that law? Have there been any attempts to ensure that universal human rights standards for equality and non-discrimination will form the basis of the contents of this law? And how are you going to ensure that such universal standards will be applied into this law? And who are the people that you will consult to ensure that this draft complies with these standards? Can you answer that question, please? Yeah.
谢谢。好，那
Thank you for your question. Yes, as you said, equality issues are scattered around different ministries and agencies. Yes, starting from 2013, we have been wanting to have one piece of equality legislation, but it's very special. So we want to do what we can first. So at the beginning of this year, we passed a human rights in fishery and industry action plan. We want to protect the rights, the human rights of fishermen first, for labor and for employees and business. We also launch a human rights action plan to protect human rights in the corporate world. So the government intention is to do what we can first. Of course, we know there's a long-term goal, but we don't want to wait for that long-term goal to be realized. So in this process, we started with what we can complete. But when it comes to protection for individual rights, we already improve protection for women, for children. We will not wait until the Equality Act is finalized, then we start the protection for women and children. No, we try to protect what we can first, and then we have the long-term goal of finalizing the equality legislation in Taiwan. And of course, we take into account the opinions from different stakeholders and an international trend as well. We are very positive and hoping that by 2024, we will have this equality law in Taiwan. Thank you.
And thank you for your response. However, the basic simple question I asked was, who is being consulted in the community, among the people in the country? Academics, scholars, civil society members, gender experts. Who are you consulting to ensure that these universal standards will be applied? I understand what you say about the protection of women and children will go on even if there is no overarching law. That's what you're saying, that each ministry has its responsibility towards women, children, or minorities, or whoever. But who is going to participate in ensuring that the contents of this law will adhere to universal standards? That was my question. Who are you consulting on this?
As of now, I don't have all the details of the legislation process, but for all the ministries and agencies, when they come up or when they want to launch new laws and regulations, they always organize hearings. For example, the National Human Rights Action Plan, which was passed last week, as I said, there are 8 major priorities. And those 8 major priorities were decided after hearings with civil society or human rights groups or religious groups. So we collect public opinions through hearings. Government wouldn't be the only contributor to the content of the law.
That is reassuring that you will hold hearings. But at the same time, you also, when you hold your hearings, and this is my experience in other parts of the world, and you get various groups who may have very different views coming together, you still have to have a balance of universal standards, you will adhere to that, and you will adhere to constitutional principles and universal standards, because people may come in with something that is even unconstitutional and want to put it into the law. So you have to have that expertise and capability to ensure that universal standards will be adhered to. But I'm glad to hear that you will hold public hearings, and you have to ensure that you have a wide representation of individuals and people. Now,
may I just,
okay.
before you go on, I'm very happy to hear that last week the National Action Plan has been finally approved. Would it be possible that we still get a translation of the National Action Plan during this week? Because it would be great for us if we get it as quickly as possible to look through and see whether there are certain questions that we have on that.
Letter. The English edition.
Thank
you very much. Sorry,
okay.
Shanti.
No, that was good. It's good to get the action plan. I'd like to continue with a couple of other legislative points. Now we move to the issue of, which comes under the same cluster. The committee also asked in the previous review about legislation that will address emerging forms of violence in the country, especially such violence may be directed at women, and one of which is digital gender-based violence, internet use and the use of the digital. And we suggested or recommended that you have legislation. It's happening everywhere now. These are emerging forms. As the IT technology develops in all our countries, there is scope for abuse, and especially abuse of vulnerable groups, especially women. And there is cyber stalking, there is internet stalking, and all kinds of digital violence that is taking place. And we asked whether there will be, we proposed the need for legislation to address these forms. Otherwise, there is no legislation. And so such violence is not identified as a crime in the penal code. So there is no remedy, you know. And we don't still see that you have moved in that direction to legislate. At least this is what I understand. What I understand is happening is that each ministry will set goals and indicators for themselves, and it will be integrated into their gender equality promotional plan. That's what I read, that each ministry has a gender equality promotional plan, and in issues pertaining to digital violence against women or children or other vulnerable groups will be put into that promotional plan. And that this promotional plan is supposed to be operational, again, correct me if I'm wrong, from March 2022 to 2025. Is this being monitored? So this is made. You have 2 months already since this promotional plan should have been implemented. Do you know whether ministries are actually implementing their promotional plan, gender equality promotional plan, in which digital violence is, they have got their own goals and targets? That's my question to you.
好，谢谢。那我想这个问题。
Thank you. I think this question can be responded by the MOJ and MOHW and the Department of Gender Equality. So as a member of MOJ, I would like to respond first. Yes, some vulnerable groups are very vulnerable when it comes to digital and gender violence. For example, some intimate images are released. So we have just revised a Protection Act for victims of sexual harassment. And we also want to amend the Youth and Children Protection and Welfare Act so that to minimize the damage caused by digital violence and to punish the perpetrators. As said earlier, the National Human Rights Action Plan was passed last week, and one of the major important human rights was digital human rights. So digital human rights is included in the action plan in order to protect vulnerable groups. So this is the response from MOJ, so maybe MOHW would like to respond too. Good morning, this is Ministry of Health and Welfare. First, in protecting children from online sexual exploitation, well, back in 2015, we amended the Prevention Act for sexual exploitation against children and youth. And at that time, online sexual exploitation was already included in the amendment. And nowadays, we understand that we need to respond to the new forms of digital sexual exploitation. So the Children and Youth Act was amended again to ask the service providers to bear more responsibilities in taking down any image of that element, and to have more stricter punishment for any perpetrators. And this amendment is being reviewed by the Legislative Yuan. We're also amending a criminal code on regulating the action of releasing intimate images. And as for the Prevention Act for sexual assault, we also make sure that the act can stop the dissemination of intimate images of people. And there's another amendment that is going on. And the victims may be able to entitle to support from the government in the litigation proceedings. There are protective measures for the victims.
Also, in order to provide speedy assistance to the victims of sexual privacy violations, starting last year, my ministry began a project to help these victims. In other words, we encourage these victims to seek help from us. We will help them to remove the intimate images on the internet as soon as possible. And the Department of Gender Equality, please. Thank you. I am Deputy Director of the Department of Gender Equality. I will reply in response to your questions. In terms of digital violence, starting 2019, members of the Gender Equality Committee already raised concerns about this issue, and Ministers Without Portfolio convened meetings with relevant government agencies to discuss. And in October 2020, in order to make sure that we can provide timely response, it was decided in that meeting that per General Comment number 19 of CEDAW, as well as the UN and EU's relevant regulations, the Department of Gender Equality will define such crime. We also ask the MOJ to review existing regulations that are pertinent to such crime prevention. So for serious offenses in this field, we first have to classify the severity of different offenses in this area, and there's also flexibility retained so as to meet the evolving situation on the internet. So far, there are 10 types of offenses that have been identified, including online stalking. As for policy responses, the gender equality key issues identified at the Executive Yuan will be incorporated into some action plans. The first one is to review the existing laws. The MOJ and the Ministry of Health and Welfare have reviewed the Sexual Assault Prevention Act and the Protection for Crime Victims. They have made amendments, and such amendments are being reviewed at the Parliament. So this is the result of the first action plan in reviewing laws and regulations. As for deepfake images on the internet, this is also one category of offense we have identified in our amendment to the Criminal Code. In March this year, in the amendment we submitted to the Parliament, the offense involving disseminating deepfake images was included. And some measures are proposed as to timely removal of such images. And as for the protection for victims, they are also strengthened and included in the amendments. And also, last December, we have passed the Stalking and Harassment Act. Starting June this year, it will come into force. The relevant ministries are looking into the implementation of the new act. In addition, there will be cross-ministerial task forces to see how educational campaigns can be organized across different departments and ministries. Every 6 months, the Ministry of Education will convene a meeting to monitor the progress. In addition, data-wise, the Ministry of Wealth will look into the prevalence of digital violence. Other ministries will also collect data on the gender of victims and the perpetrators of digital cyber crimes, so that we will have more gender-based disaggregation of data in this area. Thank you.
Responses, for your detailed responses. Thank you very much. I just want to make sure that I have understood you accurately. You do have an anti-stalking, cyber stalking act already. You do have one. Am I correct? Yes?
是的，
That is correct. Maybe the Ministry of the Interior can provide some explanation.
Thank you so much for an explanation. I'm just establishing the fact. You do have an act for cyber stalking, for stalking, which is very good. You're one of the few countries that have that, so that's an improvement for you. But you also have in the legislature amendments to your penal code on various other forms of digital violence you have presented, and hopefully those amendments will be passed. This year, will it be passed? You think this year it will be passed? Which sitting of Parliament will that be? You hope. Yes, I know these processes sometimes take time, but we are not yet halfway through the year, so I would expect before the end of the year these amendments will be passed, which is very good again, good move. I have a couple of other issues that I want to continue with the chair. And one is on domestic violence. The committee proposed in its previous review that there needs to be a comprehensive national action plan on domestic violence. In your responses for this review, what I read was that there is a strategy that you are employing, and you've described the various elements of that strategy for domestic violence, but it does not take the form of a national action plan. A national action plan will be, because you had the committee's concerns was, you had done a great deal for domestic violence, many initiatives from various ministries, lots of people are addressing, lots of institutions are addressing it. We suggested that you need to do an impact assessment of all those initiatives, and on the basis of that impact assessment, develop an action plan that will take care of any lacunae, any gaps, anything that is not being addressed, any inefficiency of a particular initiative, that you would have a comprehensive action plan. I still don't see that you have a comprehensive action plan. My question to you, because a comprehensive action plan will have goals, objectives, benchmarks, indicators of success, budgetary allocation, capacity building based on research, evaluation, monitoring. It's much more holistic in its approach, an action plan, rather than just a strategy that you will be implementing. So do you have an intention to develop an national action plan on domestic violence? Because that is the most severe form of violence against women, intimate partner violence. Do you have an intention to do this action plan? Or you feel what you're doing is adequate?
那是不是先请卫福
The Ministry of Health and Welfare. So I speak for the Department of Legal Affairs at the Ministry of Health and Welfare in response to your question. Taiwan's Domestic Violence Prevention Act already stipulates that every 4 years, the government must release a report, a national report on domestic violence, in which you can see data presenting the current status of domestic violence in our country, and of course, the efforts made by different ministries in protecting victims, prevention of domestic violence, education programs. And based on these efforts, we will review whether there are still gaps. And then we will ask the relevant ministries and commissions to include in their next year action plan or strategies what actions they are going to take to make improvements. So this national report is available to the public. Everyone can see how far we have gone in fighting domestic violence. In other words, because of the provision of the Domestic Violence Prevention Act, we have to do that. Moreover, at the central government level, there is a cross-departmental task force which will convene once a year. During the meeting, representatives from different ministries will report on the progress of their work. There will also be practitioners, the first-line workers in fighting domestic violence, report at the meeting what needs to change, what gaps there are. So that is a cross-departmental or cross-ministerial task force. Moreover, according to the law, we have to set up a cross-departmental mechanism where problems in fighting domestic violence will be gathered on a regular basis. Thank you.
Much for that response. I have one last question, and this is to do with the Gender Equality Department. One of the recommendations of this review committee in the previous review was that this department must be upgraded and budgetary allocations increased. Now you have reported that your Gender Equality Department has indeed been upgraded and you have increased budgetary allocations too. But I would like to hear from you a little bit more detail about this upgrading. What are the elements of upgrading that you have done? You say you have upgraded. And what is the percentage of budgetary allocation that has been made? In upgrading, have you increased the quantity and quality of the staffing? For example, capacity building has been increased, or the percentage of budgetary allocations that you have made. If you can just explain, describe that upgrading a little bit, I would be very grateful. Thank you.
So the Department of Gender Equality. Thank you for the question. So as for upgrading, the department was set up in 2012. Before that, in terms of women affairs, there's the Department of Social Affairs under the Ministry of the Interior was in charge of the women's protection affairs. But then the Executive Yuan set up the Department of Gender Equality. That is an upgrade already. Through such a organic design, the department has the right to promote gender equality activities at different ministries.
As for human resource allocation, when it is still the secretariat to the MOI, there were about 6 people in the division for women affairs. When a gender equality department was created, that the headcount becomes 30. Recently, when we evaluate all the human resources at the local area for gender equality affairs, there are 81 people scattered around in different gender equality affairs task force. And in 22 counties and cities, altogether there are 110 people. And budget-wise, there were about $80 million in 2019. That was an increase of 30.7% compared to 2017. The increase of the budget is 24.3%. So Gender Equality Department has its own budget. Additionally, in 2020, we have the new gender budget for various ministries and departments. And agencies under Executive Yuan have a gender budget of $46 billion in 2021. So there had been an increase of the overall gender budget. Thank you.
One point that you made is something very important, and that is, and I'm hoping I understood you correctly, the Gender Equality Department has the authority to promote equality in matters and plans in other ministries as well. This is a very important element of the capacity of the Gender Equality Department, its authority to do this. And you're telling me that here your Gender Equality Department can do that, and that is a very good point and to be appreciated of what you're doing within your government. Thank you very much. I have ended mine.
Thank you very much. Are there from other members of the review committee any questions in relation to Articles 2, 3, 26? Bill, please.
Thank you. Yes, I have a question about terminology. When we're talking about sex, gender, etc., some of the materials that have been provided to us raise this issue and refer to, I think one of them talks about a debate or substantial controversy in Taiwan about the use of these terms. It's maybe impossible for our committee to actually delve into this too much because of the linguistic issues that are involved. I remember, I think when this controversy first developed at the international level was in the early 1990s, and the Beijing Conference on Women, which had a special note about the use of the term gender, yes, which then was very controversial. Perhaps you attended the conference, I don't know, Shanti.
They debated it for a whole afternoon.
Yeah. Well, they also did a few years later when the Rome Statute was being adopted, and I was present for that, and there's a very curious, weird paragraph in the Rome Statute about the use of the term gender. When this happened in the 1990s, I was living in a bilingual country in Canada, and I remember my colleagues, my French-speaking colleagues, saying that they were puzzled by the debate because they said they thought it was meaningless in the French language. And I suspect that this is the case in other languages, including Chinese. So I don't have I don't really have a question about this. I just wanted to raise the issue because it is raised in some of the materials we've been given, and I wondered if the government might have a comment on this, on the use of terminology that might be useful for us to know a little bit more about it, although, as I say, I think we would have to be very careful about trying to venture into resolving a linguistic debate in a language that none of us are really fluent in.
Thank you very much. Would you like to respond?
Wow, sex and gender. Maybe Gender and Equality Department can help us out with this one. Thank you for your question. Right. The issue on sex and gender was also raised in the third state report review for CEDAW. I think some NGOs at the time also raised their points. Gender Equality Department refers to general comments of CEDAW. Expand the scope of sex as it was stated in CEDAW because it includes physiological sex. It also includes a social gender. And we use the Chinese term 性别 to include both. But NGOs have their different views. And in paragraph 73 of the COR for the third CEDAW reports, we invite the CEDAW committee members and more than 20 NGO representatives to discuss the usage of these terms, sex and gender and their equivalents in Mandarin Chinese. In the Chinese context, the two terms, 性 and 性别 they are not confusing. But for government regulations, the translations of sex and gender are not consistent. That's why when international committee members read information provided by the government or the NGOs, you may see some inconsistency or even some confusion around the terms. So after the meetings, we consider the executive practice and the judicial practice in Taiwan. The two terms doesn't cause any trouble in practice. I think inconsistency of translation is the problem instead of the practice of the law. And we have generated a glossary on gender equality departments and websites that includes such terms. So thank you very much for raising this concern, and we did try to resolve this.
Any other questions on 2326? Hoka.
Thank you. Just quick suggestion. Actually, it's if there is any way that they can also include the indigenous peoples into the national human rights national strategic plan. The implementations. Thank you. If that's possible. Human rights action plan. Human rights action plan. Because this is also the experience from my country, Indonesia. We are part of the process of establishing the national human rights plan, and it makes much more easier in the implementation if it is put in one national human rights plan all together with others.
But we were promised we will get the national human rights action plan as quickly as possible, and then we can have a look at it and then see whether we have any questions. If there are no other questions on this, then I would propose that we have a break. And is it fine, it's now 10:10, that we meet again at 10:30? Bill, please. The time is now 10 minutes past 10. Bill?
Is the idea then that we would pass to the next phase with the NGOs, or will we start
No.
with the government?
No. We have until 11:20
Okay.
with the government, so that we then raise other questions in relation to Articles 4, 5, perhaps also 27, that has not to do with indigenous, etc. So we have still almost an hour if we now break for 20 minutes.
Excellent.
Yeah? Is that okay with the government? Thank you very much. Then I'll see you again at 10:30.
Uh, 各位贵宾，有关于洗手间的使用部分，因10楼南侧为国际审查委员专属厕所，请勿使用。有需求者，请改到11楼使用。那接下来会议即将在10点30分准时开始，谢谢。
OK， 好，谢谢。里面包含的他说 Aboriginal people， 也包含了 LGBTI， 我们都会尽可能的保护他们。好，待会有的话OK， 谢谢。
Yeah. Can we start? Thank you. And I should also say that we are very grateful that we already received the National Human Rights Action Plan in English, and we will study it carefully and perhaps tomorrow come up with certain additional questions that derive from the National Human Rights Action Plan. Then I have a more general question. Could the people who are speaking simply raise their hand or somehow, because we are often not really clear who actually is now speaking on behalf of any kind of governmental department. So it's easier for us to directly communicate with you. We have dealt with Articles 1 and 27 in relation to indigenous peoples, and then 2, 3, 26 in relation to equality and non-discrimination issues. So now we come to the remaining articles, and my first one concerns Article 4. If I read the third national report, it's very short, and it says, since the incorporation of the Covenant into domestic legislation in 2009, Taiwan has never announced or rescinded its obligations for the protection the rights specified in the Covenant in accordance with the regulations of this article. Perhaps just to be very, very clear, most rights of the Covenant can be restricted in accordance with specific limitation clauses, unless these are absolute rights, like the prohibition of slavery or the prohibition of torture. Then there is no limitation allowed. But freedom of movement, freedom of assembly, associations, freedom of speech, etc., they all have a certain limitation clause in normal times. But in addition, Article 4 says in times of public emergency, a government can go beyond if it declares a state of emergency. That can be a state of war or a state of health emergency or any other kind of earthquake or whatever is the reason of the emergency. But the report was done before COVID. And in the meantime, COVID-19 developed and caused serious health problems all over the world, where all governments needed to respond, and quite a number of states felt that within their regular human rights architecture, they would not be in a position to actually respond to the health threats that are also directly targeting the right to life. So they needed to declare a state of emergency, and in accordance with that, of course, informed other states, informed the Secretary General of the Council of Europe or the Secretary General of the United Nations, etc., about the measures they have taken. I think Taiwan is among the countries that has taken very, very far-reaching action that is infringing on many human rights. Personal liberty, freedom of movement, the right to work, the right to education, freedom of assembly and association, privacy, of course. So quite many rights, and that is also explained in the responses of the government to our list of issues. We explicitly asked the government to tell us whether they actually have declared a state of emergency, and if so, when, and whether they also implement it. So that's why, but we didn't receive an answer. The answer was again all the different measures that you have taken, but you didn't respond to the question, did the government of Taiwan consider COVID-19 of such a severity that you declared a state of emergency, and if so, was the state of emergency declared in accordance with Article 4 of the Covenant? And if so, which are the rights from which you derogated from? And for which period? Is that period still currently running, or did you terminate it, etc.? So may I raise this question now to the government? Did you declare any kind of emergency? And if so, did you derogate from any of your obligations under Article 4 of the Covenant on Civil and Political Rights? Thank you.
Well, the Ministry of Health and Welfare will respond first. Good morning, Chair and members of the committee. I speak for the Department of Disease Control under the Ministry of Health and Welfare. In response to your question, at the beginning of the pandemic, we did follow the Disease Control Act of our country, and we also have a special pneumonia special act in January 20th, 2020. We asked the Executive Yuan to approve our request to set up a Central Epidemic Command Center, CECC, and we pulled together resources from different ministries in the fight against the pandemic. And we have identified measures to meet different severity of the pandemic as it evolved. For example, on January 27th in 2020, we elevated the alert level, and then on May 19th, 2021, we further elevated the alert level to level 3. And of course, as the pandemic evolved, we dynamically adjusted our responses. So on July 27th, 2021, we lowered the alert level. Currently, the pandemic is still ongoing. Therefore, the CECC is still running. Thank you. Well, we did not declare a public emergency state in constitutional terms, because we don't want to cause a panic among the public. That is why we enacted the Pneumonia Special Act, empowering the leaders and local governments to take measures necessary to contain the spread of the virus. And the leader of the CECC can release administrative actions or new directives. For example, border control, limitations on freedom of travel. And if people feel their freedom has been violated, they can file complaints. For example, at the very beginning, the incoming travelers would have to stay at a centralized quarantine hotel. And the habeas corpus works in this situation. If there's any complaints, the people can definitely file their complaints at the relevant court. We know that health is important, but we also want to protect human rights. So if people feel their freedom has been violated, there is opportunity for them to seek remedy. But right now, the Minister of the Health is the leader of the CECC.
Working? Yeah. Just to follow up what you just said, have any such complaints been made, and what has been the outcome of the complaints?
I again speak on behalf of the Ministry of Health and Welfare. In response to your question, have we received any complaints? The CECC has set up a hotline, 1922, to collect complaints and opinions from the public.
Based on their opinions and the content of a complaint, we may see some people say that they want to go to the hospitals or someplace, and then we will refer this case to local agencies for their assistance. Yeah, I think there were some human rights complaints. For example, a few months back, some pilots from airlines think they have to be quarantined and cannot return home for a long period of time. So they feel their liberty has been infringed, and therefore habeas corpus complaint was filed. So a court had once revoked the requirements of the quarantine, and also there are some disciplinary actions taken against those who violate pandemic preventive measures. But for people who are fined or punished, they can seek remedies in court too.
So thank you very much. So I understand, and I also understand the reason. Of course, if you declare a public emergency, that might spread panic among the people, and in principle, for the rights that we are talking about, they are not absolute rights, so they can also be restricted. But partly I had the feeling when I was reading your, for instance, replies to the first list of issues, page 12, paragraph 5, when we talk about freedom of peaceful assembly association, then it refers to the regulations for this are all according to the guidance about assembly from the Central Epidemic Command Center for COVID-19. And then you say to limit the number of assembly is for the safety of people, but not restrict their freedom of assembly. And I would disagree. I think, of course, if you're restricting assemblies, if you restrict the numbers of people who can participate in an assembly, you're restricting the freedom of assembly. Whether this is a violation or whether it is a justified restriction, that's a different issue. But I got a little bit the feeling that this kind of balancing was not really done in the way how it was perceived. So I don't want to be misunderstood. The COVID-19 pandemic is one of the events that has had the most severe consequences. And every state has an obligation to protect the right to health and to protect the right to life of its people. So I think it is certainly justified to restrict freedom of movement, freedom of assembly, etc. But I think there must be an awareness that there needs to be a balance. And I have a bit the feeling that the Central Epidemic Command Center is a very powerful body that takes action because they feel we have to do that in order to protect the safety and health of the people, but without really looking into whether these restrictions are really within the limits of international human rights law. Would you agree with my statement, or could I have any kind of response from you, whether you feel that that perhaps partly the Central Epidemic Command Center went beyond its powers, if seen from the point of view of human rights?
Ministry of Health and Welfare, any response? I'm from MOHW. As to your question, some limits on association or assembly indoors, well, those restrictions were imposed given the severity and urgency of COVID-19. And COVID-19 virus is airborne. It's more infectious, and it was quite severe at that time. So whenever we pronounce new measures, well, CECC would do that through the daily press conference and explain the latest measures to people all around Taiwan. We think it is very important to communicate the risk factors to the people and explain to them why such measures are necessary, why there's a limit on the number of association and assembly. During the daily press conference, CCC announced relevant statistical numbers And the limitation on the numbers of association change in accordance to the realities, so that we can balance protection and economic growth. So we flexible adjust the level of alert. There was such a limit because Delta virus was rampant, but now the virus strain is Omicron, so the preventive measures are adjusted accordingly. Whenever CCC make new measures, they talk to experts and scholars first. These experts and scholars are from public health field and clinicians, as well as other academic experts. CCC also talks to local governments. So communication is done before such measures are announced. I think most of the people in Taiwan understand that such measures are for the benefits of the safety and health of the people. So we explain that such limitations on personal freedoms are only temporary, and we impose or accept these restrictions because we want to protect our family and friends and ourselves. Such measures are designed to stop the spread of the infections, and when people understand the rationale, they can accept such measures, because our enemy is COVID-19. Our enemy is not each other. So when we explain the measures to the public, we explain the rationale. Thank you. I would like to add some remarks here. Yes, balancing human rights is important in fighting against COVID-19. That's one of the most important principles for the government, in addition to some health policies. So the principle is to maintain adequate prevention, but avoid prevention fatigue while still protecting human rights. So that's the balance the government wants to strike. So some things are not really forbid, they're just limited. For example, 2 years ago, the number of indoor association was 5. It was 10 people outdoors, and then the restriction was lifted. It was not to forbid people to get together. It was simply limitation. And I think, of course, there's room for discussions as to how measures should be adjusted. And CCC doesn't have the absolute decision power because ministries, agencies, and local governments have their authority to decide how to implement the policies. For example, how to limit the movement of the offshore boat for the offshore wind farms, because the boats need to come in and there are staff on the ship. So this matter is dealt with the Bureau of Energy. In the special regulation for COVID gives a lot of power to the CCC and the commander, but in fact CCC doesn't exercise this power to the highest extent. I think information protection and privacy had become an issue in preventive measures, and there was a meeting with human rights experts and NGO representatives. There were online and offline meetings. Some of the measures that were being planned were then later considered to be out of the proportion and infringe upon human rights, and therefore some measures were dropped. That's how the government strikes a balance between preventive measures and human rights.
Thank you, Madam President. Can you? Yes. It occurs to me that you might explain that it may not be obvious to everybody in the room when I'm called Bill and it says my name is William here, that we're talking about the same person. But Bill is a diminutive of William. I'm sure many of you know that, but perhaps not all of you. This is a difficult question, the COVID issue. I think it would be, we would be remiss if we didn't take it up here and raise these issues as we've done. I think at the same time we have to recognize, and perhaps our colleagues in the other subcommittee will be doing this, how successful Taiwan has been at preventing, above all, the most severe consequences, the deaths from COVID. I think at the top of the charts in terms of deaths is the United States, with apparently about 1 million people who are believed to have died from COVID. And here in Taiwan, I think the number is about 900 or 1,000, something like that, of that order of magnitude. So 1,000 times more deaths in the United States than here in Taiwan. And although you're smaller than the United States, you're not 1,000 times smaller than the United States, but more like, what, 10, 15, 20 times smaller than the United States. So it's quite remarkable, and it's important for visitors like ourselves to feel safe here as well. I'm happy to learn there are ways of challenging some of the restrictions. Perhaps one of you can tell us how we can get the swimming pool at the hotel open so that we can go there at some point this week, if that's possible. You can press air. You don't get yeah. Okay. But the issues are very complex about balancing and achieving, and again, I think our colleagues will address this, the right to health. But of course, we cover that under the Covenant on Civil and Political Rights, above all through the right to life, which is also about the protection by the state of its population from epidemics and so on. But it raises this question of the difficulty. There's also an international dimension, and again, perhaps because there's more of an opening for that in the, there's more possibility in the Covenant on Economic, Social, and Cultural Rights for the idea of international cooperation in the respect and attainment of the objectives of the Covenant. The issue is clearer there, but it's also a fact that that the COVID epidemic has had much more severe consequences in poorer countries, and also on minority groups, people of color around the world, both in developed countries and in developing countries, and that there's a responsibility on the wealthier countries to contribute to that globally as well. The other issue I'd like to take up concerns Article 4, and it's separate from the COVID issue. The COVID issue is raised by Article 4 because it's about ways of suspending or derogating from fundamental rights. But Article 4, of course, is a provision that strikes me as difficult to implement in the very specific legal circumstances of Taiwan's implementation of the Covenant on Civil and Political Rights. Because Article 4, dealing with derogation, it's an international law provision. It's one that doesn't obviously fit into the domestic law. It's about notifying the treaty, notifying the treaty partners, first of all, the other states parties to the treaty, through a formal notice of derogation. And obviously that's somewhat irrelevant, although I think we've raised the question that perhaps were this to happen at some point, that Taiwan ought to notify perhaps this committee, although it's not a permanent committee in that sense, but perhaps that might be part of the incorporation of the International Covenant on Civil and Political Rights in the legal order of a state that's not a state party to the treaty. And I wonder if some thought has been given to this, because the incorporation in the domestic law of the covenant Can this be suspended? Well, of course, if it's in domestic law, you can always, by another legal instrument, another statute, another law, suspend the existing law. And that's a normal situation, and I think the answer would be, yes, that could happen under Taiwanese law. The problem there is that Article 4 also makes a distinction between some rights that can never be suspended and those that can be suspended. It makes that very clear by providing a list of rights that can never be suspended, including the right to life. How do you reflect that in the Taiwanese legal order when you implement the Covenant on Civil and Political Rights? How do you distinguish between those rights that can never be suspended? The right to life, the prohibition of torture and cruel, inhuman, or degrading treatment or punishment, the prohibition of slavery, the prohibition of retroactive criminal offenses, and so on. So I don't know, this is the first of these meetings that I participated in, but I asked my colleagues, and apparently in previous meetings this was not explored, and I don't know that we have to explore it today, but I just think that it's useful to alert you to that issue, and that perhaps, maybe this has already been thought through, but that it would be appropriate to give some thought to the idea that the full incorporation of the Covenant on Civil and Political Rights requires that there be some distinction in national law between rights that could be suspended in a time of public emergency that threatens the life of the nation, as Article 4, Paragraph 1 states, and those that can never be suspended. So I would like to raise this issue. I can't guarantee that we will even agree to include it in our concluding observations, perhaps not, but I think it's useful to alert you to that question, and I'd be curious if you have any thoughts on this issue. As I say, perhaps a lot of thought was given to whether or not Article 4 should in some way be reflected in the implementing legislation. Thank you.
The Ministry of Health and Welfare. So in response to your question, in our Disease Control Act, Article 11 of the Disease Control Act for people with infectious diseases or for medical staff taking care of these patients, or for patients home-based quarantine, we must ensure their rights are protected. There should be no discrimination against them. Article 12 of the Disease Control Act also says that for individuals, enterprises, the rights to education, housing, work by patients with infectious diseases must be respected. So in our Disease Control Act, we already have similar provisions to specify what rights must not be derogated. In our Pneumonia Special Act, there are also provisions about protecting the right to work. For example, the people involved in the prevention of the pandemic, there will be some subsidies provided by the government to them. As for those who have to be quarantined at home or at the centralized quarantine hotels, there will be subsidies or allowances provided by the government. And there's also so-called vaccination day off mechanism in place. When we consider or formulate preventive measures against the pandemic, we take into account human rights protection. because in our education and development process, we have learned that we have to know what potential impact our measures may have on people's human rights. Therefore, we have gathered literature and research studies from other countries. We also seek advice from scholars, experts, stakeholders, and relevant ministries. So in-depth discussions take place before any preventive measures are made and implemented. So that's my response. Thank you. I would like to share with you some data. As of last Tuesday, the CECC's data shows that worldwide, COVID-19 cases have come to 510 million confirmed cases worldwide. As for death, 5.57 million. 6.25 million deaths. This, of course, is worldwide data. There. As for in Taiwan, as of yesterday, as of the end of yesterday, confirmed cases have come to 390,000. Deaths totaled 931 deaths, less than 1,000. So I think we have taken more stringent preventive measures. That is why, compared to some countries in Africa with poor infrastructure, as well as compared with advanced countries such as the US, we have relatively outperformed. And I think we can not, of course, give way to unlimited restrictive measures in the name of containing the pandemic. We have to strike a balance between protecting people's health and human rights protection. And of course, we have to perform rolling analysis and assessment. We have to apologize that I'm sorry that you have to stay at the hotel where the swimming pool is not open, and we have to take special measures. We are working hard to lift relevant restrictions. In addition, according to the Pneumonia Special Act, for those whose life has been affected because of the restrictions, for example, those who have to stay at the centralized quarantine hotels, we do provide some compensation. Of course, it may be just nominal compensation. As for businesses that have to close, we also provide some assistance to those business owners. In addition, we are not allowed to reveal the identity of the confirmed patients. We don't want them to be discriminated against because they have been found to be confirmed cases. So these are the efforts we have made to protect human rights. Well, there was once a proposal that maybe all incoming visitors must have undergone the PCR testing, but that may be too invasive as a measure, so it's not taken. Moreover, The CECC also stays in close contact with WHA associations and related organizations. We do receive information from the WHA. We also report our status to the WHA. However, we are not invited to attend the WHA assembly. We hope that we will become an observer of the WHA soon again. Maybe your help will be much appreciated. But in any way, we try to maintain the transparency of all the data we have.
Right. Thank you very much. I think we are very aware of the policies that the government has taken. I think in future we would be happy in a similar case that also in the reports this balancing that you were talking about would actually be explained in more detail. That you are aware. I mean, if I again read from the replies to the list of issues, there's a sentence simply saying people's freedom of movement is not limited. Now this is simply wrong. I mean, our freedom of movement is limited. We are contained in the 15th floor of the Sheraton Hotel. It's beautiful, whatever, and I think it's justified. But you cannot say the freedom of movement is not limited. It is limited, but it has a good reason. It's justified. You want to prevent the spread of the COVID-19 pandemic. And I mean, we are not important, but I think there are quite a number of migrant workers where the limitations are fairly drastic. And I think that is something that might also be a concern, whether this is still justified by the good intentions of the health policy. And I mean, Covenant Watch and also the National Human Rights Commission have explained concerns about certain of the restrictions that have been taken by the government. And I think it is sometimes a difficult balancing, and perhaps certain measures went too far according to international human rights law, and that we will also look into more carefully whether there will be a concluding observation or not. I don't know yet, but simply that there is the awareness that not every restriction is simply in accordance with human rights, simply because it is for the good cause of preventing the spread of COVID-19. And of course, your statistics speak for themselves. I think we all recognize that Taiwan has, compared to other countries, and you mentioned the United States and Africa, I could mention Europe. There are many European states that did much worse than Taiwan in having much higher numbers of infections, but also people who needed really intensive care, and those who died, unfortunately, from the pandemic. And I also take your point on the WHO. Of course, I share very much the concerns that in such a situation where we have really a global pandemic, and we have never had that since, I think, World War I, that something like this happened, and that a country like Taiwan is simply excluded from the most important international organization that is dealing with pandemics, the World Health Organization, I think is not an ideal situation. Anything else, please? Bill. Sorry, Professor William Chavez.
Just a final reflection on these issues, because it's true, one of the things that the pandemic has done is underscored the fact that this is an issue that requires a global response, and it's unthinkable that a territory of 25 million people are excluded from that, because it's necessary that the whole world be engaged in solving the problem. So this is one of the things that's been, I think, been highlighted. The other thing, I referred to the inequalities that have happened globally, and this has been highlighted, and these are benefits. One of the other things is that states even have assumed greater responsibilities for the welfare of their populations than ever before, in terms of minimum income and so on. So in that sense, this has been, I don't want to say it's a blessing because it's been a curse, but there are these positive consequences of it. But all of them raise serious human rights concerns, and they have to be taken into account by states when the measures are being adopted. Think of children and education and the limitations that the restrictions imposed by COVID have imposed on the rights of children to education, for example. Even the wearing of these horrible masks, which we've become accustomed to. There's a decision of the European Court of Human Rights from about 5 or 6 years ago dealing with the wearing of masks, where the French government France had adopted legislation that made it an offense for women to wear masks. And the French justified this before the European Court of Human Rights. Now, not masks for medical reasons. You know what I'm speaking about. And the justification was that it was important for society that we could see everybody's face. And I think that's true. I think it's true. And so in making us wear masks, we're restricting. We don't really communicate as human beings as effectively as we should. And that, too, is a violation of our human rights. But they all have to be weighed against the necessities of health. That's the great challenge.
Thank you very much. We are also coming to the end of our time. So perhaps last question, anything else that any of my colleagues would like to raise before we finalize this meeting and then immediately start a discussion with the non-governmental organizations? Anything from the part of the...
No, there was one issue that I left out on the equality. Can I raise that now or not?
If it's very quick, yeah, so that we don't take too much time away from the NGOs.
Very quickly, thank you very much for giving me this time again, and my apologies to all of you. There was one question that I wanted to raise on the equality issue that I left out, and this is that in the previous review, we had raised a question about data on compensation given for victims of sexual harassment when there was a conviction, and the response was that no such data can be collected. The reason given was that there is no type and cause of action set up for civil damage claims filed for sexual harassment, which means, in other words, you're saying the law doesn't allow such claims, and therefore it's, this is how I understand it, so that you cannot. Very quick question, will you consider amending your law so that damages can be awarded, civil damages can be awarded for victims of sexual harassment? Will you consider that? That's all.
Thank you. Who could respond to this question, please?
Ministry of Health and Welfare. I think prevention, Sexual Harassment Prevention Act is being amended right now. So anyone who would like to respond? Okay. Victims of sexual harassment, if they ask for civil damage claims, we don't have such data. We don't have such statistic data. The data we have is how many people file for sexual harassment complaints. We do have such data. We do have the number of the cases. As for, so we have some damages under the administrative measures. However, if it is civil damage claims, we don't have the data. Anything to add? This is the Civil Division of Judicial Yuan. If we use some keywords to search in our database, for example, we use sexual harassment or sexual assault as keywords, and then we and another keyword, civil cases, to search the database, and then we can use manual search to find such cases. We're able to find about 1,400 cases. But some of the cases are about civil damage claims between spouses. So when we use keywords to search, we are not able to limit the search result to victims of sexual harassment, and that's why it's difficult to provide the data.
Follow up on this very quickly. I understand that there is no data. You've already explained that, so that's not the answer I'm looking for. What I read in your responses was that it is difficult to gather such data because there is no type and cause of action set up for civil damage. So I'm asking whether you will consider amending your law. If your Sexual Harassment Prevention Act is being made now, will you consider including a provision which makes it easy for you then to identify whether such damage has been given and whether that can be collected? Will you consider amending your law to make this possible? That is my question. Will you think about it? Will you consider it? That is my question. Are you willing to commit yourself to this?
Judicial Yuan, is it possible to adjust the way you collect data? Yes, we can think about to set up the type of the case. We can set up an extra type for that. To do that, we don't need to revise the law. Yeah, using keywords to better search. Maybe the Judicial Yuan can study how to better use the keywords to search for the data that's more specific.
I'm trying to explain myself. In many parts of the world, including Malaysia, where I come from, the law doesn't permit a budget. Where is your source of budget for compensation? So that such damage is not provided for in the law itself. And therefore, damage is not, compensation is not given out. So my question is not so much with the collection of data, but whether your law, you will amend your law to allow for provision of compensation when there is a sexual harassment case. That is my question. Maybe we won't take up time now, but I want you to consider that. And we can talk about it later if you want. Thank you.
Thank you very much. Yeah, so perhaps we might also take it up in the concluding observations. Any final statement from the side of the government? Then I thank you very much for taking the time and also responding to all our questions, I think in a very constructive manner. We interrupt now for about 2 minutes only and then continue immediately with the non-governmental organizations that are present here. Thank you.
谢谢各位长官的与会。
Thank you very much. Refreshments are provided in 10:01. Please go to that room for refreshment. And our next session with NGO will start at 11:30.
请勿使用。有需求使用者，请改至11楼使用。谢谢。
will be a ring bell sound. And when you hear the second ring bell sound, please stop. And if you want to speak, please raise your hand so the reviewers can see where you are seated. Please identify yourself, your affiliation, and please speak at a reasonable speed. Thank you.
Thank you very much for meeting us. May I correct the speaker just before me? As I have indicated yesterday, I'm not following this procedure. So I am not looking for your speeches, prepared speeches. We want to have, and I think most of you have been present already during our discussion with the government. So what we want from you is your reactions to our discussion where you feel information is missing or where you feel that the government provided information that is not accurate, without going too much into detail. So if there is something very specific in detail, please provide it in writing. But we would like to really have a feedback on our discussion with the government, and we will structure it to this according to the same clusters. So the first cluster is indigenous peoples. We had a long discussion with the government, and I would like to ask those NGOs that represent indigenous peoples and indigenous peoples organizations themselves, where you feel, and also keep in mind, what are the main issues? Did we raise the main issues, or is there something missing? So what are, in your opinion, the main issues that are not in accordance with international human rights law, in our case, Article 1 and 27 of the Covenant on Civil and Political Rights, and that we should raise in our concluding observations? So whoever wishes to start, please do. You have the floor.
好，委员您好，我是人权促进会第一次发言。那我自己本
Hi, I'm from Taiwan Association from Human Rights. I am one of the Pingpu peoples. I think CIP in the morning said that they started to promote the amendment to the law and want to add Pingpu people into the list. But for us, this is a very tricky issue because we worry that if this is the case, we will become a different type of indigenous people, which is different from all the other indigenous peoples, and this will damage our rights.
Speed so that the interpreter can actually interpret.
We think that in the past, CIP used administrative orders to deny us to re-register us as indigenous people, and this is not in compliance with self-determination. There were many shortcomings in the registration procedure because the procedures were not known to the public, not made public to the indigenous peoples, and government, however, used this as an excuse, saying that we opened the registration to you before. You didn't come to register, and this now is used as an excuse for us to recover our identity as indigenous peoples. And therefore, we hope that in recent years, in the coming years, the CIP would abolish these or stop saying that we didn't register so that we can re-register ourselves as indigenous people. In this process, the CIP should also consult with different groups in Pingpu peoples and engage us, because after dozens of years, our situation is totally different from other indigenous peoples in Taiwan. Our needs and so on have not been considered in CIP's administrative policies. So when they change their laws and regulations, we urge that they have to include our opinions. Thank you.
Please ask the organizers to stop this bell. I'm not applying it anymore. We have a different rules now, as I explained before. Yeah, did you finish?
好，请问您刚刚的发言结束了吗？I also want to add something. Well, in the morning, CIP said that they calculate the population of Pingpu people, saying that it's 980,000. But this was because they wanted it to scare the public, saying that, oh, there is such a big population of Pingpu people. If we add Pingpu people as another indigenous people, they're going to share all the benefits that you could have enjoyed. However, this number is not correct. I think the Pingtung County thought there were 30,000 Pingpu people, but after the registration was open to us, only 2,000 Pingpu people went to register. So it was not such a big population as they thought. They are saying that population is so big as an excuse that they don't want to add us as another indigenous people. Thank you.
Much. Just one question, and then I pass on to Ruka. What I understood from the government is that this issue now is before the Constitutional Court, and that there will be a decision before the end of the year. Can you confirm that?
This case involves the Siraya indigenous people. They use administrative proceedings to protest to the government because when the registration was open, their people was ignored. And in the morning, CIP said that Siraya people wanted it to be categorized as the plain people, but that's not right. So the case is in constitutional court. That's right. At least part of the matter is about indigenous status. But it is not in conflict with the fact that CIP should have already revised their law. And it is because there was the absence of the amendments that Siraya people had the only way to seek remedies at the Constitutional Court.
Roger, do you have specific questions?
Hello? Yeah, thank you. I think I really need clear guidance from the indigenous peoples. What the aspirations, the visions, do you really want to be categorized as mountain indigenous peoples, lowland indigenous peoples, and then the Pingpu, because that's the three categories, right? I think that's very important to also respect the rights of self-identifications. Respect the rights of self-identification in the way we wish to be identified. So it is not, then the way I see things, the discussions now from our government counterpart is, yeah, of course they have decided, they have the rights to decide that they are Pingpu or lowland or a mountain, but still have to be, you know. So I think it is also the rights of indigenous peoples in accordance with the international human rights law, especially already in the UN Declaration on the Rights of Indigenous Peoples, saying that indigenous peoples have to have the rights to self-identification. And as as the way you wish. And I think this is very important because this is one of the problems, and this is one of the critical point where we can actually break down later on some steps that we can try to do for the betterment of the rights of indigenous peoples in this country. And for me, this category is very fundamental. We need to hear from them. Thank you.
In fact, since 2013, we have mentioned that the mountain people and the plain people, the classifications are there only to make it convenient for government to manage and run the indigenous peoples. And in 2017, we also drew a chart to show the reviewers. For example, I am a Bunong people. I'm a member of the Bunong people, and I am the Bunong people is classified as a mountain people. But there are also some plain people who are Bunong, members of the Bunong people. In other words, the classification is an imagined way by the government to classify indigenous peoples. And of course, this has come from the legacy of the Japanese colonial period, but such classification is not meaningful to us. This morning, government official also made an important point, that is, in all the policies concerning indigenous peoples, there's only one distinction between the mountain people and the plain people. The candidates you can vote for are different. So when I was born, my mom is classified as a mountain people, and I have to inherit that status. But actually, I was born in Taipei, grew up in Taipei, but I am not able to vote the representatives in the district where I live. In other words, I cannot vote in the elections for candidates that are only there to be chosen by the mountain people. So this is an old legacy. I cannot believe it still exists today, and it's even part of our constitution. So we don't think the government can use this as an excuse to avoid the duty to amend the law. We actually told the government that basically you as a person can inherit the status as either a mountain people or plain people. But when it comes to elections, you vote for candidates who are running in your electoral districts. Therefore, the current system, basically, there's a distinction between the membership of indigenous peoples based on your lineal heritage, whereas elections is based on territory. So I think this is a wrong classification. It has to be changed. Well, on the mountain people and plain peoples, this is a very tough issue for us living in the cities. People are not recognized as indigenous peoples. Therefore, we do not have a say on policies concerning indigenous peoples. But now, the general public do recognize, or at least they are aware of our status as an indigenous people, but it's not recognized legally yet. So, in fact, a few years ago, when there was a proposed amendment, we we might run into some difficulties competing with the existing indigenous peoples. Well, that is also why the Siraya people would like to be classified as plain people so as to enjoy the benefits available to plain peoples. We also want to be classified as plain peoples. But of course, our priority is to be recognized as indigenous people, and then to be classified as a mountain people or a plain people, the benefits may be different. That is why we have to settle for the second best strategy, that is to be recognized as plain people.
Thank you. I try to find a way how to put this in questions because, you know, we've heard from indigenous people's concerns about how the government implementing the law, even the indigenous people's basic law, they feel like, you feel like problematic. But then when we talk with the government, all these, you know, beautiful things and strategies is coming out, and CIP, I think it's the one that is very prominent. Yeah, so I wanted I think it's good to hear what is the recommendations, yeah, from the indigenous people's organizations on how to deal with these representations, or even within the mechanisms and also within the government institutions. And the second one is, and I think I'm coming from the Dutch agrarian laws background, yeah, in Indonesia, so we inherit that. According to our agrarian law, there is a clause that's saying that indigenous people's land belong to indigenous peoples and it is permanent rights. The other can only use it. And then they say, but according to our new law, it's already fall within what's so-called private lands. So our collective land is not considered public land. It is private land. So when company comes, what the government will do is they will first maintain the indigenous land that is already within the category of public land, and then we'll switch the private land into public land. So when it's the time to return the land for indigenous peoples, because the clauses in our, the provisions in our agrarian law also saying that must be returned to the owner before the company comes, before the permit issued. So what the government's doing is they will turn all into the public land, which meaning belongs to the state. So when it's time to return, it will not be returned to indigenous peoples, but to the state. So it's like company free, prior, informed consent. It is actually like you're losing everything. So, and I wanted to know if there is any case where land is really returned to indigenous peoples in this country.
No.
Please, please.
I speak for the Environmental Rights Alliance. I will talk about representation first. Yesterday, there's a question about the composition of the Council of Indigenous Peoples. There are 16 members who are indigenous peoples on that council, but the CIP is an executive agency. The 16 indigenous people members only provide advice. They serve as advisors. But how the 16 indigenous people members are elected. Well, for example, I come from Beinan people. Our own council would nominate a few people, and then there will be one person representing the Beinan people. But the decision is made by the council of the indigenous people. In other words, even though my people's council give them a list of nominees, but the council may actually pick someone not on our nominee list. And this has happened before, so we protested. So even though there are 16 members on the council who represent the 16 indigenous peoples, but they are chosen not based on the consensus of respective indigenous peoples, because the election or the selection process does not allow a lot of participation from different indigenous peoples. And the same problem is present in the indigenous people historical justice and transitional justice commission, because it's not up to the respective indigenous people to pick their representatives to join that commission. And in some indigenous peoples, they do not nominate. They may elect one to represent them. But in either case, I think our own decision-making power should be respected. In some indigenous peoples, they may have lost or weakened their own heritage in selecting representatives. But in either way, we don't want to be imposed on us a modern way of selecting our representatives.
Representatives should represent the 16 different indigenous peoples. Is that correct? So one representative per indigenous people. And you come up with, I don't know, a number, and they are choosing then, but they are choosing from your list. Or they can also appoint somebody else whom you have not proposed.
They can also appoint someone else.
Always appoint.
So sometimes they do pick from our list, but depends on different peoples. For some peoples, they will pick from their list. If they like it, then they pick from it. But if not, they don't. And with these 16 peoples, there's no Pimpu representatives.
Okay.
So usually they would pick people who are submissive, obedient, cooperative with government. So anyone who has been an activist, an advocate, is unlikely to be chosen. Most importantly, the CIP members are not there to speak up for the 16 indigenous peoples. They are, well, quasi-officials because they are paid by the government 100%. Most of the time, they promote government policies.
Of how many members? Is it only the 16, or are there also others?
And for the council, they have a minister. So that's the person who is actually making the decision. And for the 16 members, they are the only 16 members, and the others are staff members, or no, not staff members. They are public servants.
Okay,
Yeah.
so the decision makers are the 16 representatives?
No, not really. They are consultant. I'm more like consultant. They are not the one to make decisions.
So who is the minister?
The one who the president assigned.
So you mean there is, among the 16, there is one that is called minister?
No.
Another one.
Another one. So like the structure is that the highest one is the minister,
And then you have the
and
council.
then we have the council. But the council is like on the side,
council.
on the side. as a consultant body.
Consultative body meaning advisor. They give,
Yeah, advisors.
Advice. Yeah. Okay, that's very clear now.
Not to me. Not to me.
So with the name?
There's the Council of Indigenous Peoples is a governmental agency.
Yes, it is.
Right?
Yes.
It's under the Minister for... What's the title of the minister?
Well, it's under Executive Yuan.
Under?
Under Executive Yuan.
Yeah, but who, Executive Yuan is the government, but who is the minister?
So even though with the name is Council of Indigenous Peoples, but in fact, with the administrative system, it's a ministry.
It is a ministry.
It is a ministry. So there's a minister to make the decision for the whole ministry. But then they have this council of 16 members as advisors.
形式上的
They are the advisors, well, on the surface or as a formality, but that's not how things are really done. That's just a formality.
Indigenous peoples cannot take decisions. They are only advising. So the only one who takes decision is the minister.
The minister of the Council of Indigenous Peoples.
Okay.
That's the title.
Okay.
So it's the minister is actually not minister, but it's like the chair or, you know?
It's like the chair of the council, but he is not from the 16 people.
Yeah.
He is another one.
So it's simply an advisory council.
So excuse me, now I'm confused.
Yeah.
The problem is with the name.
Yes.
Yeah.
That's with the name.
Please.
Yeah, I think it is called council, not really a council, because we also have a mainland affairs
他的麦克风
council.
坏掉了吗？
Right.
哦，有了。
Sorry. So the council, that word is used by the government for a ministry that is smaller and sometimes less important than other governmental departments. For example, we have a mainland affairs council, and that is really a governmental agency, but its status is somewhat lower than other ministries. So that is why it is called a council, but actually it's just like an ordinary governmental agency.
Okay.
我这边想要补充一。
I also want to add something. So the creation of Council of Indigenous People was from the fact that some advocates, indigenous advocates in the past, urged a call to the government saying that there should be an indigenous agency in the government so that they can bring indigenous voices into the government. However, the title of the organization is Council of Indigenous Peoples, but it is just simply just like any other government agency, and the head of CIP is assigned by the premier. And in formality, there are 16 representatives from the 16 recognized indigenous peoples. However, these 16 representatives are assigned by the minister of the CIP, while the minister himself is assigned by the premier. So these 16 representatives should be advisors or consultants. However, their relationship with the minister are like the relationship between supervisor and the employees. So these 16 people's roles usually helping the government to promote government agencies in different indigenous communities.
I think we have to come somehow to a closure of the indigenous peoples. Do you have any further question or? I mean, my main really request to you would be that you sit together and coming up with 3, 4, 5 very specific recommendations. What needs to be done, in your opinion, that the government complies with its obligations towards indigenous peoples? Yeah. Both in terms of registration, in terms of classification, in terms of the CIP, in terms of developing projects, in terms of compensation for the injustice done in the past. So all those, but as specific as possible. Yeah. If we could have that until tomorrow, it would be great. Yeah, is anything finally you would like to say from the indigenous communities? Because then we go on to the non-discrimination issues. Please.
Okay, so we want to stress one last point, because in the past 2 days we talk about FPIC a lot. Today and yesterday, it seems that the discussions limit FPIC to the scope of Article 21 on land, resource use, ecology, and academic research. It seems that FPIC only applies to this scope. However, all the policies that are involved indigenous people, that impact indigenous people, should apply FPIC. So it includes, but not limited to, climate change, national human rights action plans, preventive measures against pandemic, health benefits, any policies that may impact indigenous people should apply FPIC, FPIC in the planning stage. So government talk about consultation or obtaining consensus, but this is different from FPIC. I think we're going to submit written recommendations to all of you. What I want to stress is that FPIC should apply beyond development. It should be applied to any policies or measures that may impact the indigenous peoples.
Thank you, very clear. Mm-hmm. All right, thank you so much, but please stay. Now we come to the question of equality, non-discrimination, and all related issue to violence against women, domestic violence, sexual harassment, etc. So gender issues. Shanti, would you like first to ask a question, or shall we first get the comments from civil society?
This morning we discussed with the government about the gender equality law and the anti-discrimination law, and the fact that it is now included in the human rights plan, and they say there is now, the plan is finalized. And based on the human rights plan, the law will now be drafted and then be submitted to the legislature for adoption. What we've been talking about this need for a comprehensive anti-discrimination law and an equality law, gender equality law, since 2013. What is your view about this delay? Is it justified? And is the government really serious about finally legislating on equality and non-discrimination? That was what was mainly the key part of our discussion this morning. So whether you have, and then they say also that equality initiatives or regulations are integrated into various other ministries' work. And therefore, there is protection for women and children, even if there is no law as yet. Now, is that accurate? Is that women and children are protected because various ministries are taking care of them? This is something else that that I'd like you to comment on to begin with, then we'll see more.
Okay.
1, 2, 3.
Okay.
Okay, more.
Okay, can I start?
Yes, please.
Yeah, I'm on behalf of Kaohsiung Parenting Association.
Okay.
Currently, the relating policy of Taiwan Gender Equity Education Act, they still mostly consider about the benefit of this group, like homosexuality, sexuality orientation, and transgender identification. You know, they mostly promote homosexual education, teach children about homosexual behavior like male sexual act and sexual liberation. Therefore, it not only causes the unfair distribution of educational resources toward children from different religious groups or different social background. You know, because some religions has their own belief in traditional family and moral convictions. And it also violates parents' liberty to choose education,
I know. Sorry if I may. We have heard that statement and we have taken it up, but this was not the question that we were just raising. We were really talking about a very specific issue that we were discussing in the morning.
Yeah.
So I know your concerns, and also we have noted them down, but it is about the equity education.
Yeah, I just want to say we need to have a religious exemption. So all this should be listed into current Taiwan Gender Equity Education Act. We need to have a right to promote one man, one woman marriage. Yes, because currently,
but we are not discussing
they don't allow
now.
us to do this.
Under the right of same-sex marriage, etc., and education. So let's really try to focus on what we discussed in the morning with the government and all those issues related to gender equality.
Okay.
I think you were the next one, yes. Please. Please.
我吗？好，我是台湾全国妈妈互相。
Me? Hello, I'm from Taiwan Mothers Shield Alliance. I think Gender Equality Education Act, it's very difficult to be promoted in Taiwan because there is a big problem on the definition of sex or gender. Well, please look at this. In the Chinese, 性别 may mean sex or gender, but when Department of Gender Equality explain themselves, they use 性 to translate sex. But on our ID card, the term is 性别. So I think many terms are not clearly defined, and that causes confusion. So I insist on the practice that we need to translate sex into biological sex, and we need to translate gender into social gender or social sex. Because if you translate sex into 性, it may be confused with sexuality or being sexy. It's very confusing. That's my first point. Second, on equality, we need to respect and value the rights of different groups. However, we cannot ignore women's rights at the same time. For example, for a gender-friendly washroom or bathroom, I think a space for women is infringed upon, and women or girls may feel scared in this kind of bathroom. So I think there is some challenge in promoting Gender Education Equality Act.
Thank you. Please.
Thank you, Chair. So I am Xie Meng Zhao from Alliance to Promote Civil Partnership Rights. In response to your question about the comprehensive anti-discrimination law, I think there is a shortage of political will. The government told us we have other regulations to protect the rights of different groups. I don't think that is correct entirely. For example, government in response said that we will not accept referendum proposals that involve unconstitutional recommendations. However, in 2018, we know that there's a referendum proposal asking to exclude same-sex marriage from the civil code. This is in violation of the protection provided by the Constitution to same-sex marriage per Judicial Yuan Interpretation number 748. So the government still accepted that referendum proposal, and the referendum was organized. As a result, there is a chilling effect when we advocate for gender equality education in relation to same-sex marriage rights. So we believe that once the referendum is passed, the government agency will have to enact new laws, amend existing laws, or abolish existing laws based on the outcome within 2 years. So there's a lot of hate speech targeting same-sex couples. However, there are no laws to prohibit such discrimination. That's why we need a comprehensive legislation. Right now, we have Gender Equality Education Act, Gender Equality in Employment Act, but we know that in our daily life, if you want to apply for a job, if you want to rent an apartment, you may face discrimination on the ground of your gender or sexual orientation. For example, as a member of the LGBT group, you might be denied the chance to rent an apartment or even engage in some business commercial transactions. So this is our response. We hope in your COR you can specify referendum proposals that are not constitutional must be prohibited, and there should be a comprehensive legislation to protect equality for all.
Please.
I'm sorry, I speak for Research Center for Department of Financial and Economic Law, National Zhongzhen University. So, good morning. I'm Samantha. We recommend that government must complete the legislation of anti-discrimination law so that there will be effective remedies for all groups. We know that gender equality is an important issue, but we also have to pay attention to taxation laws. There is still a lot of room for improvement in this regard. For example, the tax authorities in Taiwan would use taxation power to target certain groups. For example, in the case of Taiji Men is a spiritual organization promoting martial art exercise, and other similar organizations are not taxed, but the taxation authority in Taiwan specifically targeted Taiji Men to ask for tax payment, and this case has been going on for over 20 years. And there are many laws in the Taxation Act which may be discriminatory. For example, if there's an erroneous taxation statement, the mistake is on the part of the government, the people do not only have 15 years to ask for the return of the excess tax they had paid. So that is an example how people's right to fair taxation is not protected. In addition, according to the Taxation Act, once the local court has verified a tax statement, then people do not stand a chance to appeal against that court. In fact, whenever people fight against the government in such cases in the court, people lose in 99% of the time. So the government is basically harassing people through their taxation power. Such abusive taxation power is very harmful to the human rights of specific groups. Taijimen case is a prime example. So we believe per Article 2, Article 18, and Article 22, the government should pay back the wrongly collected tax.
Perhaps have the two still,
Yeah.
and then we come with specific questions, and we would be happy if you respond to the specific questions that we are raising.
So yes, my name is Song Li Huang, and I am with the Covenants Watch. So after the review in 2017, the government, actually the Ministry of Justice, commissioned a research on the anti-discrimination law. So there is now this report from that research project, but nothing else. I mean, there hasn't been any effort to try to harmonize or coordinate among different ministries about their actions towards the elimination of discrimination. And actually, before the legislation is completed, there are a lot of things that the government can start to do. For example, in the general comments of the two covenants, the CRPD and the CEDAW, they all have very clear definition of discrimination. But up to now, either the government officials or the judges, they lack a full understanding of the definition of discrimination. So in a lot of disputes, for example, in the employment discrimination, there is at the local government level a committee to review the discriminations associated with employment. But that committee, they often can only detect direct discrimination. So if governments or employers did not take positive measures to correct the disadvantage, then it is often not recognized as discrimination. And furthermore, the judges often confuse positive measures and affirmative actions. So including the duty to provide reasonable accommodation is often seen by judges as a measure of affirmative action. And therefore, they take an unnecessary harsh standard to review the request for positive measures, and therefore deny the persons who are discriminated any legal remedy. So that is a lot of things. I mean, there are a lot of things that the government can do before the legislation is done, which may take at least 4 or 5 years. Thank you.
Thank you very much. I think you were.
Good morning. So I will speak on behalf of the Taiwan 同志 Hotline Association. My heart is racing so fast right now as a gay person. Whenever I attend such international review meetings, my heart raced so fast because I kept hearing a lot of discriminatory remarks against the gay population. Well, in response to your question, has the government taken action to protect women's rights. For example, how about transgender women? How about their rights? Right now, government still classify people as men and women, and you have to indicate your biological sex on your ID card. As a result, transgender women are discriminated against on many occasions.
Perhaps the last one, I think you were, and then we really go back to the questions. Yes, please.
OK， 我是针对
I will speak about discrimination against indigenous peoples. I think in government's replies, the government failed to specify discrimination faced by indigenous people. They did not conduct research. They had no idea what's going on in terms of discrimination against indigenous people because there has been no research in this regard. But my association has conducted studies. It seems that many indigenous youth and children are discriminated against on campus, in middle school. In indigenous communities, there are no local schools, middle schools. So indigenous people, young people have to leave their hometown to study in schools in other places. Whenever they face discrimination on campus, teachers, principals look at them with discriminatory bias. So there's no way for these indigenous students to seek remedy. Middle school students with indigenous backgrounds have a higher dropout rate compared to other groups.
Because you asked a really long time for the floor.
I have a serious problem that I have to declare. There are discrimination who hold different opinions. Gender Equality Education Act can become a tool to suppress those who disagree with certain opinions. University professors were investigated again and again, and it turned out there were no victims of discrimination, bullying, or harassment. But some members of the Gender Equality Education Committee continue to reopen the investigation. It creates a chilling effects in the academic society and a serious effects affects the freedom of speech and expression. The implementation of a gender equity education law lacks health awareness and medical knowledge. For example, disorder of sex development, so-called intersex, and transgender people are completely different groups. Gender dysphoria and transgenders, they have subjective feelings that drive their gender. But for disorder of sex development people, there are objective disorders. So some of them need special medical professional help. Confusing. It is a very specialized field and contains more than a dozen different diagnoses, need different approaching. So a confusing DSD with gender dysphoria transgender will sacrifice individuals' health and development. I think it's too much ideology-oriented. And also parents was discriminated against. If they hold different opinion, they were considered ignorant. So my suggestion is we have to clearly define what is discrimination, and what is equity and equality, and gender and sex, and through an open public hearing, not a closed-door meeting. And the members of the Gender Equity Education Committee should have diverse viewpoints. Members with discriminatory speech should be dismissed from their position. Thank you.
Thank you. Do you want to first, or shall I first give to Shanti? Yeah. So
no, I wanted to move away from the equality legislation a little bit and to ask about one of the recommendations we had made in the previous review was about domestic violence, that there should be a national action plan. Now, the responses this morning was that clearly there is no national action plan. I didn't get that. But I think the minister, was it the Justice Yuan who was sitting here in front of us, said that every 4 years, all government departments or ministries have to produce a report on actions that they have taken to remedy and give redress for domestic violence, actions they've taken to address domestic violence. And from that report, which is public, can be identified gaps in implementation and issues that are being left out, and that can be remedied. Now, my question to you is, what is your opinion about this 4-yearly report? Is it really produced with enough detail, and is it a public document? And is that used to improve the initiatives to address domestic violence? Is this real? Is this a reality? Can those of you who perhaps are familiar with what is happening in the area of the violence against women give an answer to this? It's that.
Thank you. Who would like to address this point, or who has knowledge about it?
I don't think so. Are you aware that there is such a report? There is a report. Every 4 years a report comes out. Is it a public document? Anybody can access it? Yes?
Yeah?
It is a public document. Among the NGOs then, is there any group that works on violence against women that looks at that document? Is there anybody among you who's, yeah, there's somebody with a hand up.
Well, I am not sure which report this is, but I do know that there is a CEDAW review meeting every 4 years. So the government does provide some reports on women issues. I think when government do this, they give us data.
I think that's a different report.
Specifically on violence, yes. Domestic violence, there is every 4-year report.
Yeah.
CEDAW reports are different. Yeah. CEDAW addresses all the areas, 16 articles of CEDAW.
Okay, please, yeah?
Yes.
And then
on the internet, it is available on there. A 4-year report on the prevention on domestic violence. Yes. So it is available, but I have no further information on that.
Yeah. Okay. Thank you. Bill, please.
I want to return to the issue of the legislation and the issue that was raised about reasonable accommodation, positive measures, and affirmative action. I didn't entirely understand the point, and I'm wondering if you can just talk me through that again.
Yes.
And also what the remedy is. What's the answer to dealing with judges who don't understand legal distinctions?
Yes. Well, the problem is that in order to prevent or eliminate indirect discrimination, often the government is required to provide positive measures, including reasonable accommodation. But for some judges, there is no distinction between any kind of positive measure, including reasonable accommodation, and that of affirmative action. Because in theory, affirmative action is a reverse discrimination, and the judges would need to take a higher level of scrutiny. And therefore, if they confuse these two, they would deny any kind of provision of positive measures because they think it is affirmative action. Okay, so the remedy that I would recommend is for the government to compile the available general comments on discrimination, including those from CRPD, CEDAW, and the two covenants, and make into it a clear guideline of what discrimination is, including the different forms of discrimination, and the definition of positive measures, this definition of affirmative actions, and then provide it to both the administrative part and the judicial part. Thank you.
There's a general comment of the Committee on the Elimination of Racial Discrimination as well.
Yes.
On the subject. Yeah.
Yes.
Thank you. I'm aware of the time, but if the interpreters allow us, we can still go a little bit over time. Do you have still specific questions that you would like to have responded to by the NGOs? Because otherwise I have still 2 requests for the floor. Yes, please.
Sorry, I'm Yilin Chu from Amnesty International Taiwan, and I have an issue about the Article 26 of ICCPR, which didn't discuss in the morning section. It's about the transnational same-sex marriage. Currently, there are hundreds of families of transnational same-sex marriage couples who does not recognized as legal. Although the administrative court. Oh. Sorry. 还是我说中文会比较好。
Or maybe I should speak in Chinese.
继续讲英文吗？ Although the administrative court has ruled 3 cases of transnational same-sex marriage are legal, but those decisions cannot be applied to other cases, and other couples still have to rely on other visas to enter Taiwan, or some of them already forced to separate for more than 2 years due to the COVID-19 pandemic. Such as they are using like a study visa or employment or tourist visa. So sometimes they will face repatriation at any time when the visa expired. And even a case about the Ukraine same-sex couple who are forced to return back to Ukraine because they cannot legally registered. So we recommend the government to allow the transnational same-sex marriage to be legal and to enjoy the same rights as soon as possible, and to protect their rights to family reunion. And at the same time, before the law is revised, reasonable assistance should be provided to the cases which are already in Taiwan. Thank you.
Thank you very much. Please.
Hi,
I'm from Taiwan Parents Protect Women and Children Association. So my point on equality law is that, well, in many other countries, their equality law are anti-discrimination laws, but it seems that those laws force people to do something. So sex minorities start to bully others who have different ideas. I think that limits freedom of speech and hurts the harmony in the society. So I think such a piece of law has to be defined very carefully.
Turn to the comment by the person from Amnesty International. What is the government's rationalization for the distinction between same-sex marriages that have a transnational dimension and those that don't? How do they explain it?
I would like to ask the other lawyer to respond to that.
政府机关对于跨国同婚的
The government discriminated against transnational same-sex marriage, because they say both of the countries' laws have to be followed. For example, if the couples are from Taiwan and German, is their marriage legit? It means that the marriage has to be recognized by both countries, and Taiwan has already legalized same-sex marriage. However, among other countries around the world, well, most of them do not have not yet legalized same-sex marriage, especially in Eastern Asia, where Taiwan is the only one. So currently, Taiwanese people can only marry other Taiwanese people or marry other foreigners who are from the countries that recognize same-sex marriage. If a partner is from Japan, Japan doesn't allow same-sex marriage, and the marriage between a Taiwanese and the Japanese cannot be registered in Taiwan. This clearly causes inequalities in freedom of marriage and sexual orientation inequalities. As of now, in Taiwan Alliance to Promote Civil Partnership Rights, we have represented several transnational same-sex marriage couples in courts, and we won because if we use other countries' laws to limit the people's rights in Taiwan to marriage, then it's against public good. And the Legislative Yuan is devising an amendment to the law in Taiwan, but that amendment has not been fully reviewed right now. Did I answer your question?
I mean, you explained how the law works. I get that, but what I don't understand is why. Why does Taiwan care what the law is in another country?
Thank you for your follow-up question. This is also something we've been wondering. We think other countries' laws should not be the cause to limit the right to same-sex marriage in Taiwan. However, the Taiwanese government says that they're amending the law, but the amendment is still at the executive branch. It has not been sent to the legislative yuan yet. And the amendment process is so long and so delayed. So we recommend to the executive branch that there should be some transitional procedures during this time. For example, to lift the limitation on the residency of foreigners, or to give the identity or status to a child who was given birth to by a foreign spouse. There is a law. There is this
act to be their excuse and say if the other country is not legalized same-sex marriage, then the transnational same-sex couple cannot register in Taiwan.
But I mean that.
I don't understand why.
Yeah.
That's why people go to certain countries, so they can get married. The people from Israel go to Cyprus because they can get married there. People from, that's why they do it. So, yeah, I just don't understand why they would have such legislation.
But I also understood you first saying the COVID-19 pandemic is restricting that same-sex couples are actually coming together because of restrictive visa issues. But are you saying that that only applies to same-sex couples and not to others? Is there a clear discrimination on the basis of sexual orientation?
It's applied to the heterosexual couples if they are not registered as a legal marriage, then you cannot, yeah. You cannot use like a family or visiting visa to
I
enter.
mean, same-sex marriages are registered. So they should be on the same level than heterosexual marriages. Yeah. Am I correct or not? Yes, please.
好，应该是说
Let me put it this way. If the transnational couples have formally registered, then they can have the same rights, same-sex or heterosexual. But in some countries, if you want to have your marriage registered, there should be an interview with the government official first. So under the pandemic, without such an interview, there's no way you can get your marriage and spouse registered, and then your spouse cannot enter Taiwan. If you do not enter Taiwan, there's no way you can complete the registration process. So what we're trying to say is the border control under the pandemic has prevented couples who may have been living together, their marriage right is not guaranteed or protected.
All right, thank you very much. Any other questions from the review committee? Okay, because we are over time already, so is it really directly to the issues that we just discussed? Then I take those 4 requests for the floor, but please try to be short. Yes, please.
30 seconds each.
Please.
Other groups mentioned that a lot of discrimination resides in the lack of awareness among judges. Yes, that is an issue. And once a judgment is made in civil court or criminal court, there is a limit on the time during which you can apply for a retrial, but the executive or the administrative branch would say the judgment has been made. You have exceeded the allowed time to apply for a retrial, so you cannot apply for a retrial. So if a wrong or a discriminatory judgment has been made, then the government should correct itself. Right now in Taiwan, the threshold for retrial is very high, and there is a limited time period, 5 years that is. So once the 5 years are gone, there's no way you can seek remedy by applying for a retrial. So I think the executive branch should correct the mistakes it has made so as to be in line with the spirit of the 2 covenants.
谢谢委员。
Thank you. I am Shi Xiang, representing the Taiwan Association for Human Rights. This morning, you talk about the expansion of power on the CECC. I would like to compliment the work done by the Command Center for Safeguarding People's Health and Life. But this morning, we also heard that according to Article 7 of the Pneumonia Special Act, the power may be abused by the command center. So we want to point out that the government has been abusing the Article 7 of the Pneumonia Special Act to limit certain groups of people's right of travel, and their names have been revealed to the public. For example, some people living in a specific district in Taipei have been under pressure to reveal their whereabouts, and some of their names have been made public. In addition, local governments have also issued the restrictions on migrant workers' freedom of travel. The Ministry of the Interior, the Ministry of Justice have failed to review those measures. The proportionality principle is not honored. The human rights protection principles are not honored. As a result, under the pandemic, we see a lot of measures which are on the brink of violating human rights. So we hope in your COR you can ask Taiwan government to make sure the regulatory requirements are met so as to ensure human rights. So I would like to talk about indigenous people's rights and gender equality and the principle of non-discrimination. But I think in Taiwan there's a very serious violation of human rights. That is the financial law system, financial legal system is very problematic. We are all taxpayers. Our property at any time may be expropriated by government, by their abusive taxation power. We have moved beyond authoritarian regime as a democracy, but the Ministry of Justice, the taxation authority, officials at these agencies have very weak awareness of law and order, so they use their power to tax, to discriminate against certain groups of people. So that is a violation of the equality principle. In Taiwan, tax victims are numerous. There are actually 14 million such tax victims. You can see there is a very high proportion of Taiwanese people exposed to such tax victimization. Taijimen case is a very good example, but I'm not going to focus on Taijimen case solely because with one case unsolved pending, it shows that there are structural factors contributing to the government's violation of human rights. So we hope, we appeal to the reviewers that this issue should be included in your concluding observations, especially in relation to transitional justice. We hope that the issue of transitional justice is not limited to cases that occurred between 1945 and 1995. In fact, any cases that happened outside that period have difficulty seeking remedy. We hope you can include this in your observations. So the land belonging to Taijimen should be returned. The reputation should be cleared, reinstated.
Yes.
Please, yes.
Thank you. Thank you. I'm presenting today on behalf of ROC, Association of HIV, AIDS, and Childcare. I'm talking about protect the health and human rights of children in COVID vaccination. We government began to vaccinate 6 to 11 years old children in these days. So National Alliance on Parents Organization collect opinion of this issue in response to the COVID-19 outbreak recently. 2,035 completed surveys were received preliminarily. The data show 1/3 of parents agree, however, 2/3 of parents didn't agree to vaccinate 6 to 11 years old children. Parents' questions were that they could only get the information that vaccination is the most effective way to prevent COVID-19 from the media and the government. They couldn't get the full information and adverse effect of the vaccines, which were already known in other countries and internationally, such as waning immune human response to BNT vaccine over 6 months. Therefore, the protection of the vaccines for the children is limited. Second, extracellular RNA is known to play a role in cell-to-cell communication. We don't know if mRNA vaccine will disturb the balance of extracellular RNA in our bodies, especially in the bodies of minors. Third, seizure, syncope, myocarditis, and pericarditis were reported in children with vaccination. Fourth, the government didn't tell us that Switzerland and Sweden have decided not to vaccinate all 5 to 11 years old children. We parents urge the government and the media to give us whole picture and transparent information of the COVID vaccine, not only its benefit, but also its adverse effects. We need to know this to protect the health and human rights of children. In addition to vaccination, about 40% parents didn't agree rolling plan of school closures. They prefer online classes, distance learning rather than in-class learning. Should education department take for further consideration based on protecting the health and human rights of children? Thank you.
Thank you very much. That concludes our session, and I thank you very much for all your information. There were certain issues that are not really relating here because we have also other meetings that go on children's rights, etc. But I was. But is it really in relation to what we are discussing now? Or is it freedom of religion that is at a different time? Is it relating to the questions that we raised now? Then very quickly, please.
I come from the Buddhist Association of the Republic of China. This morning, we listened to government's response, including gender equality, tax equality. It's all part of human rights protection. From a religious perspective, we hope that the committee, in your observations, can recommend to Taiwan government that the protection of all human rights must be included in a basic law. We have several basic laws in place, but some of them have become obsolete. They need to be amended. Take Taiwan's religious human rights, for example. There's no basic law for religious human rights. 90% of people in Taiwan are religious. However, we don't have a basic law to protect people's right to religious freedom. That is an issue. So I speak not only on behalf of the religious community. I hope all quarters of society can call on government to devise very comprehensive basic law to ensure the protection of people's human rights, politically, religiously, so that government policies can be in line with the existing laws. Thank you.
Statement on Article 18, which is not on the agenda now, but I took note of it. Thank you so much, and we are continuing at 2 o'clock with the next cluster, first with the government, and I can encourage civil society representatives to be in the room so that we afterwards can have a similar discussion, but about the issues that we are discussing with the government. This will be Article 6 to 11 of the Covenant on Civil and Political Rights. Thank you very much.
Thank you.
Enjoy your lunch.
谢谢各位的与会。那本场次会议备有餐点，请至1010用餐区领取。下午的会议为公正公约第3场次，与政府机关之审查会议于2点开始，与非政府组织之审查会议于5点20分开始。 请将出席政府机关人员准时与会。有关洗手间的使用部分，因10楼南侧为国际审查委员专属厕所，请勿使用。有使用需求者，请改。
我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制， 并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。 台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。 9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权 是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾 是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。
机关之审查会议即将于3分钟之后开始，请各位长官尽速就座，并将您的手机转成静音，谢谢。 两公约第3次国家报告国际审查会议，公正公约第3场次，审查范围为公正公约第6条至第11条及结论第52点至第56点、第58点至第67点。请各位发言人在发言的时候先举手。
Ladies and gentlemen, we'll come back and housekeeping matters to the audience. When you speak, please raise your hand first. Tell us your name and affiliation. When you speak, please speak at a reasonable pace. Thank you very much. Chairman, please, you have the floor.
Yeah, thank you very much, and I'm happy to see you back during this afternoon session, which will deal with Articles 6 to 11 and the corresponding, also concluding observations and replies of the government to the concluding observations. Again, we will deal with different issues, so kind of mini clusters. The first one will be the death penalty, and that is referring to Article 6 and 7. Then we will deal with other issues relating to torture, cruel, inhuman, or degrading treatment or punishment, including also conditions of detention, and of course Article 9, deprivation of liberty, so the right to personal liberty, and at the end Article 11. So I would like first to give the floor to William Shevers to start with specific questions regarding the practice of the death penalty in Taiwan. Thank you.
Thank you, Chairman. Thank you, Professor Novak. So we now take up what is, of course, one of the burning issues, if I may speak that way, which is the issue of capital punishment. It takes the primary place within Article 6 of the International Covenant on Civil and Political Rights, and this is a way in which international law has signaled the importance of this issue. And as I'm sure you're aware, it also is addressed in the second optional protocol to the International Covenant on Civil and Political Rights, which at some point in the near future we will expect Taiwan to incorporate in its domestic law in the same way that it has incorporated the International Covenant on Civil and Political Rights. The issue has been addressed, of course, in the previous reports and in the concluding observations. I note that when the first review of this type took place, I believe 9 years ago in 2013, there had been, at the time, there had been 21 executions over the previous 5 years. And when the second review took place in 2017, there had been 18 executions in the previous 5 years. So now we're in the third such review, 2022, and there have been only 2 executions in the past 5 years. if we look at it in terms of the quinquennium that begins with 2015 to 2019, which is the 5 years preceding the publication of the report, there had only been 4 death sentences and 8 executions, and that compared with 31 death sentences and 26 executions over the previous period. So this is a very, very dramatic decline. As a percentage, over the past 5 years, compared with the previous 5 years, it's a decline of 89%. From the period 2013 to 2017, when there was an execution about every 3 months and 1 week on average, you've gone in the period of the last 5 years to an execution not every 3 months, but more like every 30 months. And if you do a little calculation, if that trend is to continue, we would expect the next execution in Taiwan to take place sometime between now and the year 2044. Do the math. This is the trend. It's very clear. The third report speaks of a strategy of gradual reduction and gradual elimination of the death penalty. I don't consider this to be gradual. I don't think gradual is the right word. This is a dramatic change in the practice of the country. So the question I would like to ask the government is whether what we can conclude from this dramatic development, because there is it's been expressed before, that the intention is to direct the policy towards abolition of the death penalty, that this is dependent on evolution in attitudes. So can we say that these changes in the practice are reflective of the attitudes? What does that tell us about the changing attitudes, and whether we can now say that Taiwan is in a position to formalize the reality of the practice, the likelihood that there'll be one execution in the next 15 or 20 years if the current trend continues. There may never be another execution in Taiwan at that rate. But is it now, can we say that we have enough evidence of changes in public attitudes that the time is now to take that step? In the reply to the second list of issues at page 12, I'm sorry, in the reply it says, first of all, that there's a conclusion that there's a need to commission scholars to conduct research on alternatives to the death penalty. And I ask myself, if the death penalty has declined so much to 2 executions in a 5-year period, it's too late for that. Why are you doing this? Why is this the policy to be followed? What are the alternatives? You must have the alternatives already, because you're barely using the death penalty. So this seems like, to me, an inadequate response and a reaction that we have in the replies to the second list of issues. I also want to make an observation about a comment that appears on page 12 of the second list of issues that raises an idea that I've heard often, not just here in Taiwan, but in other countries that are contemplating abolition, this idea that it took Europe a long time to abolish the death penalty, and that it was a gradual process, and that we're moving at the same pace as they did in Europe. It says in the reply to the second list of issues, it speaks of, and I quote, the long-term effort it took in European countries, such as the UK, France, Switzerland, and Italy. I don't think this is accurate. I think this is wrong. I mean, I would change it if you ever revise that paragraph. In the United Kingdom, there was an official study, a prestigious, what's called a Royal Commission on the Death Penalty, in 1953, that called for the retention of the death penalty. And the United Kingdom continued to execute people through the 1950s and into the 1960s. They held an execution in 1964. And then, quite abruptly, the Parliament declared a moratorium for 4 years on the death penalty. And then 4 years later, it formally repealed the death penalty from the laws of the United Kingdom. This was not a gradual change. This was quite a sudden change in policy from a very, very clear commitment to the death penalty in the 1950s to full-blown abolition within a decade. The same is true of France. France continued to execute people through the 1970s. The last executions in France, there were 3 of them, took place in 1978. There was an election in 1981, and the Minister of Justice, who was appointed in the new government, Robert Badinter, had campaigned and called for the abolition of the death penalty. They adopted the legislation immediately. So they went from a real commitment to the death penalty to legal abolition. They didn't even go through a period of a moratorium. In Italy, there were widespread executions in the first half of the 20th century. And this accelerated under the fascist government of Mussolini during the Second World War, and immediately after the Second World War ended, they abolished the death penalty. And there's a reference to Switzerland as well, which abolished the death penalty at the time of the Second World War. So I would be careful in suggesting, with reference to the European countries, that this is a long, gradual process. I don't believe that's the case. I don't think the evidence shows that. And actually, it happens quite quickly, and generally as a result of a determination by the government to move forward the policy, to develop a more progressive policy, confident that the public will, over time, come to accept this. We already discussed yesterday this notion of consensus and building a consensus on the death penalty and how that would take place. But we can see that there are some things that change quickly. It was suggested that it would take a consensus for same-sex marriage. But this was changed quickly, and it's not universally accepted. I think we had some NGOs who spoke to us today or yesterday who are still not happy about same-sex marriage. But it's the right thing to do, and society accepts it, and it accepts it quickly. So these are some ideas about the death penalty and the direction of travel, and questioning whether this is now the point that was anticipated 9 years ago when the first such review took place, that Taiwan should move towards the death penalty. And that was repeated 4 years later. But it's moved. This is the point. The movement has taken place. And so I will ask you the question at this point, can we draw that conclusion? What conclusion can be drawn from the fact that the death penalty has almost disappeared in Taiwan already? And that there's this, and that it's a trend that's measurable, quantifiable, pointing in only one direction, and suggesting that if there have been 2 executions in the last 5 years, there will be even fewer over the next 5 years. And I would think it's quite likely that there'll be none. But of course, this will depend on decisions taken by the government. So those are my initial thoughts on the general question of the right to life and the death penalty. You will be aware that you'll be joining more than 100 countries now that have abolished the death penalty in law, and another 50 or so countries that have stopped using it either through an official or an unofficial moratorium. There are fewer than 30 countries in the world today that still use the death penalty. And that too is part of a great trend, and one that we see even in countries that have had a long attachment to the death penalty. The famous example that we all know about is the United States of America, where the numbers of executions have declined now to about 10 every year for the whole country. And of course, this is a country that is more than, 15 times the size of Taiwan. And that trend is very demonstrable there as well. And they may be a little bit further away because the country is more complicated and it has many jurisdictions, and there are still a few of them, a few states that retain the death penalty, although most of them have stopped using it or have fully abolished it in law as well. So I have some more specific points on the death penalty, but I'm going to stop with that comment and would appreciate some reaction from the government on the subject.
Okay. 好，谢谢。
Thank you. So I am the director of the Department of Legal System from the MOJ. First of all, I thank you for your recognition of Taiwan's efforts to reduce the number of executions. In other words, we aim at gradual reduction of execution. And this morning, we shared with you the National Human Rights Action Plan. One of the major issues has to do with strengthening the protection of the right to life. Under that section, we also spell out our future plans to strengthen protection of this right. On death penalty, I would like to ask the MOJ representative to answer. Good afternoon. I am the head of the Department of Prosecutor's Office under the MOJ. Thank you very much for your comments on Taiwan's work in this area. Before 2013, between 2013 to 2017, and after 2017 till today, we have reduced the number of executions. This trend tells us that Taiwan continuously moves to abolish death penalty, which is our policy objective. And in practice, we have taken action to move toward that goal. We know it's an international trend to abolish the death penalty, but to stop the execution of the death penalty or to abolish it involves a lot of issues. It can hardly be done overnight. And you just shared with us the examples in France and the UK. There are different customs, cultures in different jurisdictions, and people's will, consensus may evolve over time. That results in different timetable for different countries to abolish the death penalty. Generally speaking, based on Taiwan's nationwide survey conducted by the Criminology Center under the National Zhongzhou University, this is an annual survey. According to the survey results, in 2004, people in Taiwan opposed to the abolishing of death penalty stood at 83%. But during the past 3 years, in 2020, 2021 and 2019, the number of respondents in opposition to the abolition of death penalty is about 76 to 77%. So we do see a decline in the number of people opposed to the abolition of the death penalty. However, the general trend is very clear. Most people are opposed to the abolition of the capital punishment. Yet, in spite of such survey findings, the government is working toward the goal of abolishing the death penalty. That is why, at this stage, we aim at prudent execution and reduction of execution. In this area, we have successfully reduced the number of executions in recent years. We have seen preliminary results. As for the future, we have set up a research and promotion team for the progressive abolition of the capital punishment. This team is set up under the MOJ. The team seeks to negotiate and communicate with members from the public and private sectors so that we can forge consensus. Starting 2017, the team became operational. There has been 8 meetings convened by the research and promotion team. For example, in March 2020, we invited Professor Xin, an expert on German criminal law. He shared with us the alternatives to death penalty in Germany. And last year, in May, we also targeted the criminal procedure law, and we invited the leader of the Psychiatric Society Taiwan to share with us how to determine the legal capacity of inmates. In addition, under the National Human Rights Action Plan, starting this year until 2024, we have formulated 3 important plans which will help us to move closer to the goal of full abolition of the capital punishment. First of all, we would like to encourage prosecutors to be more prudent, and prosecutors must refer to Article 6, the right to life, and General Comment number 36 of the ICCPR, the requirements, the elements involving in the restrictions on the use of the death penalty. And of course, at the same time, we would like to avoid unnecessary, inadequate execution. In addition, we value public opinion. That is why we are going to conduct a large-scale public opinion poll. We're going to ask Taiwanese people aged over 18 to see how they see death penalty. This aims to help us to stay abreast of the latest trends and thoughts among our people. The third plan is about developing alternatives to the death penalty. We need to provide good alternatives so as to persuade people to change their attitude toward death penalty. Based on past survey results, if people are provided with reasonable and adequate alternatives to the death penalty, people tend to be more inclined to agree to the proposal to abolish the death penalty. Therefore, we believe the 3 plans proposed under the National Human Rights Action Plan will help to guide our action in the future as we move toward the goal of abolishing the death penalty. That's my reply. Thank you.
Thank you very much for those comments. And I'm in total agreement that it's important in terms of reassuring the public at the time moves are being taken towards abolition of the death penalty, that there are genuine alternatives. You spoke about public opinion surveys. I'm familiar with some of the ones that have been done. There are 2 that have been prepared by scholars here in Taiwan with the cooperation of 2 professors from Oxford University in the last few years. One of them deals with public opinion polls and confirms something that we see in public opinion polls in other countries, that when the public are asked a question, when people are asked a simple question, are you in favor of the death penalty or not, that they may be inclined, and this is true in many countries that abolished the death penalty a long time ago, to think that in principle it's a good idea to keep it. But that when you present them with real circumstances, real situations involving a crime, and involving the possibility of alternatives, the obvious one being long-term incarceration, they're really, it doesn't take much imagination to come up with the alternatives to the death penalty. The alternative is long-term incarceration, possibly what we call life without parole. When that option is presented, and we see this, I've seen this in public opinion surveys in the United States, I've seen it in the People's Republic of China, in other countries, and the number, the percentage of support for the death penalty drops dramatically, usually to under 50% in support of it. So it's important in doing the public opinion surveys that those options already be presented to the public in terms of assessing their views. It's a subject upon which everybody has an opinion. It's like asking people about the weather. We all have an opinion about the weather, not that we can do much about it. But when it comes to the death penalty, if people are asked if they have an opinion, they will express it. But when they're confronted with the reality of it, they tend to favor life over death. I think the other thing that the opinion polls tend to show is that this is not a subject that is of great importance to people, actually. And that they're far more concerned with an issue like, would you like your taxes to be reduced? Or something that has a practical consequence for them. So that people often have opinions about subjects that are actually not very important to them. And I would hope this would be taken into account as well. I have a couple of specific questions about the death penalty that arise from the independent opinion that was prepared by the National Commission. And this, if you have this to hand, this is on pages 10 and 11 of the report of the opinion, paragraph 16 and 17. Paragraph 16 refers to the general comment number 36, and I'm very pleased to see that it's being referred to, because this is really now the authoritative statement, not just on the death penalty, but on the other issues concerning the right to life. And it says that the death penalty should not be imposed on individuals whose disabilities, psychosocial and intellectual disabilities, impede their capacity to make an effective defense or diminish their ability to understand the reasons for their sentence. This is a complicated subject, but it makes a recommendation. It says the Ministry of Justice should properly and with caution conduct an assessment of the physical and mental condition of the prisoner before his or her execution. Now, I realize this report only came out a few months ago. There have been no executions, so maybe this is not something that actually arises often. But have there been any policy developments or changes as a result of this recommendation of the National Commission?
Thank you for your valuable questions. I'm from the Division of Prosecutorial Division. You mentioned public opinions. And Taiwanese scholars who work with Oxford professors. I said earlier that in the in the National Human Rights Action Plan, also plans to conduct public opinions, and the methods for collecting public opinions will be carefully designed. We seek feedback from NGOs and scholars in Taiwan. So in the future, when public opinions surveys are to be conducted, we will ask the opinions from different stakeholders first, before we design the questionnaire for public opinions. After the questionnaire is designed and finalized, then the survey will be launched. This is to ensure that the surveys are able to collect or reflect true public opinions. That's my first response to your question. Second, Article 6 in ICCPR on the right to rights and General Comment number 36, well, both of them are very important in the eyes of the government. And we understand that General Comment 36 has an authoritative view on the execution of death penalty. After the UN issued this general comment, Ministry of Justice has already provided the English version and also the Mandarin Chinese translation to the Judicial Yuan and the prosecutorial offices under Ministry of Justice. So the judiciary in Taiwan, including judges and prosecutors, all understand the importance of this general comment. Also, General Comment 36 states limitations on the execution of death penalty. For example, the inmates who are not able to understand death penalty shouldn't be subjected to capital punishment, or those who have mental illnesses are the same. In Taiwan, for inmates who have finalized verdict of death sentence, in fact, they are also subject to psychological evaluation every 3 months. So this kind of evaluation is conducted in prisons to understand the mental status of the inmates with death sentence. And in 2020, in July, the regulation on the execution of death penalty was revised. In the revision, well, in Article 2 of the revision, it states a very important matter. That is, before executing a death sentence, it is necessary to review international human rights instruments, including General Comment 36, then decide whether or not the execution will be truly carried out. And the Supreme Prosecutorial Offices in Taiwan in March this year issued a public letter to prosecutors, stating that when prosecutors decided to ask for capital punishment sentence, prosecutors have to take into account international human rights instruments, including Article 6 of ICCPR, as well as CRPD and General Comment 36. These all mean that the Taiwanese government attach great importance to the spirit of General Comment 36. Thank you.
Very much. I don't want to prolong this, and I know that Professor Novak also has some comments with regard to Article 7 of the Covenant and the prohibition of torture or cruel, inhuman, and degrading treatment or punishment. I would just conclude with one final thought on the subject. In this morning's session, we had a discussion about the referendum process, and Professor Novak asked the question, could you have a referendum that would establish a legal rule that would, in fact, be in violation of human rights? In effect, he was asking, what if public opinion, through a referendum, expresses itself by adopting a rule that is, in fact, contrary to or in violation of fundamental human rights? And we had the very reassuring answer that the legislator would not be bound by a referendum, and that it's in this manner that a referendum conclusion that was contrary to fundamental rights would not, in fact, override the protection of fundamental human rights. And I think the same logic has to be borne in mind when we talk about the significance of public opinion in taking decisions about the implementation of the death penalty. We have these safeguards. Even when we have the safeguards, we may have public opinion crying out for the execution of a criminal who has committed a terrible crime, and yet we will know that because the criminal suffers from a mental disability, that the death penalty cannot be imposed because of the fundamental human rights principles that are involved. We can't have criminal justice policy dictated by public opinion. And the practical problems we see and the more theoretical problems we see in the case that we had in the example this morning of a referendum, I think is the same when it comes to criminal justice generally. I think we all understand that. And it's also true of the death penalty. So there's a point, it seems to me, at which, although it's important to bear in mind public opinion, to try and change public opinion, to bring it along with you, to help it to understand what's happening, that at the same time, governments have to take courageous steps at times and do the right thing, even if the public is not entirely endorsing such a position. Professor Novak, I think I've said what I have to say on the death penalty, and I want to thank the answers as well and the response from the government.
Yeah, thank you very much. In my opinion, the way how the government of Taiwan deals with the death penalty is the litmus test of whether or not you're willing to really take international human rights obligations seriously or not. When I received the National Human Rights Action Plan today, thanks to you, I was very happy. And I was sure that the first of the 6 or 8 different points would be, we commit ourselves to abolish the death penalty by 2024. When I now looked through that, I'm deeply disappointed. It's the same old arguments and issues that we have heard now for the last 10 years. And as Professor Shepard has said, it's simply not true that it took 200 years in Europe. In my country, it was also a discussion that took less than 10 years. And when finally the government decided to abolish the death penalty, the majority of the people were still in favor of the death penalty. And that's in most countries of the world. There are certain international human rights obligations that simply need to be taken into account, and it's simply an excuse to say, but the people still need, and it takes another 200 years until we go down from 80% to 77%. If I would follow this logic, it takes still until the 22nd century. And you are another 100 years in violation of international human rights law. Today, the old interpretation, systematic interpretation between Article 6 and Article 7 does not hold anymore. And you have said yourself, you take General Comment 36 very seriously. Now, if you look at General Comment, sorry, I have to, 36, then it also refers to Article 7. And it clearly says that the time has come to change. Why? Because state practice has changed. In the old days, we said the right to life still allows for certain exceptions of the death penalty in the most serious crimes and all the other exceptions. But it at the same time says you should work towards the abolition of capital punishment. And it's now already quite some time ago that Taiwan ratified the two covenants, and therefore that's the point when this gradual abolition started. Today, as Professor Shepard has said, Taiwan is among a very small group of states that is left, about 30 states, primarily Islamic states. These are all, most of the states are authoritarian governments, like the People's Republic of China, and many Islamic states. So you are among a very small group of states that are still executing. And it was always my understanding that Taiwan wants to be among the best states in the world in relation to human rights, or at least in the Asia-Pacific region. But also in the Asia-Pacific region, many other states are no longer executing people. The General Assembly is adopting a resolution every 2 years where it is very clearly calling upon the few retentionist states to abolish the death penalty and at least to start first with a moratorium. And this opinion is also reflected in paragraph 51 of General Comment 36 of the Human Rights Committee, where it is clearly said that the considerable progress that has been made towards establishing an agreement among states parties to consider the death penalty as a cruel, inhuman, or degrading form of punishment. The same is clearly established by the Special Rapporteur on Torture, who clearly said that the death penalty as such violates Article 7 of the Covenant, because all these human rights treaties are living documents. They have to be interpreted in light of present-day conditions. And present-day conditions clearly say that states should abolish the death penalty. So if I look at the Human Rights Action Plan, there are three, as you referred to, three proposals until 2024. And the one is that prosecutors shall seek sentencing with caution. And the second is research and analyze public attitudes and opinions on the death penalty and its alternatives. As I said, there are other opinion polls that clearly show that the majority of Taiwanese people are no longer really in favor of the death penalty if you ask the right questions. And the question is, what is alternatives? And that's your third point. Formulate an alternative plan to the death penalty. And then it says you commissioned a research on alternative plans, and there's a commission of experts and scholars to conduct a project research plan on alternative plans for the abolishment of the death penalty, to propose suggestions for feasible alternative plans in the legal system. Timetable 2022 to 2024. What do you think are alternatives? Why do you need 3 further years of the best experts in the country to tell you what the alternative to the death penalty should be? I have no idea what you are talking about. There are more than 100 states that have abolished the death penalty, and they all have alternatives. So it's not a difficult research question to find out what should be the alternative. I hope that you are not going to introduce, I don't know, medieval kind of punishments. I think the alternative is imprisonment, and probably long-term imprisonment. I would not suggest it should be life imprisonment without parole, because that would violate Article 10 of the Covenant. But the usual way is life imprisonment or long-term imprisonment. This is the alternative. We can give you this advice. You don't need your own research to be further carried out in order to know what alternative is to the death penalty. So I'm a bit afraid this is, again, a means of filibustering, of again delaying the process of abolishing the death penalty. And I mean, that is the main issue, or one of the main issues that we had from the very beginning. We made very clear recommendations. I think we are now already assisting the government for almost 10 years in bringing its national legal system in line with international human rights obligations. And I think that is enough for the gradual abolition of the death penalty. So I must say I'm very surprised about these very weak provisions in the National Plan of Action. And I have just few short questions, because most has been said by Professor Scherbers. The replies of the government to the first list of issues, page 27, paragraph 2, that you are referring to the careful execution, and you say after the re-investigation of prosecutors, retrial was successfully granted to one case in each of 2017 and 2020, so 2 individuals, and the defendants in both cases were eventually found not guilty. So we are talking about 2 persons who have been on death row, I don't know for how long, but already for some time, and then they finally got a retrial, and the judges found out that they were not guilty. And then you conclude these are the best examples to illustrate Taiwan's careful execution, respect for life, and protection of human rights. Now, I would draw a different conclusion. My conclusion is that's one of the strongest arguments against the death penalty, that there might always be cases again where people are wrongly convicted to death. And if you would not have this careful execution policy, perhaps these 2 innocent people would have been executed already. And of the 38 persons who are on death row today, there are quite a few where there is strong evidence that they were convicted on the basis of a confession extracted by torture. And that is the risk of the death penalty, if people then confess and then they are executed, and you might execute innocent people. So my question to you is, why do you feel that these are best practices or best examples of Taiwan's policy, rather than drawing the conclusion only on the basis of those 2 cases that it is high time to stop the death penalty? That would be my first question, please.
检察师。
The Department of Prosecutorial Affairs. Thank you. Thank you for the questions. I think our long-term goal is to abolish the death penalty. Currently, our strategy is reduction and prudent execution. As you pointed out, in 2017 and 2020, there were 2 prisoners on death row. After the prosecutor's initiative to apply for a retrial, they were acquitted in the end. In fact, the 2 cases have been adjudicated by the courts of 3 instances before the conviction was made. However, as I answered previously, in executing the death penalty, we do have regulations governing the execution of the death penalty. We have to review whether there is any ground to apply for retrial or any extraordinary appeal. This is a way to ensure the rights, the human rights of the inmates on death row. Your recommendations and the examples you shared with us, the UK, France, I think other countries' experience can serve as valuable reference for Taiwan to formulate policies, measures, and strategies to abolish the death penalty. I agree that the public opinion should not be the sole basis on policy making, but for any democracy, people's will, public opinion still serve very important basis. So as we move gradually toward the goal of abolishing the death penalty, most important of all, we have to forge consensus so that we can ultimately achieve the goal of abolishing the death penalty. As you said, alternatives to the death penalty, you can tell us right away. In 2007, the Ministry of Justice also commissioned scholars to conduct study into the alternatives to the death penalty. However, after the proposal was reviewed by the research and the promotion team for the progressive abolition of the capital punishment, there were still different opinions. That is why, under the latest National Human Rights Action Plan, the MOJ once again proposes to conduct research into alternatives to the death penalty, because 13 years have gone by. There has been some evolution in the death penalty policies in different countries. We hope that next year we will be able to identify alternatives to the death penalty, and then we will present these alternatives to the people through opinion polls. So these alternatives will be presented to the public so that we can come up with a policy that is acceptable by most people. The Judicial Yuan in principle, as reviewers pointed out, during the past year, there were decreasing number of cases where death penalty was meted out. In other words, the judicial system is very cautious when giving the sentence of the death penalty. And judges also actively cited the provisions, the articles of the covenants. So the two covenants, including the right to life and the irreversible nature of death penalty, the judges are very well aware of these issues. The same goes for every member of the judicial system. So we have given quite consideration to the articles of the covenant. And this has been reflected in the judgments rendered during the past couple of years. Even though the criminal code has not abolished the death penalty, the judges do have discretion to avoid the death penalty. Thank you.
My last question is, it's a question and an appeal. The question is why, even if you feel you still need to do further research, you still have to ask another opinion poll. Why are you not doing that after you have issued a moratorium? That is what other governments usually have done. So if something is so highly controversial, then you put a moratorium so that not further people are executed, and then it is a more kind of relaxed atmosphere that you then can discuss the pros and cons and how quickly you will actually then formally abolish the death penalty by means of legislative action. So I'm fully aware that until you finally draft and adopt these laws, that might take some time. A moratorium can be imposed in one day. So that's why my appeal would be, so that our also concluding observations that I think in many aspects recognize very much the progress that has been made in Taiwan over the last 4 years since we had our second review. There will be many positive observations, starting with the establishment of the National Human Rights Commission, etc. All that will be overshadowed if we have to say Taiwan is among a few, very few countries that still refuse to really abolish the death penalty, not even being willing to follow our recommendation to immediately impose a moratorium. So since this is something that can be done very quickly, I would be very happy if you could come up with a decision to impose a moratorium before we are finalizing our review this week and before we having a press conference and having to tell the press. It would be great if we could say the outcome of this third review is that what we already recommended 7 years ago was finally now implemented. The government agreed on a moratorium, and then they will further discuss what needs to be done, what are the alternatives, etc. And when we come back in another 3 years, then we will see what the final outcome of the deliberations is, whether the government is already that far to fully abolish the death penalty, since the will to abolish, I think, has been repeatedly brought to our attention. So it's not the will. I think that the will is there, but the moratorium would really underline that this will is also a serious conviction of the government. Could you imagine that this is the outcome of our third review? You have the floor.
检察师有没有意见？
Any response from the Department of Prosecutorial Affairs or other agencies? Okay, Department of Prosecutorial Affairs. Taiwan has rule of law. For any democracy that follows the rule, the basic practice is to be compliant to the law. While death penalty still exists in current law, if the judiciary finalize a sentence on death penalty, unless there are causes to suspend the execution, or unless there are reasons as stated in General Comment 36, then for the principle of the rule of law, it may still be, the country must still need to follow the law. But Taiwanese government has upheld that life is very precious to all the people in Taiwan, and protecting human rights is definitely an ultimate goal of the government. So we will take into account all of your comments today. Thank you very much for your insights. Okay, I would like to and add by saying, thank you, Professor Novak, for raising this up. I think the first time you talked about it was 10 years ago. And the research and promotion team for the progressive abolition of the capital punishment was created 10 years ago. And it's not only a legal issue, and we respect the importance of the issue of abolishing death penalty, and this is our ultimate goal as well. However, the term abolition or the abolition of death penalty in Taiwan is not only a legal issue. Of course, it's a human rights issue, yet it is also a social issue and a political issue. Therefore, for government agencies, it's very challenging as well. From the perspective of human rights, we need to abolish death penalty. But this issue, as I said, is not only a legal issue, it's a social issue and a political issue. It involves all the government agencies. Second, I remember about 2 weeks ago, a Malaysian was executed because of drug offense. Yeah, and right in Singapore. Many people have made efforts trying to rescue him. And plus, this person has mental illness or had mental illness. So we do see death penalty is still a controversial issue in some of the Asian countries. So the government, therefore, dares not just go ahead and abolish death penalty because there will be some consequences and some cost. And therefore, we take the term progressive or gradually. But in fact, we understand your critique. And the Philippines had abolished death penalty and revive it and then abolish it again. So these are the cases that happen in Asia. Maybe it's a little bit easier in European countries, but Asian countries have their differences. I need to reiterate that this is our ultimate goal, and I can not promise on behalf of all the government that will be able to abolish death penalty immediately. But what I can say is that, as Professor Manfred mentioned, there are people who are on the death row, and there were 2 cases when a death penalty was reversed. I think this is a positive example. And in 2019, we issue the English version of the General Comment 36 to prosecutorial offices and to police agencies so that they have a better understanding. So we're trying to gradually change the attitude and the mindset of government officials. And we also invite people from correctional agency, and we invite the Taiwan Alliance to End the Death Penalty, along with the staff from correctional agency, to visit inmates who are on death row, so that they have a better understanding of the issue. So it's not that we're not doing anything, we are doing something. And also in the National Human Rights Action Plan, we include some lessons we learned from European countries. And again, thank you very much for your comments. We take into account your comments. I'm sure we will make progress. I can't say there is a definite time schedule or time frame, but we will take your comments into consideration. Thank you very much.
Thank you very much. We took up quite some time on the death penalty, but I think it is one of the most urgent issues. So I ask Judge Lorenzen.
Yeah?
Yeah.
Thank you very much. Thank you, Chairman. I have a few questions or comments in this respect. It was said by the government that we try to reduce the use of the death penalty. It's not quite clear to me what you mean with we. And I would like to ask in this respect, who makes the decision? Is this left to the individual prosecutor whether he wants to claim a death penalty, or is there a sort of centralization so it goes up to a higher level, the prosecutor general or even the Ministry of Justice to be involved in this respect? And secondly, the role of the press in relation to this issue. I have heard, when taking part in discussions of this issue earlier, that the press, or I should rightly say a part of the press, has a very aggressive attitude to the use of death penalty whenever a hideous crime is committed, which of course can and will influence the public opinion in this respect. I'm in no way trying to propose that interference with the freedom of the press should be done, of course not. But if, to the extent this is true, is anything done to influence the public opinion in this respect in order to have a better understanding for abolishing the death penalty? Thank you very much.
Departments of Prosecutorial Affairs, thank you very much for your question. When it comes to individual prosecutors' decision, well, they have their own discretion based on the fact and evidence, and the general prosecutor issue a letter to all the prosecutors saying that when prosecutors consider asking for a death penalty, they have to review CRPD, CRC, ICCPR, and General Comment 36. Before they determine whether they want to request for death penalty. As for inmates with death penalty, well, execution has to be reviewed by different levels at MOJ. The Supreme Prosecutorial Office has to review the case according to the regulation that govern execution to see if there's any petition for retrial, if there's extraordinary appeal and judicial interpretation, or whether there are any cases of insanity, and whether there is presidential pardon. So all of these factors have to be considered as well in considering if an execution is going to be conducted, and to also investigate whether there is any wrong prosecution. And when an execution case was sent to the MOJ by the prosecutor, the MOJ will assign personnel to review all of these factors. Other than that, there is an evaluation of execution task force, which was headed by Deputy Minister and several Vice Minister of MOJ as the final gatekeeper. Of course, in the end, the Minister of Justice is the one who has to say to decide whether or not the execution will go ahead. Any remarks from Judicial Yuan?
Good afternoon. I speak for the civil court under the Judicial Yuan. Speaking of the reduction strategy, right now, for death penalty cases, the courts, the judges have been very cautious when dealing with these cases. As for the administrative regulations, at the criminal cases at the Supreme Court, then the cross-examination will have to take place. As for evidence based on the investigation and the trial date scheduling, there are specific requirements telling the judges to be very cautious and careful when adjudicating death penalty cases. In addition, I think starting 2021 or 2022, many judgments have referred to or cited articles of the two covenants upholding the respect for the right to life. And of course, for the defendants with mental disabilities, if they are not morally reproachable to such an extent, then death penalty must not be executed. Or if a person committed a crime when the mental disorder was not present. However, at the end of the day, when sentencing decision is made, mental disorder, mental capacity still has to be taken into account when the defendant stands the trial. So these are all considerations the judges have to take into account. That is also why we have seen a declining number of death penalty cases and executions. So this is response from the judicial system's view. I would like to provide some additional information. I think the reviewers just mentioned that in terms of prosecutors' action, basically we do not limit the prosecutor's power or right to indict people, but we do provide guidance and advice to the prosecutors, urging them to be cautious if they want to seek death penalty. And the Prosecutor General recently also once again reminded the members of the judicial system that we have to refer to the two covenants and be very careful and cautious when applying death penalty. And of course, we respect the independence of any trials. So in recent years, we have seen some high-profile violent cases where judges, based on their independent discretion, cited articles of the ICCPR. As a result, there's no death penalty meted out. As a result, there's a public outrage against judges who made the decision not to impose death penalty. And in those cases, usually it's a life sentence was imposed instead. So in 2020, based on the newly amended Prison Act, we have a regulation for the execution of death penalty. So there are several conditions under which no death penalty can be carried out. So that is a mechanism to make sure that there's a final review before the death penalty is executed. So we do have mechanisms in place. What about the role of the press? Right now, we cannot yet abolish the death penalty, and I think the media, the press, plays a role because there's also voice from the press calling for the retention of the death penalty. Take my family, for example. Some relatives feel that death penalty should be carried out as there are serious crimes committed. I was scolded by my family and relatives for not carrying out the death penalty. So I hope you will understand the situation we are in Taiwan. Last Saturday, I watched a movie on Netflix, The Life of David Gill. This is a movie based on a case in Texas in the United States. The governor supported the death penalty, and the Attorney General of Texas opposed the death penalty. So that's a movie I watched last Saturday. Please give us some more time so that we can realize the goal of abolishing death penalty. Thank you.
The last question was, what is the government doing in order to positively influence public opinion, including the media? Because if you say that the public is outraged if the prosecutor is not asking for the death penalty, or even so, because there is an obligation, if you have the policy of gradually abolishing the death penalty, you also have an obligation to educate the public about why the death penalty is not a useful form of deterring crime or whatever. Has there been any campaigns by the Ministry of Justice or by any other governmental body, by the Ministry of Education, etc.?
How about the Department of the Prosecutorial Affairs? Would you like to respond? The MOJ on human rights education has held campaigns to promote the right to life. So we do have such campaigns to interact with the general public. In addition, the Taiwan Alliance to End the Death Penalty, TAEDP, has organized a number of campaigns. We also took part in those campaigns so that we can know the viewpoints proposed by the NGO. Through such interaction, we want to forge consensus as well. Moreover, in our research and promotion team for the progressive abolition of the capital punishment, the team members consist of people on both camps. Therefore, the team members in discussing relevant issues are also trying to come to meet each other in the halfway. As for the press, the MOJ did try to provide information for the press like Professor Manfred said, in the 2 cases of the death row inmates who were then acquitted and released, we provide, for example, we wrote a public letter to the press telling the press what has happened in the process. And then the press will decide what kind of news stories they would like to write about. As for the Taiwan Alliance to end the death penalty, the alliance can also seek information from us so that more information can be made available to the general public. Sometimes the legislators may accuse the MOJ for favoring one camp over another if we do this too publicly. And of course, we also continuously communicate with relevant stakeholders. For example, on the research and promotion team meetings, we've invited Professor Xing from Germany to give us lectures. And so these are different means by which we try to influence opinions and thoughts of different sectors of society. And death row inmates can be interviewed by the press. As for the wars in the prisons, we also ask them to take part in these campaigns. Currently, for death row inmates, they stay at some specific prisons, and we tell the guards at those prisons that there should be more lenient treatment and accommodating actions taken for those death row inmates.
Soon have a break. Just 2 very short questions. The one is, I mean, according to the covenant, there is always a right also to seek pardon. To my knowledge, the right to grant pardon is a prerogative of the president of Taiwan. Is she free in doing that, or is she dependent on the Ministry of Justice or the executive yuan, or can she do that on her own? And the same is moratorium. In order to issue a moratorium, is that again a prerogative of the president, or who has the power under domestic law to actually issue such a moratorium? The last question is also to the prosecutor's office. You said repeatedly that when prosecutors are considering whether or not they should ask for the death penalty, they are taking all the necessary human rights standards into account, including, of course, the covenant, but also General Comment 36. Why are prosecutors not taking the clear recommendations of the review committee into account? Because I thought we have been invited because the Human Rights Committee cannot exercise its functions vis-a-vis Taiwan. So we have kind of taken over the function of the Human Rights Committee in relation to Taiwan. And the last point, we are not really, if we are talking about abolition, we are not primarily talking about the right to life. It's written in Article 6.2 and Article 6.6, but if you look in all the countries in the world and all the decisions that have been taken in order to abolish the death penalty, they are all based on the right to human dignity and personal integrity. So it's not anymore a question of the right to life, it's a question of the prohibition of torture, cruel and inhuman punishment. That is the main issue. That is what the European Court of Human Rights has done, what the Inter-American Court of Human Rights, the South African Court, the General Assembly in its resolutions is referring to the right to dignity, not the right to life. It's very important to understand that the violation is not Article 6. Article 6 is still allowing under certain preconditions to some extent that death sentence and execution. It's a violation of Article 7. I think that's the main issue. And I think also in the public awareness raising, it's important to say also people who have committed a serious crime are human beings with the right to dignity. I think that's the main argument also for the abolition. Before we close this debate, is anybody else from the committee? So perhaps I could have a short answer to my two questions about moratorium and pardon. And has there ever been a case where a death row prisoner has been pardoned by the president of Taiwan?
I would like to respond to the question on pardon first. There were 8 pardons, but none of it was for death row inmates. There was a pardon for an indigenous hunter who violated the ecological law. He received presidential pardon, and the other pardon happened this year. I think 2 military officers received a pardon, and they violated Corruption Act. And secondly, on prosecutors' power in requesting death penalty, I think the key is in paragraph 2 of Article 6. It states that for countries which have not yet abolished death penalty, and only the most serious crimes can be subjected to death penalty. In other words, paragraph 2, Article 6 does not require countries which still retain death penalty to stop death penalty or cannot execute. So whether or not prosecutors request for death penalty in his or her sentencing, this is not forbidden by the laws and regulations. And in the substantive law, there is death penalty. So prosecutors will follow the criminal code procedures. But of course, with CRC, CRPD, and ICCPR, as well as General Comment 36 in his or her mind when deciding whether they're going to request to sentence the perpetrator to death penalty. So prosecutors are reminded that there are certain factors, important factors to consider when requesting death penalty. Okay, in our Pardon Act, pardon is the privilege of the president. In current Pardon Act, it doesn't require the president needs to obtain permission from any other parties before making the decision to give pardons. And when it comes to prosecutors, well, I used to be a prosecutor when I was younger, about 20 years ago. Well, 20 years ago, there were more prosecutors which asked to sentence death penalty. But in the past several years, there were very few cases in which prosecutors asked to sentence the defendant to death penalty. So, but we will relay your comment to the prosecutors. But indeed, prosecutors now rarely request death penalty. And torture, cruel or inhuman treatment yet is another perspective as to why we need to abolish death penalty. Some people will say that if you put a person behind the bars for 30 or 40 years, this is inhumane, this is cruel treatment as well. So I think we still have to work harder in explaining to the general public as to why we want to abolish and why permanent imprisonment is cruel. Thank you.
For this very rich debate. And I suggest that we have a break now. I would say it's 15 minutes, all right? So that we can meet again 10 minutes before 4 o'clock, because we have still quite another, both Article 6, 7, but also 8, 9, 10, and 11, so quite a number of human rights issues we still have to do. So see you again in 15 minutes. Thank you.
现在是中场休息时间。那待会在3点50分的时候呢，会议准时开始，请出席人员准时与会。有关洗手间的使用部分，因为10楼的南侧是国际审查委员的专属厕所，请勿使用。有使用需求者，请改至11楼使用。谢谢。
everybody to take their seats again. Apologies that it was a fairly short break only, but we have only until 5 o'clock and still quite a couple of issues. So the first question relates to Article 7. And my first question is, and we raised this question already quite some time ago in the first and in the second review, that Article 4 of the Convention Against Torture, and I'm aware that the Convention of Torture has not been ratified or accepted by Taiwan so far. And unfortunately, I understand there is a draft implementation act, but it has not been adopted yet. But still, also in interpreting Article 7, one of the strongest means of eradicating torture is if you make it a crime under domestic law. And so we have been recommending very strongly that torture as it is defined legally in the Convention Against Torture, Article 1, and this is the deliberate infliction of severe pain or suffering on a person usually under the control of others, so in detention. But this infliction of pain for a particular purpose, that might be extraction of a confession, extraction of information, intimidation, discrimination, punishment, etc. So it's a very clear definition, and the main kind of reason why this is one of the worst crimes, and why also the Convention Against Torture required states to make it a crime. It's not a misdemeanor. It's a major crime, like other violent crimes, like homicide. And the answers are always the same. We received them now already for quite some time, that there are various provisions in the criminal code of Taiwan that are applicable. And our response was always the same, that this is not what is required by the convention. These are various general obligations of police officers, etc., prosecutors, but there is no clear specific crime in the domestic criminal code of Taiwan. And I would like to conclude this long debate, and my question is, why is it so difficult? What is preventing the authorities, whether it's the Ministry of Justice, and of course that has the main responsibility of drafting a bill and then proposing it to the legislative yuan, but nothing has been done to really make torture a crime with appropriate penalties. And appropriate penalties, according to international law, is a long-term imprisonment. irrespective of whether the torture leads to death or injuries. This is not the important point. The important point is the deliberate infliction of severe pain or suffering on a powerless person. That's what makes torture such a terrible crime. So what prevents or what has prevented so far the government to implement our recommendations in the first and in the second, and now also with our list of issues? Please, if I can have an explanation, I would be very grateful.
National Police Agency, please respond. Thank you for your question. I am from the Criminal Investigation Bureau of National Police Agency. But in fact, the Implementation Act for CAT was sent to Legislative Yuan for review in 2020. And the definition of torture is very clear. And as to the amendment to criminal code is the responsibility of MOJ. But for police officers who have to fight crime on the street, we have our own opinions in terms of including torture in the criminal code. Well, if we include the definition of torture in our criminal code, is it possible that the abuse of power or inflicting pain on the defendants, which are already in the criminal code, will such an addition being conflict or overlapping with what is already included in the criminal code? Also, when fighting crimes, police officers may sometimes need to use lethal weapons. So if we include torture in the criminal code, maybe police officers will become very concerned when they carry out their obligations and responsibilities. They, at the same time, they sometimes have to use weapons to protect themselves. So that's our first concern. Second, MOJ proposed a draft amendment to Article 126 in Criminal Code. There were many different opinions from the public, so we think we must be very careful in considering whether or not to include torture in Criminal Code.
Good afternoon. I speak from the Department of Prosecutorial Affairs of the MOJ. Please raise your hand so that the reviewers can see where you are. So please refer to our replies to the second list of issues. Page 26 of the English version, page 25 of the Chinese version of our replies to the second list of issues. The torture as defined per Article 1 of CAT. Basically, the action was taken to exert confession or information obtaining from information or a confession, as a result, impose physical or mental severe pain or suffering. The Article 1 of the Convention Against Torture actually can be found in the provisions of our criminal code. For example, in Article 125, our criminal code, basically for public official charged with the duty of investigation or bring offenders to justice who commits one of the following offenses shall be sentenced to imprisonment for not less than 1 year, but not more than 7 years. And such officials include prosecutors and judges. For example, if the public official uses force to arrest a suspect, and if there's evidence of power abuse, then the public official will be faced imprisonment. And if there is the action of coerced confession, that means the public official tries to obtain from the suspect information or a confession. As for threats or intentionally impose severe pain or suffering, both physical or mental, I think you can find similar wording in our criminal code. Any public official implicated in such behavior will be sentenced to imprisonment. In addition, if the public official knows one person is innocent but still indicts this person, or if the public official knows one person is guilty but still releases that person, the sentence of imprisonment will also be imposed on the public official. And if such action results in death or serious injury, you can see harsher penalties are imposed on public officials too, per Article 125 of the Criminal Code. In addition, Article 126 of the same code stipulates that
we have this all in writing, and we explained time and again that this is not the definition of torture as it is in the Convention Against Torture. I'm sorry for interrupting, but to save time, we simply do not agree. The particular seriousness of torture has not been taken up by Article 125 and 126. These are, if a police officer is abusing his authority in arresting a person, yes, that is a crime, fine. Has nothing to do with torture. So the torture has very specific elements, and they have to come together. And that makes torture such a serious crime. And that is lacking in the criminal code of Taiwan. So I was only asking why it has not yet been done. And I accept that the government doesn't feel the necessity of really enacting a crime of torture. That leads to the next question, and that is, if I read the third report, and that is paragraph 53, under torture, the government says, torture victims may file a criminal charge with a prosecutor, submit a petition, or report cruel treatment to a prosecutor or judge. Inmates can file a complaint with a prison or regulatory authority. And then it was said there were 1,945 such complaints received by correctional institutions between 2015 and 2019. So my question is, it seems torture is existing in the country. I cannot imagine that you have almost 2,000 complaints and they are all totally unfounded. But are they really investigated? And I mean investigated from a criminal perspective. And that is related, if there is no crime of torture, of course it's also difficult to investigate a crime that doesn't exist. But my question then also was, how many of those persons who have been accused of torture have been actually brought to criminal justice or have been sentenced? And when I look again to the replies of the government, then I get the feeling that the utmost a police officer or a prosecutor who has been accused of torturing is a reprimand, a disciplinary action, but not a criminal action. And I think that is the problem. If torture is not really defined as a crime, then you deal with it like if it would be a misdemeanor, something that you take over, to take upon in a disciplinary proceedings. But perhaps there are other facts. I couldn't, so for instance, on the reply to the second list of questions, then it was said, as of March 29, 2022, a total of 410 applications have been accepted, of which 2 were further processed and transferred to the disciplinary court trial. So 410 applications, only 2 were further processed, and then not to a criminal court, but to the disciplinary court. So there is something fundamentally missing, wrong, and that I think there is no independent authority to investigate and prosecute torture. Otherwise, I cannot imagine why there are no consequences for torture that is obviously happening. Otherwise, there wouldn't be so many complaints about torture. Again, so why is there no independent body that is investigating torture by the police or by prosecutors?
Department of Prosecutorial Affairs, would you like to respond? So you talk about the criminal handling of the accusations. Well, we have applied the Article 125 of the Criminal Code and indicted the perpetrators, and the perpetrator has been sentenced. For inmates, if they file complaints to the correctional institution, then the complaints will be handled by the correctional system. But if they file the complaints to the prosecutor's office, then there will be the prosecutor's duty to investigate if there is acts of torture. So it's not the dispositionary court solely taking care of such accusations. And again, if it's confirmed a torture case, there will be criminal punishment. How about the judicial yuan? Would you like to respond? Correctional agency? Well, let me say something. The concept of torture, even though we don't have a separate crime for torture, but the idea of torture is something we know very well. Take correctional agency, for example. 2 years ago, a guard at the correctional institution tortured inmates, and he was indicted and punished. The Kaohsiung prison case. We will collect the relevant data and give you the relevant data tomorrow.
认为说是侦查中警察司法警察打人，酷刑，酷刑取得其供，或是检察官甚至。这是一套。另外，在执行面的话呢，也不应该有酷刑。
Actually, currently, we have been trying to crack down on torture for sure. We don't yet have an act on the prevention of torture. In 2020, we already sent the draft to the Legislative Yuan, which is reading this draft. So domestic law-wise, we don't have a specific law. But of course, we have to know what constitutes torture. That has to be clearly defined. Should we have a separate, dedicated law, or can we incorporate the concept of torture in existing laws and regulations? And we know deepfake is a rampant crime nowadays. And sexual privacy and the right to personal privacy are also issues close to people's hearts. And people have been discussing whether we should have a dedicated legislation. But now, in that regard, we have incorporated provisions into the criminal code. So in the end, the Legislative Yuan will have to decide whether the draft will be passed. If we can incorporate the CAT into our domestic law through the Implementation Act, then we will consider whether some overlapping provisions in the criminal code can be taken out and combined into a dedicated legislation against torture.
Please.
I will provide additional information concerning the case. Deputy Minister just said, in 2020, the court sentenced the defendant, who is a guard in a prison, and abused inmates under his guard. Some of them were sentenced to 9 years and 6 months. Some were sentenced to 8 years and 6 years of imprisonment.
I think it's the crime of homicide, because
他用伤害，应该是用伤害致死罪啦。
I think it's a manslaughter resulting from serious injury. So the inmate and one guard cooperated to beat another disobedient inmate who died in the end. That is why the prosecutors and the judge indicted this perpetrators with manslaughter resulting from serious injury. But as for the specific crime, we will look into other possibilities in the future.
The point I'm making, he was sentenced not for torture, he was sentenced for manslaughter. The crime would be as bad even if the person would not die. And in this case, he would have gotten perhaps a disciplinary reprimand. And that is my main concern. Since there is no crime of torture, there is also no consequence. And since there's no consequence, there's no deterrence. And that's why torture is continuing to take place in the country. So if you want to fight torture, you first have to establish a crime with the necessary consequences, and that is a severe punishment. Anything else on the, please?
我先说明一下，那个主席刚才所提到说
Well, right, torture, whether or not torture should be defined as a crime. Yes, we're considering that. We're still discussing what elements constitute torture. So we're still in discussions.
Yes, it works.
I have a very basic question. In many countries that I'm aware of, Malaysia included, there is torture in detention, not by a guard, but by the police who need to establish guilt. So they want to extract a confession from the suspect. He is a suspect only. They bring him in. The magistrate gives them a remand order for 5 days, 3 days, maybe, or even 24 hours. You cannot keep him longer than that if you cannot charge him. So to charge the suspect, you have to have some evidence of guilt. And therefore, within that even 24 hours, there is torture to force him to confess. That happens in many countries that I know of, and as I say, Malaysia included. In the process of that, sometimes the suspect dies. So we call it custodial death, death in custody. My question to you is, are there any instances in Taiwan of death in custody? When you have arrested somebody on suspicion and you're given a remand order to get some evidence so that he can be charged, because he must be charged within the number of days the magistrate has allowed. So there's sometimes very severe torture to get this confession. I'm not saying it happens here, I don't know. I'm asking you then, has there been any instances of death in what I call custody while the suspect is being remanded? Do you have any incidents of death in custody? That is my question.
Yes, Emil.
Well, I think in 1982, there was such a case. When I was still being trained as a prosecutor, there was a defendant called Wang Mingxian, but torture was not the term that was used. So Wang Yingxuan was caught because of robbery, and under martial law, that was a crime subject to death penalty. He confessed, and the police officers at the time were very young, and they were ambitious. They wanted to crack the case. So they were looking for the gun in a bridge. So the real criminal was Li Shike, but Wang Yingxuan was brought by the police officer to a bridge to look for, well, the so-called weapon, the gun. And then Mr. Wang jumped from the bridge and died. I think the person who caused this issue, those police officers, some of them went to China, and as far as I know, one even become a high-level official in China, so I heard. Back then in Taiwan, when the case was still being investigated, suspect did not have the right to attorney. But later on, this has been changed. So you said that torture should be defined as a crime. I think we are, of course, thinking about that. And when CAT becomes ratified, we will have a clear idea. This is National Police Agency. May we add some more information?
this was a 1982 case. Huh? Yeah?
Kwan科长，你可以先说明一下。那我先补充说明一下。
The case of Kaohsiung, the offense was abuse suspect to death. That was the offense that was used to prosecute the perpetrator.
Any more recent cases of what I call death in custody? Because the death is not the torture. The death is the consequence of the torture. So it's an indication when there's death in custody, when they are in detention and being questioned, investigated and questioned, if the man dies, or if man or woman, whoever it may be, if they die, it's an indication that there has been very severe beating and torture. That is why he died. So that I'm asking is, otherwise you don't know he was tortured. It's hidden. Has there been any more recent cases of any death in custody? You don't have that here?
If I may add, in the responses of the government to our concluding observations, page 81, there are 2 tables on inmates' deaths in correctional institutions. In fact, it is between 148 people who died in 2015, and it decreased to 117. But then you have very few homicides, you have a couple of suicides, a few accidents, and then most of them are natural deaths. My question is, have all these cases been investigated by a forensic expert in order to find out whether or not the so-called natural deaths might have been a consequence of torture?
Criminal Investigation Bureau. I'm from Criminal Investigation Bureau of National Police Agency. The Wang Yingxuan case happened in 1982. That's why criminal code procedure was amended significantly. National Police Agency regretted that such an event happened, so we devised many regulations to prevent this kind of event. So far, there haven't been any new cases when suspects were tortured to death in custody. But why were there cases of torture? This was because police officers didn't have enough investigative capacity. There weren't strong enough laws and regulations and so on. But after that, new regulations were devised: continuous recording, access to counsels, mandatory assignment of counsels for vulnerable groups, and investigation instructions that states the interviews and investigation have to be transparent and so on. All of these new instructions prevent torture conducted by police officers during investigation. And currently, maybe some think that if torture becomes an offense, we're able to reduce the offenses. However, there are so many offenses already defined in criminal code, but such offenses still exist. So I think the point is we need to educate the police officers to understand that everyone should be presumed innocent before found guilty. So instead of punishing law enforcement, we need to educate them so that they don't feel that they have to use torture or any cruel treatment. I would also like to add by saying that according to Prison Act and Detention Act, in prisons or detention centers, if some people die of illness or other factors, we need to report to the prosecutors for examinations of the bodies, and the prosecutors then will investigate whether this is a death caused by death or ill treatment. Of course, at the executive aspect, well, say in the Kaohsiung case, the jail in Kaohsiung at the time worked with prosecutors to investigate the case. So investigators, and in fact, examine the body to perform forensic examination. So I think as of now, we have a better system. It is just that we still need to discuss what elements constitute torture.
In your replies to our concluding observations, it's paragraph 159. When an inmate dies, the case is transferred to a prosecutor's office for an impartial and independent examination of the person's remains. But the prosecutor is not an independent body. The prosecutor is a government body. It is under, I guess, the Ministry of Justice. It's the same if the police is accused of torturing, and if this allegation of torture against the police is investigated by the police, it will not work. And the same is if there is an, if the prosecutor is accused of torturing, and this allegation is prosecuted, is investigated by the prosecutor, it will not work. So you need an independent investigation and prosecution body, like with the anti-corruption agency, etc. So, because otherwise there's a conflict of interest. And I think that is also one of the reasons why so many cases of torture or other forms of ill treatment by the police or by the prosecutors are actually brought to justice. Because if you investigate against yourself, you're not impartial and independent. Are there any other requests for the floor on? Yes, please. Yeah.
我们这里稍微说明一下，稍微。
We would like to explain more.
So I would like to provide additional information. If we are talking about criminal cases in Taiwan, then judicial personnel must be involved. I'm sure this is the same in other countries. But for anti-corruption investigations, we, of course, investigate any misconduct by public officials. But for criminal procedures, for judicial procedures, according to our system, the judicial personnel will investigate and prosecute. In Taiwan, our prosecutorial system is based on the continental law system. And we know that public prosecution is the focus in the case law system. So the prosecutors and the policemen also both have the right to make prosecutions. But in Taiwan, only the prosecutors can prosecute. So we have judicial police officers in the investigation bureau, and they have to investigate under the guidance of the prosecutors. So I'm talking about the prosecutor is the only capacity in Taiwan that can prosecute. For economic crimes, financial crimes, drug-related crimes, protection for women and children, they have different divisions of labor among the prosecutors to be in charge of different cases. And the prosecutors are under the leadership of the prosecutor general. The Minister of Justice cannot override the rights of the prosecutor general. So the Department of Prosecutorial Affairs would like to provide additional information. According to Taiwan's judicial system, prosecutors enjoy great level of autonomy and independence. Article 86 of the Judges Act. According to that article, prosecutors on behalf of the state investigate and prosecute criminal activities. The prosecutor acts in the public interest so as to honor the Constitution and relevant laws. They must fulfill their duties impartially. So these are provisions concerning the duties and role played by the prosecutor in our law.
Not putting into question the professionalism of prosecutors in Taiwan. I'm only saying, if you investigate against yourself, you are not impartial and independent. So if a prosecutor is accused of whatever crime, doesn't matter, there must be somebody else who is investigating and prosecuting. And the same is with the police. If the police is investigating against the police, whether they have tortured, it will not be an independent investigation. So that is a problem that we have in many countries of the world. And that is one of the reasons why there is so much torture ongoing, which is not detected, because it's never independently investigated. And of course, there is a certain tendency of the police to actually protect their colleagues. And the prosecutors and the police are together responsible for investigating crime. And torture usually is used when a suspect is investigated, is interrogated. That is the usual time when torture is used. And it is again a suspected criminal. So that's why the Committee Against Torture and others have always again said we need a real independent investigation and prosecution. If it is only about torture and ill treatment, police misconduct, it's also in the interest of the police, because they are often accused, and perhaps of the 1,400 or 1,900 cases, perhaps really 1,000 cases are totally unfounded. But if only one or two are prosecuted, then there is, I think, a certain suspicion that the investigation doesn't really work independently. Any other issues? 6, 7, 8.
那我补充一下，刚才跟教授跟主。
So we were saying that the prosecutors would investigate criminal activities. As for other investigations, I think, according to the Convention Against Torture, the control yuan can also serve as an independent organ to initiate investigations. I think in our draft, we do have this provision. So According to the draft for the Implementation Act of the Convention Against Torture, we follow the OPCAT. We plan to set up an APM. The MPN does not have the right to initiate criminal investigation. So MPM is independent oversight agency. Under the National Police Agency, we have anti-corruption office to look into misconduct, and we also have an oversight office to look into any potential violations of the law. So we do have very stringent mechanisms in place.
Of the National Preventive Mechanism, but this is not an investigation body, it's a prevention. They carried out preventive visits to places of detention in order to prevent torture, ill treatment, bad prison conditions, etc. But the NPM doesn't have the power to investigate individual cases. That's a different issue. Article 11, is there anything on Article 10, on prison conditions, we welcome. I think that quite much has been done by the government since our last report in order to reduce overcrowding and improve conditions in detention, in particular in prison. So I think that is definitely an improvement, and I also see in the report that further measures are envisaged in order to also partly build new prisons, and but also to reduce the overall prison population in order to reduce overcrowding. In relation to children and juveniles, we see there is quite a high number of children in different facilities that are depriving children of liberty. Are there any intentions to reduce that? It's going a little bit into the Convention on the Rights of the Child, which says that deprivation of liberty of children should be a measure of last resort. So it should be a very, very exceptional measure, and if so, only for the shortest appropriate period of time. Are there any plans? I haven't looked now in the National Plan of Action, the Human Rights Action Plan, but are there any kind of plans to reduce the number of children in detention?
In this regard, the Judicial Yuan can respond. We can ask our judge of the family and juvenile court. So in terms of juvenile cases, if a juvenile violates law, the juvenile court will be in charge of such cases. In terms of procedural protections, we provide the same protection regardless of the age of the defendant. Whether or not the liberty should be deprived, again, there will be a juvenile investigation officer to provide assessment. If it's a very minor case, then we can actually decline this particular case, and then we can transfer the juvenile to social welfare institutions to provide interventions for the juvenile. In other words, we would resort to non-judicial means to provide interventions for the juveniles who have violated laws. In our written report, we also said that between 2015 and 2019, the number of such referrals is included in the table. Thank you.
Thank you. Any other additions to the? I mean, we have the table. It is also in the replies of the government to the second list of issues, where it sees altogether there are about 500 children or juveniles that are either in reformatory schools or juvenile detention houses, or very few in juvenile rehabilitation centers. And then somehow on the next page, it says there are no incidences of the detention of juveniles. I'm not quite sure what is meant with that, because I think we probably agree that children in both juvenile detention houses and reformatory schools are in detention. Is that correct? They're deprived of liberty. Yeah. And what is the main difference between the reformatory schools and the juvenile detention houses?
Okay, I speak for the correction agency. For those in the juvenile detention houses, usually it's because they have an investigation or trial ongoing. After a judgment is made by the court, then the child may either to serve a sentence or go to a reformatory school. We have 4 reformatory schools. 3 accommodate juvenile delinquent juveniles, and 1 accommodates juvenile inmates. I speak on behalf of the Judicial Yuan. For reformatory school, the court has completed the judgment, and the juveniles will be sent to the reformatory school, providing institution-based intervention. As for juvenile detention houses, when the case is still pending because his family background or conditions, or there's a need for psychological or mental evaluation, then the juvenile will stay at the juvenile detention houses. In other words, when the case is pending, that's where the juveniles will be at.
And to my understanding, the minimum age of criminal responsibility is 14. Is that correct? Or is it 12?
刑事责任是14
14 years for criminal responsibilities.
保护事件
But in Juvenile Justice Act, there is juvenile protection cases, meaning that juvenile who may be sent for protective facilities, then it's 12 years old. But for criminal cases, it's 14 years old.
On page 20, there is 1 child 12 years old and 8 children 13 years old in juvenile detention houses. And I understood that juvenile detention houses are kind of a pre-trial detention if you're suspected of having committed a crime. How do you reconcile that with the minimum age of criminal responsibility of 14, that you can bring a child for pre-trial detention already with 12 years?
The Division of Children and Youth Affairs. The juvenile judicial system in Taiwan can be separated into two: protective cases and criminal cases. In criminal cases, of course, criminal age of 14 years old is applied. For juvenile protective cases, then it applies to children between 12 and 18. For these cases, well, for both criminal cases and protective cases in Taiwan, such a child will be sent to the court for further decisions first. So it is different from general criminal proceedings. So for children who are sent to juvenile detention houses, such a decision is made by the courts, and the juvenile investigators will decide whether or not it is necessary to temporarily place the children in juvenile detention houses, because some of them are not able to return to their family because their family has some difficulties. So these are the cases.
Not in the social welfare system. Why do children who need to be protected then spend time in the juvenile detention house, which is under the, I guess, in the administration of justice? Or what does protection mean? Detention for protective cases.
I'm from the Division of Criminal Affairs from the Judicial Yuan. But in Taiwan, if a child is between 12 and 18 and has violated criminal code, this child is not sent to the criminal court directly. We have a dedicated juvenile court. The courts will first understand why the child violated the law. Was it because of his or her own behavioral issues, or was it a family issue or some issues at school? So the juvenile courts will try to investigate the reason. That's why we decided to create dedicated juvenile courts and professional juvenile judges. In the process of such investigation, the juvenile courts will evaluate the physical and mental situation of the child and to evaluate the reasons of such behaviors. And that's why we have the juvenile detention houses. And according to the Juvenile Justice Act, Article 22, children enter juvenile detention houses not for the purpose of detaining them, but to evaluate their mental and physical status. And this is a temporary shelter. And the prerequisite is that the child is not able to return home. For example, the parents are not able to pick them up, or it is improper for them to return home. Only in these cases will children be taken to juvenile detention houses. Parents, other guardians, or attorneys can apply to the juvenile court to pick up the children and take them home at any time. And the time spent at the juvenile detention houses is for evaluation of the physical and mental status. And the juvenile detention houses need to issue a report to the juvenile court to understand how to help the children to grow in a healthy manner, and whether or not the court need to help the families. So in this process, if the juvenile judges realize that a felony was committed by the child, then the judge may decide to send the case to prosecutors for further investigation. And before the juvenile courts and judge made that decision, such children cases are not considered to be criminal cases. So only when such cases have been transferred to prosecutors will such cases be considered to be criminal cases. Even though a case has become a criminal case, the juvenile judges need to protect the children and see the protection as the main goal instead of punishing the children as the main goal. So juvenile detention houses are different from general detention houses. They are for the purpose of evaluating the situation of the child. Thank you.
Yeah, we're approaching already the end of our session. Are there any other questions on any of those articles and issues from my colleagues? Any final statements on these broad issues of deprivation of liberty and right to life, prohibition of torture from your side? Anything you would like to add to the discussion that we have had? If not, then I thank you very much again for your frank and open dialogue that we have had on difficult issues. I admit that these are some of the most difficult issues in human rights in general. And I look forward to the continuation in Cluster 4, which is tomorrow at 8:30, when we go to Articles 12 until 17 of the Covenant, so freedom of movement, foreigners, but also the right to privacy, and in particular the right to a fair trial and access to justice. We'll see that tomorrow, and I wish you a pleasant evening. Thank you very much for your cooperation.
谢谢各位的与会。谢谢各位的与会。今日与政府机关之审查会议到此结束。明日上午的会议开始时间。
This is the end of Cluster 3 with government officials. Tomorrow, Cluster 4 will start at 8:30 in the morning tomorrow. Please join the meetings on time. Thank you very much.
原专属厕所，请勿使用。有使用需求者，请改至11楼使用。谢谢。
And the meeting with the NGOs starts at 5:20. Yeah?
尽速就座，并将您的手机。
We're about to begin momentarily. Please be seated and switch your cell phone to the vibration or silence mode. Thank you.
All selfies.
两公约第3次国家报告国际
Cluster 3, meeting with NGOs. We are going to review Articles 6 to 11 and the concluding opinion of 52 to 56, 58 to 67. Now, please make sure you speak within the time allotted to your group. Each group should have about 2 minutes.
Please,
Okay, we won't do it.
We have a different
那请问
procedure.
各位发言人在发言的
Okay, so please make sure you raise your hand so that the chair and reviewers can see where you are seated and identify yourself, your name, your affiliation, and make sure you speak at a reasonable speed to help with the interpretation. Thank you.
Thank you very much, and welcome again. It's a long day, but we are all very happy to have your views on the issues we have been discussing today, and I guess all or most of you have been present already before. So I would again cluster it, start with the death penalty. That was the first issue where we spent quite some time, both in relation to Article 6 and Article 7, and the new national plan of action that the government recently adopted. Any kind of comments you might have to us in relation to anything that we did not cover, that we overlooked, that you feel is important in addition to what we discussed with the representatives of the government. And then we might have a few questions still to you. Please.
Thank you. Well, we don't have any government officials here. Actually, I want to speak to those government officials. The review is live streamed online, and I thank you for your comments to the government officials. It's a way of educating the public as well. I think the MOJ has done a good job organizing the international review meeting, but as the agency in charge of promoting the abolition of the death penalty, I don't think they have done enough. In response to the comments made by the MOJ, I would like to say something. I am Lei Xinyi from the Taiwan Alliance to End the Death Penalty. I think the Deputy Minister of Justice and other government officials mentioned my organization. So what I want to say is, in terms of the execution of death penalty, Professor Shabas said, in terms of data, Taiwan has made tremendous progress in this area. However, I think Minister Cai Qingxiang of Minister is the one to sign off on the death penalty execution. I think the reason why we have seen such a reduction is because in 2018 and 2020, these two death row prisoners basically had no way to seek remedies. In fact, these two defendants or inmates suffer from mental or psychological disorders. So it is wrong for the Ministry of Justice to say that their execution is in line with the covenant. And the MOJ also says that every 3 months for death row prisoners, there will be psychological assessments and evaluations that are done. But we know that no psychiatrist in Taiwan would like to perform such assessment at all because it's against the medical ethics. So basically, there is psychotherapists that would go to the prison to talk with the death row prisoners to assess their mental state. The MOJ thus used these reports as the basis for their decisions. But at our alliance, we have done a lot of research. We know that the so-called assessment or evaluation is not really a very strictly defined psychological evaluation performed by psychiatrists. As for the National Human Rights Action Plan, well, why are they now talking about conducting opinion polls or alternatives to the death penalty? If the government wants to push forward with this action plan, we know that the results will be the same no matter what kind of opinion polls you are going to hold, what kind of research you are going to conduct. Is the government willing to say that by the end of 2024, at the end of the research, they are going to stop executing the death penalty? Or in the legislative year, maybe we can pass the second optional protocol. Is the government willing to make such promises? In addition, the MOJ has consistently claiming that they have a research and promotion team for the progressive abolition of the death penalty, but the team is dysfunctional. In 2009, after the ratification of the two covenants, the research and promotion team was set up then. I, as the CEO of the alliance, talked with the prosecutor's office leader back then. On many occasions, we invited a lot of scholars to join the discussions. Many of the scholars have very clear views about the abolition of the death penalty. However, with the change in the governmental personnel, we have seen the determination weakening over time. In 2020, the government once again executed the death penalty, and we decided to drop out of the team, the research and promotion team. In 2020, the MOJ actually has the so-called guidelines for the execution of the death penalty. And the MOJ also admitted that there are many problems in that guidelines. In that case, in 2018, the MOJ still executed one death penalty. The MOJ back then was still talking with the NGOs about the amendments to the Prison Act. In other words, while the government was negotiating with us, the execution took place. That is why my alliance decided to withdraw from the research and promotion team. We had no choice but to withdraw.
Because we thought that team was not of any use. If we had stayed in the team, the government would use us as excuses saying that Taiwan government is promoting the abolition. Also, well, say last year there were no executions and there were no death penalties. And if we are going to attribute these positive progress, then I say this is because the judges understand how to apply the two covenants in their judgment. But I have to point out that some judges have misunderstandings of the two covenants. Also, in this process, lawyers and attorneys play a very important role because for every individual case, they invoke many of the human rights conventions in their arguments so that judges agree with them, and therefore the death sentences were not given as much as before. But the prosecutors did the opposite. Well, maybe my colleague will give you more examples, but prosecutors still request death sentence for not the most serious crime. Or when the first instance or the second instance do not result in death sentence, the prosecutor then decided to appeal to a higher court. So I think among judges and prosecutors, prosecutors didn't really play a positive role in abolishing death penalty. And additionally, MOJ has been saying that Zheng Xingze and Zheng and Xie, their cases which were wrongfully verdicted with death sentence. And lawyers ask for retrials for many times, but in the Taiwanese culture, the judges found it to be difficult to accept retrial, but then prosecutors in those cases were the one who decided to appeal the cases. This is because the private sector and the NGOs have done enough in order to reverse these two cases, whereas MOJ said they played the most important role in reversing the cases, which is not true. I would like to end here, and I would like to provide more information later. Thank you very much.
Thank you.
主席，
death penalty. I think you've already noticed this already because you continue to stop government representatives from telling lies or interrupting them or asking them whether they can make immediate commitment to abolish death penalty. I'm very touched because you play a very proactive role. But if the government truly want to carry out the two covenants, their attitude wouldn't be like something they demonstrate today. Instead of defending themselves all the time, instead of giving a lot of excuses, they should be very acceptive of your recommendations. So you talk about what need to be included in a COR. I think what we need the most is you, the International Review Committee, and the committee members. Because MOJ tells the stories they want to tell. They say the two covenants are applied in judges. On their website, they say they have data. They have shown numbers of cases which use two covenants. But in fact, there are cases when the judges heard about the two covenants, but in fact didn't cite the two covenants in their judgment, so their numbers are not accurate. So I think there should be a mechanism to examine whether or not the judges actually apply the two covenants in their judges. And MOJ also says that there are rules to govern prosecutors and so on. Right, but the covenants articles are not included in those instructions. So I think they should do better. I would like to end here. Thank you.
To ask you a few questions about what you just said. First of all, I may have misunderstood, but I think there's an inconsistency between the two of you about the role of the covenant. I thought that you, the first speaker, said that people had argued, or defense lawyers, or the issue of the covenant had been raised and presented to judges who had then not ordered the death penalty because they were influenced by the covenant. But the second speaker seemed to suggest that it actually was being ignored. I don't know if I got the message right, but how would we characterize that? Because you can put it in a negative. There's a kind of a negative version of this.
没有误解。
No, there's no.
Let me finish. There's a negative version of describing it, which is that the government, the prosecutors, for example, don't tell the judges about the covenant or don't argue the covenant. But to hear that actually lawyers, whether it's the prosecutor or the defense lawyers, who raise the issue of the covenant, and then the judges decide not to impose the death penalty as a result, for me, I smile when I hear that. I think this is a wonderful example of the influence of the International Covenant on Civil and Political Rights. So I'm just, part of what we have to do is, you understand, we can't write a manifesto about the abolition of the death penalty in our concluding observations. We have to deal with a lot of issues. We're going to deal with this appropriately, I'm confident. We haven't written the concluding observations yet. But we have to get the right tone as well, and to appreciate what, you know, if the covenant is having a positive impact on the reduction in death sentences and in the use of capital punishment, it seems to me this is something that we may want to acknowledge. But I sense from you that would be making it look too positive, that the message should be negative. So this is a little bit what I'm trying to figure out. Can you clarify that idea for me? I have a second question for the Taiwan Alliance that's in the report, where it's not in the...
But can we perhaps first clarify the first question, yeah?
In fact, what she said and what I said are both correct, because she said some judges apply the two covenants, but what I said is that only a very small number of judges use it, and most of the numbers doesn't mean that a lot of judges use it, but because attorneys and prosecutors raise them, so judges use them. And from December 2009 and January 2019, there are about 2,195 cases that involve the two covenants. So there are 900, 700, 100, and 100 more at the different levels of courts or at administrative courts. So different courts apply or mention the two covenants. It sounds a lot. However, do you know how many judgments we have a year in Taiwan?
This question yesterday, that it's not enough just to tell us that the covenant is being cited without telling us how, in what context. But here, we're confined to the issue of the death penalty. So this is what I want to know, is how how relevant is it to the judicial debates about whether or not the death penalty should be imposed?
Thank you. I'm Lin Ciwei from TAEDP. I can respond to this question because our alliance has studied more than 10 years of the two covenants of their application on death penalty. Yesterday, the government representatives did mention the numbers of cases which apply the two covenants, and some of the data is on the website. That's true. However, I have to point out that to apply or not is not really the point. The point is how to apply the two covenants. It's not a yes or no question. It's about how the two covenants are applied. From the second review to now, there were two finalized death sentences. And in both cases, the judges said that their sentence are in compliance with the two covenants. And in this year, in the fourth month, there have been 3 new death sentences. Of course, those cases are still being appealed, but in those 3 cases, the judges also say that their sentences are in compliance with the two covenants. So if one country says that they are in full compliance with the two covenants, but still give the 3 new death sentences, I don't think it's realization of the two covenants. And in the past several years, indeed, courts use the two covenants more and more. I'm not going to deny the positive progress. And I think the most serious part is in the prosecutor's office. Let me give you an example. In July last year, there was a case which was given death sentence for many times. The case was reversed at the Supreme Court to become a permanent imprisonment. But the prosecutor general raised extraordinary appeal to this permanent imprisonment. The general prosecutor wished that case to be a death sentence case, even though the Supreme Court already reversed that. So from that case, I think you can tell whether or not these governments understand the spirit of the two covenants. So we have to understand that the judicial side and the Ministry of Justice, these are the two sides, and they have different understanding of the two covenants. And I really wish that in your concluding observations this time, you may include the following recommendations. That is, if the court's judgments are in violation of the two covenants, then this should be a cause for retrial. To have such a clear rule so that judges and prosecutors know that their prosecutions and their judgment shall not violate the two covenants, because if there are such violations, then those cases must be retrialed. So I see in that case, we will see more concrete effect of the two covenants. Or, like I said, in the first 4 months, there have been 3 new cases that received death sentences already. Thank you. I will end here.
Per, please. So, there's one and then I give you. Yes?
I have the floor.
Please.
Okay, yeah. Thank you very much. I haven't got the information, I think, from a previous visit to Taiwan, that the Supreme Court is a huge institution with about 100 judges or something like that, and working in sections of 3 or 5 judges. It's evident, if this is correct, that there's a risk of conflicting jurisprudence within the court. And my question is, if this is so, is that relevant to application of the death sentence? And if so, is anything done in order to try to get a certain harmony in the jurisprudence? If you could elucidate that a little.
好，谢谢委员的。
Thank you for the question. In Taiwan's judicial system, from district court, higher court to Supreme Court, there are 3 levels. Right now, at the district court and higher court, the interpretations may be quite inconsistent, but in the end, all death sentence cases will go up to the Supreme Court. And the Supreme Court can interpret the 2 covenants and express their interpretations through their decisions. And to us, it's ridiculous. Many of them cited the 2 covenants at the district court and higher courts to support the use of death penalty. But fortunately, the Supreme Court, when suspecting some problems in the lower court's decisions, the Supreme Court can order a retrial or remand it back to the lower court.
This afternoon, I began by saying that there had been a dramatic decline in the use of the death penalty. Was that incorrect?
I think you are right. Because my colleague just said, this year, there are still instances in the district court level where death sentences were given. But throughout the past 2 years, we didn't have any executions or finalized death sentences. And in some cases, the prosecutor asked for death penalty, but in the end, the judgment did not agree to have death penalty.
Phenomenon, then, that I pointed out how, at the time of the first and second review, the rate of execution in the previous years was much higher than it is today. So how do you explain that?
I think there's one important factor. In December 2012, the Supreme Court in Taiwan began to allow oral arguments in relation to death penalty. As a result, many NGOs began to provide their support in such oral arguments. As a result, you can see more reference to the covenants in these oral arguments. Of course, in the Supreme Court's decisions, as there's more reference to the 2 covenants, it's increasingly difficult to allow the imposition of death penalty. But this is because of the hard work by the private sector. So I believe that is the reason behind the progress. I think my colleague talked about the judgment resulting in death penalty. Of course, this collaboration between lawyers and NGOs work. On the other hand, in terms of the reduction in the number of executions of death penalty, the MOJ kept saying that they would assess if there are grounds for retrial, extraordinary appeal, or mental disorder. And my alliance has been working with defense lawyers, defense attorneys, to see if there are grounds for retrial or extraordinary appeal. So I would not say the MOJ is working hard toward abolishing the death penalty. Rather, it's because these death row prisoners do have grounds for the death penalty not to be carried out. In 2018, actually, we did see executions.
And I'm from Amnesty International, and my comment does not represent Amnesty International. My next comment does not represent Amnesty International, just because I'm also on the board of Taiwan Alliance to End Death Penalty. And I think they are being very kind for not saying what I'm about to say, is because every time we see a serious case happening like that's being widespread on media, death penalty, TAEDP will start forming a lawyers group. They will assign 3 lawyers to work on that case, to prepare for trial, to prepare for the court, to prepare all the case details. So they go into the court prepared for all these possible cases that might get sentenced to death. So we nip it in the bud, or should I say that? They started preventing cases from getting the death penalty from the very, very early stages. That's what I think is the crucial step that Taiwan's death penalty verdict has dropped in the recent years. Thank you very much.
Thank you. I just want to say that the reduction in the executions of death penalty, why? I think it's because in some previous cases, the parties did not want to seek remedy. That is why there's a huge pool the MOJ can take credit for. But now, among the 38 death row prisoners, basically there are grounds, there are reasons that you cannot impose death penalty or execute the death penalty. So it does not represent that the MOJ is determined to abolish the death penalty.
Questions. We were given at the break a document that has another statement by the Taiwan Alliance, and it's this document. And it says, however, Taiwan government has carried out the death penalty every year since 2017, every year except 2017, since its first international review in 2013. But I thought there'd only been 2 executions in the last 5 years. What does this mean? It says it's carried out every year except 1, except 2017. But I thought that since 2017 there have only been 2 executions. Which is the situation?
Could you tell me where you read that particular information in our first parallel report, or?
We received a document from you earlier today.
Oh, okay.
We got this at the break. It says, Taiwan government has carried out the death penalty every year except 2017 since its first international review in 2013. Then it says June 2019. Maybe this was written in June 2019.
Yes, because when we apply to attend this session, we're required to send in a paper of what we are about to say. So that was written back then.
Okay.
I believe.
Okay, that explains it.
Thank you.
So then the other question was the reference that was made to psychiatric assessments that were done on death row prisoners, and you said that no psychiatrist would participate in that process. I haven't found that in the documentation, and I just wondered what we would have as a source for that. Is there a statement by a professional body or something? Because it's a bit of a dilemma. On the one hand, if, for example, you want to get a psychiatrist to go and meet with the death row inmate to assess them as to whether they may have an argument that they shouldn't be executed because they're not mentally competent. Would the psychiatrist do that? I mean, will psychiatrists do this depending on who asks them to do it? Is that the point?
According to the MOJ's response, they said during the past couple of years, some death row prisoners died in prison and some committed suicide. That is why the MOJ decided to recruit therapists or counselors to evaluate these death row prisoners every 3 months to make sure their mental state is good. So this is what MOJ said. As far as I know, my alliance actually would keep correspondence with these death row prisoners, and they told us that the conversation they had with such therapists or counselors is something like, how are you? Have you been sleeping well? It's not really a professional assessment or evaluation. I believe these death row prisoners are likely to seek psychiatrist evaluation before the execution of their death penalty. But the MOJ simply used this, saying that that is the evaluation report they provide.
Appropriate psychiatric medical care, and they require some kind of therapy. Are the therapists then being used as, where this would appear would be if there was litigation before a court prior to an execution as to whether someone is fit to be executed. And it seems to me unthinkable that a therapist would then testify against the patient. That wouldn't be allowed. That would be contrary to all ethics. So what I don't understand is what's the problem here?
As far as we know, we don't think there is such psychological evaluation. Maybe a doctor is summoned to go to the prison to provide some regular checkup. But there's no such case where a death row prisoner has to go through such psychological evaluation because there's an imminent execution of the death penalty. In fact, we have talked with many psychiatrists, medical professionals, and they wonder if they are involved in this, they may violate their medical ethics. I think your confusion has to do with our disagreement with the MOJ. The MOJ thinks that they have done everything right in executing the death penalty, but we don't think they have taken the proper procedures. I think that's our disagreement with the MOJ. Yes, we agree that before the trial, after the judgment is made, the prisoners or the defendant's mental state must be evaluated to make sure he is ready to stand trial or see his execution.
More than 40 prisons and detention centers in Taiwan, and most of them do not have stationed physicians. So these inmates do not have a psychiatrist that are regularly treating them. So what the Ministry of Justice do is to arrange contracts for these prisons to have outpatient visits by another hospital. And they don't see these, the doctors do not see these inmate patients regularly. And that is why I don't think any one of them can have sufficient information to prescribe or to make the diagnosis whether they are mentally fit to be executed.
To confirm what I also asked to the Ministry of Justice, legally speaking, under the Constitution of Taiwan, is it true that the president is totally free whether she grants a pardon or not? Because I heard in reality she's always then asking the Ministry of Justice, and the Ministry of Justice is not in favor, and that might prevent her from issuing a pardon. But she could. So is she legally free to do it?
We believe so. Yes, by law she is entitled to.
And why is she then always knowing that the Minister of Justice is not in favor of pardoning? Why is she then doing that? I mean, I'm now asking a political question. Because she doesn't dare to do it, because there would be a lot of criticism from the media, etc. Or yeah.
Yes, my judgment would be that it is political considerations that prohibiting from doing that, because, I mean, the DPP is very concerned that if they abolish or do anything related to minimizing that penalty, then they will lose the support from the public. And that is why the polls means so much to them.
And the political parties, do they have different approaches, or
they are almost the same.
All in favor? No. Please.
Right. As Professor Huang Songli said, yes, the president can decide to give pardon. And we always apply for pardons for all the death row inmates, but none of them receive a clear response as to whether or not whether the president will give pardon. But many NGOs are concerned about wrongfully convicted death cases, like the one with Chiu He-shun. For Mr. Chiu, the presidential pardon is his last chance. And through MOJ, well, we learned that the president, of course, is entitled to make the decision, but it's impossible for her to understand every little detail about the case. So she may consult with MOJ, but legally, the president doesn't have to consult with MOJ, but MOJ did provide some information which the president based her decision on. So it seems that the MOJ didn't recommend the president to give the pardon.
Dear Honorable member of the International Board, I'm speaking on behalf of the Chinese Association for Human Rights, 中华人权协会发言。I first second the colleagues' opinion about the pardon issues. There is a recent case, actually, across the political parties, they have the consensus that one general should be pardoned because he has some abuse on the accounting issues. Then maybe he emboldened only 2,000 and a few hundred new Taiwan dollars. And all the political parties are in support of him to get the presidential pardon. And the president did grant him the pardon finally. But the prosecutors group still are very defensive about this pardon. They say it's not fair to all the other defendants because only this one, a general, who escaped the court-martial and get the presidential pardon. So they say it's unfair. So you can look from this example that even the president did grant the pardon, but there are still some very strong objection from society that they should not grant the pardon very regularly. So if you, in comparison, Taiwanese president very seldom exercise his or her pardon power. So I just second their opinion. And may I bring about my own the concern of my association? My association, we want to bring about the case for your to your attention. It's a measure about quarantine measures in fight for the epidemics and during this period of time, and in possible violation of the Article 9 of ICCPR. And because the content of this case, I would like to also to share with all my colleagues here. So allow me to use the Mandarin to continue. Okay. 最近有一个很指标。
There has been a leading case recently. There were 4 airline pilots working for a certain airline. They finished their flights and were about to re-enter Taiwan. Well, on March 7th this year,
Okay.
Yeah.
Okay. I think you finish the death penalty issue first. Then I can proceed.
Okay. I think I have you first, and then you. Please.
Yeah, regarding death penalty and torture, just like Xingyi and Ziwei has talked about the Qiu Heshun's case. His case is just like the cases that Ministry of Justice has keep on mentioning. The 2 cases that they exonerated. Mr. Qiu has been locked up in jail for 33 years, and he's still facing injustice and torture inside within the prison. And the recent report published by the Control Yuan highlighted that the police has subjected Mr. Qiu to torture and other ill treatment during the investigation process, and reported that Mr. Qiu's confession was obtained through torture, and government has lost crucial evidence of his case. And Amnesty has listed Mr. Qiu as one of the rightful right cases in 2012, and since then issued several urgent action for him. And we, along with other human rights NGOs in Taiwan, have met with the Ministry of Justice to provide further details regarding his case. But still, we have not heard back from Ministry of Justice. So we would like to suggest that maybe Ministry of Justice should actively re-examine his case, just like how they re-examined Zheng Xingzhe and Zheng Xingzhe and Xie Zhihong's case that they kept on mentioning. And maybe Ministry of Justice can actively seek the opportunity to brief President Tsai and suggest her to grant pardon for Mr. Qiu. Thank you very much.
Thank you. Please.
委员好，今天早上就是听到应该是 Manfred。
I think this morning I'd heard Professor Manfred Novak ask MOJ about why not adopting moratorium. And MOJ said that abolition is not only a human rights issue, it's a social issue, it's also a political issue. But that's where the problem is, because their concerns are political and social. instead of human rights. Social human rights shouldn't be approached from the political aspect. We should go ahead to do what should be done. So as the alliance mentioned, maybe government officials believe that they are in compliance with the two covenants. I think there should be a mechanism to examine whether or not government practices are in line with the two covenants. And I want to know if later on we're going to discuss torture, because I want to know whether I will have the opportunity to raise my point about torture and other issues.
I think we are finishing the death penalty, but I think you have still a question.
One more question about
Yes.
the death penalty. Is it accurate to say that the Minister of Justice could, in practice, impose a moratorium on the death penalty?
I'm sorry, would you please repeat?
Correct to say that the Minister of Justice could, as a practical matter, impose a moratorium by simply declining to authorize executions? Yeah. Okay. And could the President do that too, or does a pardon imply a full pardon? Or could the President's right to pardon also be a partial pardon in the sense that the President could stop the death penalty but allow for detention? In other words, could the President also impose a moratorium?
Yes, and according to Ministry of Justice, before they carry out execution, they have to call the President to ask whether or not she grants the prisoner a pardon. But
If the President said, I grant the pardon, does that mean the prisoner gets out of jail free?
Yes.
Okay, so that's not the same as a moratorium on the death penalty.
But she can keep on saying no. But the thing is, we do not have a clear procedure regarding application for pardon. It's unknown. We do not know why she rejected. We do not know whether or not she accepted the application. We do not know whether or not she officially denies the application. There's no official document whatsoever. We can only hear from MOJ saying that they did call the presidential's office. We do not know who they talked to. We do not know whether or not they talked to the president directly. We do not know whether or not she gave the answer yes or no personally. So we would like to suggest the government to have a clear procedure regarding pardon applications.
Well, should not the procedure be that the president must consider giving a pardon? Should that not, wouldn't it be better to say that there should just be, the procedure should be that the president has to address the issue of whether or not to grant the pardon? Because as you said, in practice, the execution can't go ahead without the president's approval.
是，对，没错，刚。
Right. I think what you described is exactly the problem. Among the 38 death row inmates, 35 had applied for pardon to the president, but the president didn't respond. So the president didn't say that she's going to accept or whether she's going to deny. So these 35 death row inmates had filed a lawsuit against the president, because her lack of response is illegal. And the president sent out attorneys to say that the president or the presidential office doesn't have to provide a response. So as you described, right, in Taiwan, there isn't a clear procedure legally. But as other colleagues of mine said, in practice, the president did pardon some of the inmates.
Well, if the president believes that commutions or pardon can be granted, as a means to introduce a moratorium. Maybe we can learn from Mongolia. Before the abolition in Mongolia realized they actually used this particular method, the MOJ can also refuse to sign off on the execution order of death penalty as long as they have the political will. My alliance also included in our written document our specific recommendations.
It was the president who issued the moratorium before they abolished it. It was just the president by himself. And who can actually commute a death sentence? Is that also the president? And can she then decide you get 10 years in prison or 20 years or lifelong? Or doesn't it have to go to the judiciary? Please.
Well, there is a Pardon Act which says that the president is entitled to order the executive yuan to order the Ministry of Justice to consider pardon or reduction in sentences. So it is actually her right to have this order. It's in the Pardon Act.
But I mean, if she grants pardon, the person needs to be released.
Yes.
If she grants commutation, then she orders the government to whatever, to bring the case again to the judges, or
I don't think she can order every trial.
So who is then deciding in the commutation what prison sentence the person then has to serve? Yeah?
I have one practical question. Before the executions, who is the one who have the last say? Because like in Indonesia, before the executions, it is the president who signed the paper, who authorized the execution. So who is doing it here, president or minister?
It's the Minister of Justice.
Minister of Justice.
Okay.
And also the case will also bring to Chen Mingtang, who was sitting here. So he did review all the execution since 2013.
Okay.
But we still need an answer.
Yeah. Okay.
Is it in the Pardon Act?
So it is only the pardon that is in the hand of the president, but executions is in the hand of the minister.
Yes.
Okay.
Yes.
Commutation we still find.
Yeah, we are still looking up the details regarding commutation, and Tsuwei has the answer now.
In terms of commutations, in addition to the Pardon Act, there are other provisions in the Constitution. Article 40 of our Constitution, the president of the country, per laws, can grant pardons. However, in accordance of laws and regulations, that's the prerequisite. As for the Minister of Justice, in the criminal code procedures, in the Code of Criminal Procedures, the leader of the judicial ministry will sign off on the death sentence order. But it doesn't say that the ministry has to sign off on it. It has the right to do that.
The answer tomorrow or Thursday, but just it seems to me important to know could we say in our concluding observations that the minister should impose a moratorium by declaring as an official policy that there will be no further that no further authorization of executions. And could we also say that the president could do the same thing?
Yeah.
Because if the answer is that if the president's power is confined to pardon, then that would imply release, and that would be unacceptable as a general principle that the alternative is simply release or execution.
Okay, can we, because time is running, so.
Just about the moratorium, I asked the official from the Ministry of Justice that he forgot to or neglected to answer that question, who can do that? And he said that it is too political for him to reply. So I would say if signing that order is beyond, is beyond the power of Ministry of Justice, I think moratorium would be coming from the president. It's more likely.
Okay. Mm-hmm. Yeah.
Regarding the death penalty, I have one last thing that I wish to share with you guys. That I believe it is government's responsibility to promote our state policy of gradually abolishing death penalty, but our Ministry of Justice is not doing so. They keep on saying that TADP is doing this, TADP is talking to the public, they're saying that they have information given to the media, but compared to Judicial Yuan, they spend 70 million NTD to promote the citizen judge system. But I would like to know how much money the Ministry of Justice spent on promoting the state policy of gradually abolishing death penalty, because from my understanding, it's close to nothing.
Yeah.
Thank you.
I think we are fully aware of that. Can we stop with the death penalty, because I think it's 5 minutes, and I think on the one hand we want to discuss torture. I think you also raised this. But yours was about deprivation of liberty, I guess, the pilot cases. Is that the same case that the minister actually, or the ministry was raising? Because I interrupted you before. So can you quickly say on the pilot case?
Okay, yeah, I will be quick, since we only have a few minutes left. This case is about 4 pilots' quarantine location after their re-entry into Taiwan. The Central Epidemic Command Center announced that from March 7, 2022 on, instead of staying in quarantine hotel, if crew members are fully vaccinated, go through some tests, and the most importantly, their residents meet certain conditions, they can quarantine in their own household by the rule. And we so-called one person in one household principle. So, and if the crew members so choose, their airlines and the relevant authorities should permit such application after review their eligibility. However, upon the 4 pilots' re-entry into the country, the airlines and the relevant authority fail to provide necessary measures to realize their options, and therefore they are still forced to stay in the quarantine hotel. And these 4, they file to the Taiwan Taoyuan District Court for habeas corpus. The court issued an injunction ruling on 2 bases. First, the quarantine measure deprives personal freedom and constitutes detention, which should be subject to habeas corpus. Second, the 4 pilots are illegally detained and should be released from quarantine hotel. And my association, we brought out this case to your attention in the expectation of closer scrutiny of administrative measures interfering critical human rights during epidemic in this country and around the world. Thanks.
Thank you very much. So you are suggesting that we should also file a habeas corpus claim about our confinement. But thanks very much. This was a judgment very recent, I guess. Yeah.
We also attach the English translation of the press release of the Taoyuan District Court, so for your reference.
That would be kind. Thank you very much. Yeah. Now I think we have to go to the torture issues. Please.
我想要讲的是
So what I'm trying to say is, I'm really grateful to your attention and concern about the death penalty. But I think the issue I'm going to talk about has even far-reaching effects because your property, your everything may be lost, not to mention the impact can last for decades. That is tax victims. Real cruelty or torture may not be confined to prisons or confined to a number of torturers. I think the worst form of torture is the government's bully of people, and such bully can have long-lasting effects. When you discussed with the government representatives, I don't think you get the full picture because there are so many cases of such tax victims. If free press is respected in our country, please take a look at this. This is a woman in her 60s holding this placard on the roadside, and she was arrested by the police. Why? Because the placard she's holding was supporting one particular case, which has been ongoing for 26 years. So for this woman, she is a tax victim. This is torture to her. I think she leads a miserable life, sometimes even worse than the death row prisoner, because the death row prisoner can seek remedy in the form of retrial or extraordinary appeal. But this woman's property was auctioned by the tax authorities. And the retrial period, according to the administrative court, is only 5 years. So 5 years on, she would have no means to seek remedy. This is the enforcement agency under the MOJ. When these organizations' land was auctioned by the agency, you can see before the enforcement action took place, 6 months before that, in the internal documents in the taxation authority, the officials were talking about how they could divide up the bonuses they would receive if they completed that particular auction. So this woman was arrested and she was interrogated for 6 hours. And then she was transferred to the district prosecutor's office. And she also faced restrictions on her freedom of travel for the subsequent 6 months. You can see this is torture, mental and physical, and this torture has been ongoing for 26 years. And now this woman has been admitted to hospital because she suffers from PTSD. So, taxation, I have to say, in addition to death penalty, the death penalty meted out by the tax authority on some taxpayers is equally unbearable. And this is a case of injustice, but there's no solution. You can see judgments made in 6 years. 5 out of the 6 years, the judgments said that there's no taxation owed to the taxation authority. However, there's still 1 year's tax statement that was held valid. As a result, the Taijimen disciples didn't have a chance to seek remedy. So I believe the tax authority, the Ministry of Finance should be held accountable. Even when the court ruling is obtained, there should be some means for these tax victims to seek remedy. Otherwise, these people will never see justice prevail to their favor. Thank you.
Please.
Dear committee members, hi, I am Pan Tianqing. I'm from the Taiwan Alliance to Promote Civil Partnership Rights, and I want to talk about gender-based discrimination, which is a form of torture. And I want to point out that the response to your first LOI has a mistake. Well, that's a wrong response from the government. For example, forced surgery before changing one's sex. So when the government responded to your first LOI in paragraph 36, what they said is misleading and wrong. The government, in fact, does not implement the point 72 in 2017 COR. In Taiwan, transgender people in Taiwan still need to go through surgeries to remove their sex glands before they can change their sex registration. And the government says that Ministry of Health and Welfare doesn't have such a restriction. But in fact, it is the Ministry of Interior that has such a restriction or requirement. So according to the administrative interpretation in 2008 from the Ministry of Interior, transgender people still need to go through surgeries before they can change their gender, and that has not changed at all since 2017. And under such circumstances, transgender persons who are not able to change their legal gender based on economic, health, or personal reasons, when being arrested in criminal cases, put in a cell, detained, or jail, will be categorized and treated based on their sex assigned at birth and face criminal treatment which is not aligned with their identified gender. And our alliance urges you to provide a recommendation and ask the government to immediately abolish the policy of forcing transgender persons to undergo surgeries before they can register their legal gender, and to correct the measures that result in transgender citizens being incarcerated in prisons that are not aligned with their gender identity. We consider the existing measures are equivalent to cruel, inhuman, or degrading treatment or punishment. It infringes upon the rights of the transgender people and their right to health. Thank you.
Coming again to this reading out of statements in a speed that interpreters cannot follow. I think we have these written documents anyway, so I think there's no need that you read that out again to us. I think you were before asking for the floor. Is it also a written statement that you are reading out, or is it related to what
I would like to...
Is it related to the topic we are discussing?
I would like to draw attention to the principle of non-refoulement and for the undocumented migrants. So yes, this is related to Article 7 and 8 to 10.
Yeah.
Should I continue?
I'm just thinking, would you be here tomorrow as well? Because we are dealing with the non-refoulement in relation to migrants under Article 13 tomorrow, or if it is very quick, then we can still do it now.
I'll do it quick, okay?
Yeah, okay.
Because in the previous second conclusions and observations in 2017, you have recommended our country to enact a refugee law, but we still list virtually no progress of institutionalizing a mechanism of refugee protection in Taiwan, and because of that, there's virtually no value for the asylum seekers to establish that to bring evidence to claim a principle of non-refoulement. So irrespective of the increase of asylum seekers in Taiwan, the government refused to enact any statutory codifications, and there's only ad hoc administrative actions. So there will be, like in rare cases, the government will agree to let the refugees stay without any formal status, but because of that, they cannot attain any working permit. And occasionally, show the government acknowledges that they come from a country that's under a more grave crisis. They will agree that they will make a monthly evaluation and to extend their stay on a monthly basis. But there's still no institutional protection and review for asylum seekers. We have forwarded Ethiopians, Tigrayans, Yemenis to the immigration agency, but they dismissed our cases, and they also did not bother to get in touch with the asylum seekers themselves. So our recommendation will be to establish a national Refugee Protection Act, and in the interim, we can amend the Employment Service Act and the Immigration Act, so that they can have apply for relief for deportation, and they can gain legal work in the interim.
As I said, this is the subject for tomorrow, refugee, and that is Article 13. And for migrant workers, also in the other committee, they are dealing with the right to work and also the conditions of migrant workers. But thank you for having made this statement. I actually wanted, again, more, but now the time is already very late, what we discussed actually with the government today, whether there is anything you would like still to add in order to assist us in forming and formulating our recommendations, please.
Thank you. I have something to add about the juvenile detention house.
Yes.
Okay. It is set up for children who are involved in or suspected of criminal cases, and they are put into the juvenile detention house for further assessment as to what kind of protection they need, and they are there for temporary protection up to several months. But actually, the juvenile detention house is set up under the legal basis for it is Juvenile Justice Act. And therefore, the juvenile detention house actually is managed, and the living conditions are that of a prison. And they have very limited access to social workers or psychologists, and actually many of them have been bullied by elder residents there. So I think the juvenile detention house, because it houses juveniles who are themselves victims of negligence or domestic violence, extra care is necessary. So I would recommend that the committee ask more questions about the setup of the juvenile detention house. Thank you.
But they have two different functions. So on the one hand, and that can start with 12 years, if they are suspected of having done something wrong, they will be assessed there and they can be there, although they are not yet under the age of criminal responsibility.
Yes.
And then it is for those who are above 14, who are suspected of having committed a crime, in order for pre-trial detention.
Right.
But as soon as they are then brought before a court and the court is sentencing them, then they are brought to the
correction schools.
To the correction schools.
Yes.
Yeah. Is that correct?
Yes.
Yeah.
So yeah,
so
there are two.
It's particularly problematic for the ones who are between 12 and 14, so that they are for their own protection.
They are over 12, but not necessarily under 14, because
okay.
Yeah. So it's a temporary housing facility which is managed like a prison.
And should our recommendation not be that that is something for the social welfare system?
Yes.
Yes?
Excuse me.
You have to turn it on.
Please ask the audience to turn off their mic if they're not speaking.
Yeah, whoever is not speaking, please turn off.
Can I ask a quick question on juvenile justice and youngsters who are confined to go through that justice system? Is there, I want to understand the gender dimensions of this justice program. Are there both girls and boys who go through the system, and is there a difference in the way they are handled? Are they put in different houses? And what are the particular challenges for young girls? Because in many countries, mine included, young girls, very young girls, hardly reach age of, they are 14, 15 years, have become pregnant and have done damage to the newborn baby because they cannot handle it, because they're just 13, 14 years. Do you have, what kind of offenses, in other words? Is there a difference in the offenses that male juveniles commit and female juveniles commit, and is there particular sensitivity in handling these differences?
Well, I can answer the simple one, which is that in prisons and in the detention houses, they have separate housing. So that is one thing. But I would say that they are managed quite in the same way. And I am not knowledgeable enough to answer the second part of the question, which is that whether they get different treatment in terms of sentencing.
Not different treatment, but sensitivity according to the offense, and some consideration given to mitigating circumstances, which maybe they're present because of the reproductive functions of young girls and so on. Is there any difference?
I know just one case who is around 16 or 17 years old when she got pregnant, and there was a case of infanticide. And she was sentenced to, I guess, 20 or more years. So now she's in the correction school.
20 years?
Or more, I don't recall, maybe 25.
I have a question to our interpreters. First of all, my apology, because we are already 20 minutes over time. My question is, could we still go on for 5 to maximum 10 minutes?
Yes.
I'm really very much appreciate that, and I'm really sorry that we're abusing your time. So really now let's focus on really the most important issues, otherwise we can take them also up tomorrow. I think you have been asking for the floor for some time.
我是民间司法。
I'm from the Judicial Reform Foundation. I already submit our written statement, and there is an external inspection team that is independent of prisons to inspect the condition in the prison. but it's not operating very well. I'm not going to repeat what I said in my written submission. I only want to mention that when committee members ask MOJ whether or not there are cases of torture, MOJ representatives only talk about cases that involve deaths, but that is wrong. In paragraph 14 to the second LOI, they say that after July 2020, the Judges Act was amended so that prosecutors' misbehavior can be disciplined. However, as of now, after these amendments becomes effective, no case was established to really assess the performance of the prosecutors. I think there was only one case, and in that case, the prosecutors interview the defendant illegally and force confession. And in the prosecutor's assessment committee, the result of that assessment is that his or her salary should be deducted, but this prosecutor can still remain on the position. So torture still exists. And the current monitoring mechanism in Taiwan is not very effective.
Thank you very much. That fully confirms. Is it again about the taxpayers?
Last time. Yes. No. It's about the 酷刑.
It's about torture. Torture, I think the reviewers may have overlooked an important issue. Some people may not consider this to be a case of torture. In the previous session, you talk about having prosecutors investigating prosecutors or police officers investigating police officers. I think this can constitute a torture case. I think the Investigation Bureau under the MOJ and the prosecutor's office are responsible for initiating investigations. But you see, after the investigation into tax cases, the enforcement agency under the MOJ will be responsible for carrying out the penalty. In the process, human rights may once again be infringed upon. Death penalty or torture, of course, exists for some people to remove or eliminate people they dislike. But the tax authority has a different system to eliminate people they dislike through abusive taxation. So this, again, is a very big structure.
Dealt with that, I think, already. I mean, quite often we have all kind of written statements about the tax.
很抱歉，那我不知道说，那如果这样子的问。
So I would like to know, for this kind of issue, which clusters will be the right occasion for me to raise the issue? Because I don't think the Ministry of Finance has any representatives in the delegation. So I hope that the review committee can help us either in terms of death penalty, torture, tax victims can also be included.
2013 and in 2017 and now again, and there is no right taxation that is in an arbitrary manner is a violation of the right to property, but the right to property doesn't exist in the Covenant on Civil and Political Rights. And that's why it was always again brought in under the torture, but it has nothing to do with torture. I'm sorry for that. That is simply not covered by the Covenant on Civil and Political Rights. There might be some issues under the Covenant on Economic, Social and Cultural Rights, but I think it doesn't really fit into our into the rights with which we are dealing with. And I fully understand the case. I know it already since 2013, and I have discussed it very, very long and often with different people. But I think we cannot really.
可是我们非常的无助，我们有多少个
We are so helpless. How many 25 years do we have in our lives?
Or review the obligations of the government in relation to the Covenant on Civil and Political Rights, and there is no right to be exempted from the.
那我想请问各位委员，就是
Can I ask? So, are there any means for us to seek remedy, either from the ICCPR or ICESCR, or there should be other avenues through which I can seek relief or remedies? I think taxation should be considered an integral part of human rights.
It's not part of our mandate. I'm really sorry. That those are tax courts, and if before the tax courts there's an unfair proceedings that might be under Article 14, but I think again what we have discussed the last time, it was not really falling under that. Are there any other issues? Because I think we have been already very much overstretching the very nice attitude of our interpreters. So again, many thanks to the interpreters for having worked half an hour longer, and I hope that tomorrow we will be more in time, and also very often working when you are reading out statements very, very quickly. So thank you very much, and to you, again, many thanks for the discussions we have had. Many issues were for us extremely important to understand better the situation, and we will take care of them in our concluding observations. Yeah? Thank you very much. Bye-bye. And have a nice evening. Please.
谢谢各位今天的与会，今日的会议到此结束。明日上午的会议开始时间是早上8点30分。公政公约第4场次在10楼1001会议室，经社文公约第4场次在8楼8001会议室，请出席人员准时与会。有关洗手间的使用部分，因10楼南侧为国际审查委员专属厕所，请勿使用。有使用需求者，请改至11楼使用。谢谢。
台湾是连续3年被评为亚洲唯一公民活动自由度开放的国家。我们乐于参与相关议题，并举办国际论坛。9大人权公约已持续在国内法制化和建立审查机制，并制定同婚专法，让台湾成为亚洲率先捍卫同性婚姻的国家，落实平等及保障多元文化的精神。人权是台湾最美丽的风景。